All right. All right. I'm here. I'm back. I'm back. And Brandon, I am not fashionably late. I arrived precisely when I meant to. 10 minutes after I precisely meant to. Something like that. But either way, I'm here and we'll consider that a win today, frankly. So, I'm here. And it JT Davis, it absolutely is amazing, but that's that's what happens when one side spends a year in a media campaign, you know, allegedly hiring bloggers and YouTubers and useful idiots to spread doubt and disinformation. And had the prosecution done this, frankly, the case probably would have been dismissed for misconduct. But since the defense did it, hey, that's fine. But there's a reason they say, don't try it in the media, try it in the courtroom. And as I said, I have a feeling this is the beginning of the end. There are gradually, and maybe not so gradually, going to be changes to media access. There's going to be changes to gag orders, for the parties. I don't like it. So I do like, though, that 3 Cents is here and that Vince is here. Welcome. And so hard evidence against Karen Reed. It's thus far it's all circumstantial, I would say. But once again, circumstantial does not mean lesser evidence. It doesn't mean that you get to discount it. Well, I mean, you get to weigh the evidence yourself. But we kind of did end on a bombshell on Monday, but the Lolly, being Mr. Unexcitable and the witness being a little bit odd, shall we say, displaying what, the general public might say autistic tendencies. Once again, not diagnosing, just saying, the bombshell came out very muted, but I believe it was either the last or second to last bit of testimony was, yes, yeah, those fragments, at least the big piece of the fragment of taillight, matched Karen's taillight housing. So, that was huge. That was huge. And, we have probably, her blood alcohol content from last week. We have probably the hair that was on the rear quarter panel. We don't have testimony about it being DNA matched, just that it's a human hair. But we're really getting into sort of the meat and potatoes of the case. And yeah, and that's it. It's by the time they were doing the search, 18 inches of snow, and 3 feet of snow where the plow had piled it, and they had to dig for the taillight pieces. So, when exactly did they get around to sprinkling the taillights in the bottom of the snow? It doesn't, it just the conspiracy is making less and less sense. The frame job, it didn't make sense to begin with, but to me, it's dead. It's gone. We're getting guilt, and yeah. So, and that's what I've been saying, Paul, and I know you've heard me say it. Um, to me, that's a huge, huge scandal. It's the feds should not be interfering in a state case. Like, literally, the only two justifications I can see for the feds even looking at this are, number one, if there's somehow federal murder jurisdiction, which I don't see, or number two, straight from the sovereign citizen playbook, 18 USC 241, 242, deprivation of rights. And once again, I don't see that. This isn't a civil rights case for Karen Reed. The feds never should have been involved, and it's just it's awful. And that's it. For 6 months, a year, they leaked mostly through Turtle Boy their preferred evidence, truthful or not, and it's terrible, absolutely terrible. And that's, yeah, I hit him. That's evidence. Now, what weight the jury gives that evidence is up to the jury. They get to decide who they believe and the context. The jury does get to decide, well, she was in shock, it was a question, or that's consciousness of guilt, or whatever. The jury gets to decide. We don't. The Free Karen Reed crowd doesn't. It's just the jury. So, and I've during the off day yesterday, I was giving more thought about my annoyance with the investigation, because you may remember, in the testimony on Monday, I was a little bit annoyed, and I still am, with the swab techniques. Once again, I don't actually know what the standard is, the generally accepted practice. But to me, I want each individual blood stain swabbed individually. The taillight, I want each part of the lens swabbed differently, just to be on the safe side. What, what's the harm in spending a couple extra bucks on the swabs? But as far as the state not testing those swabs, I don't actually really care. It's not a big deal. The reality is, the state probably wouldn't test it anyway, because there's no reason to. There's no evidence to suggest they need to test it. If you get where I'm going. Um, there is no actual evidence pointing to someone else. There is no evidence that someone else's DNA is going to be on Johnny or on the tail light or anywhere. So, it's just cost effective. You don't waste money on unnecessary tests. I do think, however, you know, well, so it was the prior witness that testified, and you know, they did cross-examine her just like I would have, oh, so you didn't test them. No. You used one swab. Yes. And I would have tried to get the same thing out. But when the when I lost my train of thought. Okay. So at closing, the defense is going to almost surely bring it up. The Commonwealth didn't test these swabs. Therefore, they're worried they'd find some other DNA. And I hope that the prosecution, that Mr. Lawley, counters that with something to the effect of, we cherish each and every one of your precious tax dollars, and we don't waste those tax dollars on running unnecessary DNA tests that we already know the results of. If the defense is so worried, if the defense is so convinced that they're going to find someone else's DNA on these swabs, they could have sent them to a lab and had them tested themselves. That's always available to them. Because the reality is, as long as a sample is large enough, meaning, all of the genetic material isn't consumed in the one test, meaning the prosecution's test, the defense is able to send the DNA to another lab and have their own tests run. And so the defense could have run it. I'm assuming they didn't because they want doubt. They want to be able to say, well, look over here, look at the funny monkey. But if they had run the DNA, it would have just confirmed that it was John's DNA. So, yeah. But there we are. So today we are still on the jigsaw puzzle lab analyst. So still on the direct examination. I believe, it's not a spoiler. It's just, I don't know anything about his testimony, but I believe we are getting Trooper Buchanan later today. So that should be fun. And yeah, so that being said, let's jump into it, shall we?
Hear ye, hear ye, hear ye. All parties having anything to do before the Honorable First Justice.
No one.
Douglas Zanoni, now sitting in the Dedham Superior Court with and for the.
No one would take that bet, Brandon. No one. And his voice sounded really, really strange to me. And it was my reminder that I restarted the computer. I actually did install the updates, and therefore we're not automatically on 1 1/4 speed. So now he's going to sound normal to me.
The county of Norfolk, draw near with your attendance and shall be heard. God save the Commonwealth and this the court. Thank you. May be seated for now in session.
Good morning, Dexter.
22-117, the Commonwealth versus Karen Reed. Counsel, can I have you identify yourselves for the record?
Oh, yeah.
Adam Lally for the Commonwealth. Good morning, Your Honor.
Good morning, Mr. Lally.
Good morning, Your Honor. Laura McLaughlin for the
Good
Commonwealth.
morning, Ms. McLaughlin.
Good morning, Your Honor. Alan Jackson, Ms. Reed.
Good morning, Mr. Jackson. Good morning, Ms. Little.
Good morning, Your Honor. David Yannetti.
Good morning, Mr. Yannetti. Good morning, Ms. Reed.
Good morning, jurors. So I have to ask you those same 3 questions. Were you able to follow the instructions and refrain from discussing this case with anyone since we left here on Monday? Everyone said yes or nodded affirmatively. Were you also able to follow the instructions and refrain from doing any independent research or investigation into this case since we were last here? Everyone said yes.
And that is Turtle Boy's phone pointed straight at the jury. So there is speculation that he is taking photos of the jury, which, of course, would be contempt of court. But, you know, the court would have to know. And yeah, it's problematic. And my understanding is there are a couple of, you know, crayon munching YouTubers sitting with the Reed family today. So
Nodded affirmatively. Did anyone happen to see, hear, or read anything about this case since we left here the other day? Everyone said no issue. Okay, thank you. May we have Ms. Blair, please?
Just watch your step again.
Maintain your face. You raise your, you solemnly swear to ever record the jury in the case ever here to the truth, the whole truth, and nothing but the truth, so help you God.
I do.
Sure. VALLIER.
All right, Mr. Lally, whenever you're ready.
Thank you, Your Honor. Good morning, ma'am. Now, Ms. Valier, when we had left off the other day, I believe you had just looked at some photos of item 7-16. Is that correct? If you recall.
It's been a few days.
That's what, Your Honor.
Yes.
And Ms. Valier, I'm going to show you a series of 6 photographs. Ask you to review those.
All right, so I'm going to remind both of you to keep your voices up. Mr. Lally, when you're facing the witness and you're this close, I guarantee you nobody behind you can hear you.
Understood. Hey, Ms. Valier, do you recognize what's in those photographs?
No.
And what do you recognize those to be?
Photos that I took of item 7-16.
May I approach the witness, Your Honor?
Yes.
Your Honor, the Commonwealth will seek to introduce in a minute. Witness, may I be seated, please? No,
oh, and Brandon, no one took your bet, but you did lose, so Of course, they were supposed to have their exhibits marked before court today, so there is that. Well, no one took the bet. No one took the bet. So unfortunately, it would have been a fool's bet, but
Your Honor, for the record, those are exhibits. 332, 333, 369, 370, 371, and 372.
Thank you.
332 and 333 skipped over.
Thank you.
Thank you, Your Honor. With the court's permission, may I have those published for the jury?
Yes.
And Ms. Gilman, if I could have photograph 2059.
Yeah.
Ms. Blair, do you recognize what's up on the screen is that photograph, which is now marked as 332?
Yes.
Is that one of the items from 7-16 next to the ruler with measurements corresponding to that item?
Yes.
And Ms. Gilman, if I could have photograph 2081. I believe 2061. And Ms. Blair, what's up on the screen is that another piece from 7-16 that's now been marked as exhibit 369.
Yes.
Now, Ms. Blair, as far as this,
and once again, boring as it is, he has to introduce each piece into evidence. Once all of them are in evidence, we can actually hear testimony about, well, yeah, this piece fit with this piece, and you know, put everything together. But you need it all in evidence first. You need each exhibit. So it's boring, but it's necessary.
particular item is concerned. With reference to sort of the texture of that particular piece of plastic, what, if anything, did you know or observe in reference to
I'm sorry, the texture?
that? I'm sorry, you have the laser pointer in front of you? Or
Oh, yes.
now, as far as the surface area of that particular piece of plastic, how would you describe that?
I mean, there are little
I
dots.
can't remember. I'm pretty sure it's a Tool song. I'm pretty sure it's on the Enema album. But there's a song, "This is Necessary," and it's, you know, yeah.
On it. They're not just like dimples of a sort.
Stippling or dimples of some sort
Kevin?
on a piece of plastic.
Yes.
And as far as those stipplings or dimples on the piece of plastic, were those flush with the rest of the plastic? Were they raised a little bit? How were they sort of configured?
I don't recall.
And Ms. Gilman, if I could have photograph 20. Forgive me, Your Honor. 064. And again, Ms. Blair, what's up on the screen is now been marked as exhibit 371. Do you recognize that?
I do.
And that is another piece next to a ruler, essentially memorializing its measurements from item 7-6. Is that correct?
Correct.
Thank you. Your Honor, may I approach the witness?
Yes.
Ms. Blair, I'm showing you another series of 11 photographs. Ask you to look at those.
Can you tell Mr. Yannetti what those are so he can look at his copies?
Counsel has shown each and every one of the photographs prior to court coming in today. But I'm happy to give them to counsel as well.
I'm just trying to save some time.
Right, I just need to know the particular evidence numbers at the end.
Do you recognize those?
I do.
And what do you recognize those to be?
Photos that I took of item 7-16.
So additional items contained within item 7-16, is that correct?
Yes.
And what's contained in those photographs, is that a fair and accurate portrayal of what you observed during the course of your examination and analysis in regard to item 7-16 in this case?
Yes.
Thank you. Your Honor, the Commonwealth will seek to introduce and admit as the next 11 exhibits.
Any objection?
I'm not going to have an objection to the guy speaking about that.
Exhibits 373 through 383, Your Honor.
Thank you.
And Your Honor, with the court's permission, if I could publish some of the photos from this packet for the jury.
Okay.
Ms. Gilman, if I could have photograph 2036. And next, Blair, do you recognize what's up on the screen as exhibit 373?
RBF is resting bitch face.
That was one of the photos I just looked at.
And as far as the evidence back containing items from 7-16, is that correct?
Yes.
And Ms. Gilman, if I could have 2039. And again, Ms. Blair, do you recognize what's up on the screen, which is now been marked as exhibit 374?
I do.
And what do you recognize those to be?
A photo that I took of item 7-16.
And that would be the entirety of the items contained within that evidence back from the prior exhibit, is that correct?
Yes.
And Ms. Gilman, if I could have 2051. And again, Ms. Blair, do you recognize what's depicted up on the screen?
I do.
And what do you recognize that to be?
A photo I took of item 7-16.
And in particular, one of the,
Can you speak up a little, sorry, a little bit
Yes.
slower? Thank you.
in particular, one of the red plastic pieces from item 7-16, is that correct?
Yes.
And for the record, Your Honor, that's exhibit 376.
Okay.
And Ms. Gilman, if I could have photograph 2053. And again, Ms. Blair, do you recognize what's up on the screen, which has now been marked as exhibit 378?
I do.
What do you recognize that to be?
One of the photos that I took of item 7-16.
And lastly, from this batch, Ms. Gilman, if I could have photograph 2055. And again,
I definitely get the feeling that she views this as an inconvenience more than anything, an expensive inconvenience, but
Ms. Blair, do you recognize what's up on the screen, which has now been marked as exhibit 38?
I do.
And what do you recognize that?
It's one of the photos that I took of item 7-16.
And this particular item up here as exhibit 380, describe sort of color, shape, what you observed from this particular item.
That's a piece of red and clear apparent plastic.
A piece of red plastic with a piece of clear plastic sort of within the same piece, is that fair to say?
Appa-
Same piece?
Yes.
apparent plastic, yes.
Now,
pretty much.
Ms. O'Leary, if you could describe for the jury again, just as far as the process that
Can we
you-
put the lights on, Mr. Nally?
Yes, I'm sorry. My apologies, Ron.
That's okay. Thank you.
Ms. O'Leary, if you could explain to the jury again, sort of the process that you undertook as far as these various pieces from these various evidence item numbers. What was the process that you undertook as far as doing your comparison?
So first of all, everything is documented. Each item is documented separately with photographs, notes. I put a label with the case number, item number, and then A, B, C, etc. If there are multiple pieces in it, a label on each piece. I look at the photos to see if there are any similarities, dissimilarities, to see if there are any potential pieces to compare. And then if I do think that there are pieces that could be compared, I'll open those items and keep them all separate, and then look at them in real time to see if it does actually look like they could be consistent before I bring them close together. And if it still looks like they could be consistent, then I'll bring them together to see if there is an actual mechanical fit, and then I'll document that and look at it under the stereo zoom.
And the device or the instrument that you're looking at, again, could you describe for the jury again what that is?
So the stereo zoom is also called a stereo microscope. It's a microscope that is on a stand, so you can put larger pieces of evidence underneath it.
Now, as far as that initial sort of looking at things together, are you doing that? How are you sort of organizing that? Is that by item number, by color, or by something else?
I did this by color because it seemed the easiest way to organize all of these pieces.
And then within the individual item number, say just randomly 7-15, for example, are you looking at that? Those, if there's multiple pieces within an item, are you looking at the consistency within the item prior to looking sort of crossing between 715 and 716? Is that the process?
Sorry, could you repeat the question?
Very long question, very confusing, my fault. So as far as the comparison is concerned, are you looking solely within an item? So if an item has multiple pieces, are you comparing just those pieces within that item first?
As part of my initial examination, I'm documenting that item. If there are multiple pieces, I'll compare those pieces first.
And then if there are any pieces that are consistent, are you then cross-referencing that item's pieces with pieces from a different item?
Yes.
Your Honor, may I approach?
Yes.
Ma'am, I'm showing you another series of 19 photographs. Just ask you to review those.
Ooh, those papers are noisy.
And do you recognize what's contained in those photographs, Ms. Blair?
I do.
And what do you recognize them?
These are photos from my case of either within the same item that had a mechanical fit that I'd then taped together, or of mechanical fits from between different items.
May I approach, Your Honor?
Yes.
I'm about to seek to introduce in a minute the next 19 exhibits.
No objection, but have I seen those yet?
Morning, but I was going to hand them to you after they were marked.
That's fine.
Once again, I thought the judge instructed them to get things marked before court. I thought she said they were going to show up at 8, I think 8 a.m. It's my time, and be prepared. Apparently not. Lynn,
384.
good to see you.
402. Thank you.
And it definitely looks like she had,
May I speak to counsel for 1 second?
looks like she had the stickies numbered. Just had to put them on the exhibits. So more prepared than last time, at the very least. Of course, that might be what they did, is discussed how many and how they'd be labeled, but can't label them until they're admitted, so there's that.
Before you get to the photos, Ms. Blair, if I could just ask as far as your analysis was concerned with reference to each of these items, if I could, excuse me, just ask you some questions about that. Starting first with item 3-1, that was the passenger side taillight housing, is that correct?
I believe so.
And you analyzed pieces of that along with the sort of housing unit itself, is that correct?
Oh, do you mean like there was like the taillight and then there were smaller pieces also in the?
Correct.
Yes,
And you took measurements of the various pieces that you observed?
I did.
And did you record those within your notes?
I did.
Do you recall what those measurements were?
Not without looking at my notes.
With court's permission, may the witness refer to our notes?
Yes.
Your witness is ready, Mr. Valley.
And what were those measurements?
Do you want all of them?
Just in yes, I mean, first starting with reference to the taillight housing assembly.
Okay, so the taillight I called piece A in this case, and it measured approximately 14 inches by 9 inches by 8¼ inches.
And then which of the pieces that were contained within that sort of taillight evidence bag did you compare to the taillight housing itself?
So there was a lot of like very, very small pieces that I took pictures of, but they're very, very small, so they were not suitable for comparison, so I didn't look at those. There were some larger pieces that I did that were suitable for comparison, so I did look to see if they fit in with piece A.
And with regard to
So basically, nondescript, round, 1 millimeter, no distinct shape. It's like you're not going to get much from that, but 3 inch by 2 inch with a distinct curve, with that you are. So
that analysis of whether or not they fit in with piece A, which of those pieces did you find did fit?
So amongst item 3-1, let's see. Sorry. Yeah, sorry. Piece A and piece B fit together mechanically, and then piece A and piece F fit together mechanically.
F is in Frank.
F is in Frank, yes.
And it may be pretty apparent, but if you could, Ms. Blair, just expound upon what you mean when you say they fit together mechanically.
So when things break, they break in a unique pattern. Like it's pretty different every time. So a mechanical fit is bringing two things with broken edges together to see if they were originally part of the same item. See if they if the broken edges align, and if they do, then that's a mechanical fit.
Now, turning your attention to item 7-5, you looked at those various pieces together as well. Is that correct?
I believe so.
And were there any 3 pieces in total from 7-5, so A, B, and C? Is that correct as well?
May I look at my? Yes.
once again, she's an expert witness. Experts get to look at notes.
And what, if any, match did you find with within item 7-5?
There were no mechanical fits amongst those 3 items or 3 pieces of the item.
And with reference to item 7-6, there were 2 pieces, A and B, within that. Is that correct?
May I? Okay.
And no mechanical fit doesn't mean, oh, so there's another taillight. It's, all those nondescript little pieces could be what would be the mechanical fit, but it's not feasible fitting them together. So the piece that would be a mechanical fit just doesn't exist. It's dust.
Yes.
And were there any physical matches within those 2 pieces of item 7-6?
No.
Now, turning your attention to item 7-8, do you recall how many pieces were contained within that?
If I may look at my. There were 14 pieces.
And of those 14 pieces, they were each compared to each other. Is that correct?
Correct.
And what, if any, mechanical fit did you find between the pieces contained within 7-8?
So pieces C and D were found to fit together mechanically, and then pieces E and F were found to fit together mechanically.
Your Honor, may we approach, please?
Hmm. What's the issue here? Does he not like the mechanical fit? It's the custom taillight breakage service or something. I don't know. I believe
You are unmuted.
I've been told, once again, I don't know this for certain, but the guy sitting behind at basically at the TV tray as his desk is the defense's IT expert. They're, working their displays and stuff. So I believe she was passing a sticky note to him. He's part of the defense team, so that's fine. Good one.
Mixed Lawyer, turning your attention to item 7-9. You analyzed 3 pieces from that, is that correct?
Go ahead.
Okay.
You know what, Mr. Laird, you can just look the whole
Okay. Sorry, could you repeat your question?
How many pieces were contained again within item 7-9?
3 pieces, 7-9,
Yes.
3 pieces.
And what, if any, physical matches did you find contained within that item 7-9?
There were no mechanical fits.
And with reference to 7-10, how many pieces?
1 piece.
And with reference to item 7-11, how many pieces contained within that?
6 pieces.
And what, if any, physical matches did you find contained within 7-11?
There were none.
In 7-11, how many different colors of pieces were contained within 7-11?
There was black, red, and colorless apparent plastic.
Now, with reference to item 7-12, how many pieces were contained within that?
There were 14 pieces.
And of those pieces, again, how many different colors or how many different colors of pieces were within 7-12?
They were all colorless.
And from those, what, if any, mechanical fits did you observe or did you find within item 7-12?
So there were 3. Do you want me to say all the pieces that fit together?
Please.
Okay. So pieces B, C, D, F, and K all fit together. Pieces E and I fit together. And pieces M and N fit together.
Now, turning your attention to item 7-13, how many pieces were contained within item 7-13?
3 pieces.
And how many different colors of items were contained within 7-13?
It was red and black apparent plastic.
What, if any, physical matches did you find within item 7-13?
There were none.
Turning your attention to item 7-14, how many pieces were contained within that?
There was 1 piece.
And what color was that 1 piece?
It was colorless.
And turning your attention to item 7-15, how many pieces were contained within that?
There were 8 pieces.
And as far as those 8 pieces, how many items were of different color? What color were they?
They were red and colorless apparent plastic.
And of those 8 pieces, what, if any, mechanical fits did you find within them?
So piece F and piece H were found to fit together.
And turning your attention to item 7-16, how many pieces were contained within 7-16?
There were 7 pieces.
And of those 7 pieces, what, if any, differences in color were the 7 pieces within 7-16?
It was red and colorless apparent plastic.
And of those pieces, what, if any, mechanical fits did you find within 7-16?
So pieces A, C, and D fit together mechanically.
Now, with reference to those pieces, once you did those inspection from or analysis from the individual items, what, if anything, did you do with those individual items with reference to the taillight housing?
So before even comparing it to the taillight, I compared all of the questioned items to each other. So that's the 7-5 to 7-19, to see if any of those pieces would fit together. And amongst those, I was able to make 5 larger pieces that I called piece 1 through piece 5.
And of those larger pieces, which of those larger pieces were you able?
And Thumper's mom, yesterday was a rough day, so I'm yeah. Yesterday was a rough day, so I'm kind of exhausted today. Let's put it that way. So but you're you know, we don't know yet if she did or not either. As I've said, my personal feeling is that she did. That's my gut instinct, but our mantra here is we don't make up our mind until trial is over. And as far as Karen Reed, her demeanor in court, it's we've discussed it before. I think this is the first time I've seen you in here, but we've discussed how people act in court. Defendants, or victims' family, everyone. And the thing about Karen, it's entirely possible her demeanor is in court is exactly what her attorneys have told her. Sit there, don't respond, don't react, just keep your face emotionless. And that rubs some people the wrong way, and it could rub the jury the wrong way. I'm of the opinion that she comes across looking disinterested. She doesn't have to be sitting there crying and wailing and but she just comes across looking disinterested, like this is a big inconvenience to her, which admittedly, being on trial for 8 weeks is inconvenient, but it just rubs some people the wrong way when the witnesses have been the ones who have in front of the jury shed tears over Johnny. You've had not wailing, but you've had tears on the witness stand, and not at the defense table, which once again, she might just not be an emotional person. She might be, this is what her defense told her how to act. But just, once again, to some people, it rubs them the wrong way. So
To mechanically fit together prior to comparing them to the taillight house.
Sorry, can you?
From your analysis of those larger pieces and analyzing them together with other larger pieces, what, if any, opinions did you draw? What, if any, conclusions did you come to as far as your analysis of those pieces?
So for the larger pieces amongst the different items that fit together mechanically, I can see that those items were once a part of the same unit.
And so I guess what I'm asking, Ms. Blair, is with reference to, say, item 7-6 or 7-5 are the items in and of themselves. Which of those items were you, if any, were you able to find mechanically fit with each other?
Amongst sorry, are you asking like which specific items made up like piece one?
Correct.
Okay, I can. Okay. Okay, so piece one contained pieces from item 7-5, 7-8, 7-10, 7-11, 7-13, 7-15, and 7-16.
And then, so based on their mechanical fit, what if any conclusion did you draw in reference to those several items?
That those specific pieces from all of those items were at one time together as part of a larger unit.
And then what, if any, comparison or analysis did you do of items between item 7-15 and item 7-16?
So pieces from item 7
That's the problem with direct examination, Kevin. Sometimes your question is hard because you have to ask it in a non-leading way. So
15 and 7-16 were part of piece one. I could look through my notes and see if they're a part of any of the other pieces that I fit together.
With the course permission.
Okay.
and I think I've seen you in other people's chats, like not even Karen Reed related, but I think I've seen you in other chats. And like I said, all are welcome. Yeah. So I was just saying, I think it's the first time I've seen you in here. So didn't know, if you were caught up or not. So yeah.
Okay, so piece two consisted of pieces from item 7-15 and 7-16.
And then with reference to items 7-6 and 7-11, what if anything did you observe between the pieces of those?
Okay. So piece three consisted of pieces from item 7-6 and 7-11.
And similar to what you had described before with 7-15 and 16, as far as them mechanically fitting together, and now I'm talking about 7-6 and 7-11. What, if any, conclusions did you draw in regard to that?
That those pieces from item 7-6 and item 7-11 were at one time together as a larger unit.
And then as far as item 7-8, 7-9, and part of 7-16, what, if anything, were you able to do with reference to those?
So piece number 4 consisted of pieces from item 7-8, 7-9, and 7-16.
And as far as mechanically fitting those pieces together, again, what, if any, conclusions did you come to in reference to those items 7, 7-8, 7-9, and 7-16?
That those pieces from item 7-8, 7-9, and 7-16 were at one time together as a larger unit.
Now, lastly, with reference to this, in reference to item 7-12 and 7-14, what, if any, analysis did you do with reference?
So my 12-year-old brain, I'm reminded of the King of the Hill episode where basically I don't remember the title of the episode, but it's basically sexual harassment in the workplace where they're at Strickland Propane. Everyone but Hank is engaged in a big game of grab ass, and that's what she said. And Hank at home complaining to Peggy, how unit is now a dirty word, and it's his favorite word. And here it's just, yep, it made for a bigger unit, and 12-year-old me giggles.
Pieces from those items.
Sorry, which item?
7-12 and 7-14.
I have item 7-11 and 7-12 that fit together for piece number 5.
And Your Honor, with what's now been marked as exhibits 384 through 402, if I could ask to publish some of those to the jury.
Yes.
Ms. Gilman, if I could have photograph 2069. And Ms. Blair, do you recognize what's up on the screen as now exhibit 3?
Yeah, Kevin, by that wording, it could be, how to do it better.
Before?
I do.
And what are we looking at?
Within item 7-16, those are pieces that were mechanically fit together.
And Ms. Gilman, if I could have 2096. And Ms. Blair, do you recognize what's now been marked as exhibit 386?
I do.
And what do you recognize that?
So, and you'll notice all the price tag stickers that aren't price tags, but actually evidence labels. So each one of those is on a different piece of apparent plastic. And depending on how you're watching this, you might see, like right here where my mouse is a piece of Scotch tape. Right here, this whole area is a mess of Scotch tape, just holding all these pieces together. So this is a reconstructed taillight lens, and presumably we'll see how it fits into the taillight housing, and it very well could. Of course, she's presumably been wearing gloves, and we all know how wonderful it is using Scotch tape with gloves, but yeah.
So that is what I called piece 1. So the piece that is made up of apparent plastic pieces from many of the different items.
And Ms. Gilman, if I could ask you to just zoom in a little onto the middle of that photograph.
What exhibit number is this, Mr. Malley?
Yes, Your Honor, this is 386.
And now you can better see the tape, and like this label says 7-13, 7-6, I think, and a handwritten D, handwritten A, and 7-6, I think. So if I'm remembering right, so 7-6 and 7-6, so they were brought in as the same exhibit in the same exhibit bag, and then the sub-label A and D is her label to differentiate the pieces within that evidence bag. So
And from sort of this zoomed in version of 386, Ms. Blair, are you able to now see some of the stickers or the evidence stickers that you would put labeling each of these pieces?
Yes.
And you could just use the way that you want to draw the attention where those leave in the photograph.
So these labels right here are the labels that I put on each piece individually when I initially examine it. So all of the little white labels.
And Ms. Gilman, if I could have 2097. Ms. Blair, do you recognize what's up on the screen? What is now been marked as exhibit 387?
I do.
What do you recognize that to be?
That's still piece 1. It's just from a different angle.
Ms. Gilman, if I could have 2101. And Ms. Blair, you recognize what's up on the screen now that has been marked as exhibit 390?
I do.
What are we looking at?
That's still piece 1 from another photo taken from another angle.
And Ms. Gilman, if I could have 2103. And Next, do you recognize what's up on the screen, which is now been marked as exhibit 392?
I do.
What are we looking at?
Benny Hill music, I presume, of the time lapse.
That's exhibit 392.
That is another angle of piece 1.
Ms. Gilman, if I could have photograph 2107. Ms. Ware, do you recognize what's up on the screen, which has now been marked as exhibit 395?
I do.
And what are we looking at in exhibit 395?
May I look at my notes?
Sure.
Okay. Uh, Okay, so that is piece 2.
And Ms. Gilman, if I could have 2110. Ms. Gilman, if you could just zoom in a little bit on the stickers on this photograph. And Ms. Ware, do you recognize what's up on the screen, which is now marked as exhibit 398?
I do.
What do you recognize that?
That is piece 3.
And Ms. Gilman, if I could have photograph 2111. And Ms. Gilman, if you could zoom into the stickers. Ms. Valier, do you recognize what's up on the screen, which has now been marked as exhibit 399?
I do.
There was a little damage to basically the tailgate, liftgate, whatever, right below the rear windshield. And I believe the bumper a little bit. And what do you think this is? CSI?
Do you recognize that, Steve?
That is piece 4.
And Ms. Gilman, if I could have.
And so you see there's no mechanical fit between this piece and this piece, but there is between this piece and this piece and this piece and this piece. But there's a gap because this is basically dust.
Photograph 2113. Yeah, you can zoom in this little. And Ms. Ware, do you recognize what's up on the screen now that's been marked as exhibit 401?
I do.
What do you recognize that?
That is piece 5.
Okay. Your Honor, may I approach?
Yes.
So, Ms. Valier, earlier I'd put before you another 23 photographs. Do you recognize what's depicted in those 23 photographs?
I do.
What do you recognize that?
That's comparisons between item 3-1 and piece 1.
And item 3-1 again was the taillight, is that correct?
Correct.
Your Honor, with course, Court Commonwealth would seek to introduce and admit as the next exhibits.
Publish means showing it to the jury. So putting it up on the screen is publishing it. Admitting it means it's an exhibit, the jury can see it later. So you can publish something without it becoming an exhibit, but that means the jury only gets to see it while it's being published. But if it becomes an exhibit, you know, they'll either have it or have a picture of it, you know, representation of it, whatever, in the jury room when they're deliberating. So publish, put it on the screen. Admit makes it a exhibit. The appeals court would have access to the non-exhibits that are published because it is part of the record. The jury just doesn't get access to it. So, you know, if you publish something, let's say something's been suppressed and you publish it. Okay, yeah. So that's it. That's it. So even not non-published exhibits, but also published non-exhibits, it all goes to the appeals court. It's all part of the record. It's just a matter of what does the jury have access to and when. The appeals court, as long as it's on the record, gets it. Oh, yikes. That was from the court feed, not me. Oof. Well, takes time putting stickers on 23 photos.
7403 434. Thank you.
Thank you. Your Honor, with court's permission, if I may publish some of these photographs
Oh,
for the jury.
Yes.
that's brutal.
Ms. Gilman, if I could have photograph 2156. Where do you recognize what's now up on the screen has been marked as Exhibit 403?
I do.
And what do you recognize that to be?
That's one of the photos comparing item 3-1 and piece 1.
All right. So this is actually fitting the taillight fragments into the assembly. So,
Ms. Gilman, if I could have,
and just for orientation, I believe this is the bottom of the assembly. This is the back on the right-hand side of the photo, our right. And then 90-degree bend, and this on the left side would be on the passenger side of the SUV, I think. Because this clear glass would be the clear glass is on the rear. This just looks reversed to me. The image looks reversed to me, so it's got me confused.
photograph 2125. Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 411?
I do.
And what do you recognize that to be?
That's the contents of item 3-1.
And that's prior to you, at what stage of this analysis or comparison process is that?
So that's when I initially looked at item 3-1.
If I may have a moment?
Yes.
Mr. Gilman, if I could have photograph 2150. And Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 431?
I do.
And what are we looking at in 431?
So on the left is item 3-1, piece A, and then on the right is piece 1.
And Ms. Gilman, if I could have 2151? And Ms. Blair, do you recognize what's up on the screen, which has now been marked as Exhibit 432?
I do.
What are we looking at in 432?
No idea, Kevin. This courtroom sucks. This courtroom sucks, but it's the one the defense wanted. And apparently he needs to stand away from the podium so the jury can see the exhibits, because this courtroom sucks. But all right, this one definitely isn't rotated or reversed. So on our left, because the clear plastic is faced to the reverse. And so this is around onto the passenger side. So
That is piece 1 on top
Lisa?
of item 3-1 in mechanical fit.
Is that the mechanical fit that you were talking about earlier in the testimony?
Yes.
Thank you. Ms. Gilman, you can take that down. Thank you.
So I mentioned in my opening ramble that we ended Monday with quite a big piece of evidence that it fit. And, you know, some of you on Monday missed it before I pointed it out because it was said so matter-of-factly, nonchalantly. But I wasn't too worried about it because I realized, you know, that's not the only time the jury's going to hear about it. The jury's going to see it. And so Lolly not making a huge fuss, not, you know, being expressive, I knew we'd end up seeing this last photo, which, you know, it shows that the taillight pieces came from the taillight from Karen Reed's SUV. And yeah. This is a witness I probably should have done at 1.5, but I think that's a little excessive for my taste.
Mr. Lear,
Especially since some people will watch me at 1.5 and that'll just screw everything up.
in reference to those items that you testified to earlier in item 3-1, the taillight housing, what, if any, conclusions regarding those items as far as the physical match? What, if any, conclusions did you come to?
That item 3-1 and the pieces that make up piece 1 were at one time together as a larger unit.
Thank you very much. I have no further questions. May we approach Rob?
As well you should. And that, in order to do that, well, I don't, unless they say some Puerto Rican guy stole her SUV and hit John with it, I don't know how they can do this some Puerto Rican guy defense to this. And that's a problem for them. In order for the conspiracy to fit this, it's, oh, the taillight wasn't actually broken, or it was broken somewhere else. And conspiracy. They sprinkled it under a foot of snow, under 18 inches of snow. They sprinkled the taillight pieces to find which 18 inches of snow. That's preposterous. I guess we're not getting straight into cross-examination. Although it looks like we are quickly, so I'm not going to bother because, yeah. And I remember seeing on Monday after Monday's court day had ended, the Free Karen Reed crowd saying, "Oh, the defense doesn't even need to cross-examine this witness. It, she sunk the prosecution's case." Yada yada, and I have a feeling they're saying, well, they're not going to actually admit it, but they were wrong. Cross-examination is needed because she wasn't an exciting witness, but she was a good witness. She did damage to the defense. So, yeah. And no. Like, I highly doubt he would ever be called. Like, I'm sure Turtle Boy is a witness. I'm sure he has stuff he could testify that Karen Reed told him that would be admissible. But he would be such a poor witness that it wouldn't make sense for the prosecution to call him. So it's yeah. And the thing is, for defense attorneys, having a client found guilty, you don't like it, but you know, a large percentage of your clients are found guilty. Maybe not on national television, but a large portion are. And, if you're seen zealously representing your client, that's what matters. And Painted Bronco, you've got it. So only the people looking for taillight pieces found taillight pieces. Conspiracy. And can the prosecution get away without calling Proctor? Potentially. From what we've heard, every witness that spoke with Proctor, there was another trooper there. Whether it's Trooper Tully or Trooper Buchanan or whoever, So can they? Potentially. But that leads to the question, does the defense call him because they might not like having to ask him questions on direct? I'm sure if they did call him, they'd have already asked the judge, hey, he's a hostile witness, can we lead? And it's, it's entirely possible she says yes, but I don't know if I'm the defense that I want Lolly to have the opportunity to cross-examine Proctor, because then he gets to lead. Most likely, unless there's a rule against it in Massachusetts that I don't know. But yeah, so it just depends. It just depends. So and that's it. The myth of Jerry Spence, 50 years winning streak. You win at trial if you have all your guilty clients plead out. So, you win if you don't try your tough cases. I'm not saying Jerry Spence didn't try his tough cases. I'm just saying I'd be wary of any attorney saying, yeah, I never lose. Because if you never lose, you never try. So and that's not just criminal defense.
Good morning.
Good morning.
You have testified that when evidence comes into the crime lab, it's given crime lab evidence or item numbers, correct?
It's given a case number, and then each piece of evidence gets its own individual item number.
Okay, and if you can just keep your voice up, because we want to make sure that the last jurors here can hear you. Consistent with that policy, the evidence that your lab received in this case was also given those item numbers, correct?
Correct.
So I'd like to ask you about one particular item number in this case, 7-18.18. Would you agree with me, and feel free to check your records, but would you agree with me that that was the item number given to, quote, debris from orange t-shirt and gray long sleeve shirt, end quote?
Okay.
You can go.
Okay.
And again, it's 7-18.18.
Debris from orange t-shirt 7-17 and gray long sleeve shirt 7-18-JO.
Terrific. Item 7-18.18 did not include the orange t-shirt itself, correct?
No.
Believe that you just testified that was given a different item number, which was 7-17?
I believe so.
And 7-18-18 also did not include the gray long sleeve shirt either, correct?
I didn't look at 7-17 or 7-18. I only received the debris from.
Okay, well, yeah, that's my point. So with regard to the orange t-shirt and the gray long sleeve shirt, those were given separate item numbers, and you examined what was the debris allegedly from those shirts, right? 7-18.18, correct?
Correct.
And that debris consisted of...
So once again, the defense is taking what is completely normal and appropriate and making it sound suspicious. So you only analyzed the debris. You didn't analyze the t-shirt itself, did you? It's separation of powers. It's separation of duties. She doesn't do blood work. I can't remember what her title, well, I mean, she's, lab tech 2, whatever. But she mentioned the things she's certified in. And I remember there were 2 things. Like, she's not even tested. She's not certified on DNA work. Neil, good to see you, even for just a quick hello. I hope well, I don't even know that the post office trial is still going on, but I hope you're enjoying it if it is. But basically, she's the puzzle master and something else. So her not analyzing the shirts, that's because it's not her job. The defense, ooh, conspiracy. Someone else did that. Someone else that we've already heard from. So that was the previous witness. We heard from them. They testified about their analysis of the shirt. But it's suspicious that not everyone did it. And it's like, as Mark says, if work is distributed, hey, you've got to show that all of them are corrupt and not just one person. But there's also, areas of competence. She's the puzzle master, puzzle mistress. But once again, going back to the discussion of the DNA tests, the Commonwealth could have done the DNA tests. It would have been a waste of taxpayer money to do the DNA tests. It would be a waste of taxpayer money to have this lab analyst do the exact same work that the other lab analyst has already done. Divide and conquer, not, hey, let's all do the exact same thing 3 times. But it's suspicious that they didn't. How dare they? And that's it. Higgins, who has no power at the Massachusetts State Police, told her not to, told her how to do her job. Conspiracy. And Neil, good to know. Good to know. Like I said, I haven't paid any attention to that whatsoever. Maybe I should have.
Different categories, did it not?
There were different there were different things inside of it, yes.
Yes, different categories of things, correct?
I'm sure.
All right, so one category was dirt and debris, correct?
Yes,
You did not test the dirt and debris, correct?
correct.
Another category was, or were, I should say, several apparent hairs.
Yes,
And you did not test those hairs, correct?
correct.
And another category, I believe you've already testified to, consisted of several pieces of red apparent plastic and one piece of clear apparent plastic that measured 1/8 of an inch by 1/16 of an inch. Is that accurate?
Okay, so there were several pieces of red apparent plastic and then one piece of clear apparent plastic measuring approximately 1/8 of an inch by 1/16 of an inch, yes.
Okay. And I apologize for continually reminding you, but I'm just mindful that everybody needs to hear you. So to the best you can, if you can just keep your voice up, I'll try to do the same. So when those several pieces of apparent red plastic and one piece of apparent clear plastic came into your possession, those pieces were obviously not embedded in either shirt when you examined them, correct?
I don't know. I didn't examine the shirt.
Well, so to my question, the pieces that you saw were not embedded in a shirt when you examined them, correct?
Correct.
And again, that's because you never took possession of any shirt in this.
And once again, that's because it wasn't her job analyzing the shirt. Not her job. Her job was to put it together. Someone else to analyze or to look at the shirt, to gather debris off the shirt. But suspicious.
Case, correct?
Correct.
The pieces were loose and they were not embedded in anything, correct?
The pieces were, well, I examined the debris from the shirt. I don't know what the person who packaged it did to collect that.
Another one.
And so it goes without saying that you never saw those pieces on either the orange shirt or the gray long sleeve shirt, correct?
I did not.
And you obviously had no control over how the evidence was handled before it came into your possession, correct?
We have a chain of custody in the laboratory, but I did not follow the evidence as it went through the chain.
Okay, and we'll talk about the chain of custody in a minute. Before this evidence came into your possession, you did not witness who seized it, correct?
Correct.
You did not witness who handled it, correct?
Correct.
Before it came into your possession, you don't know who had access to that evidence, correct?
So all of our evidence is stored in locked facilities.
So
Right.
actually, when you say that viral defendant, I immediately thought of the one in Washington, the Moroccan tribal chief. But are you talking about the one that was driving on a suspended license in Judge Simpson's court? Because that one, so this might be a little controversial, but Judge Simpson was right. Judge Simpson was right. So the guy, to my knowledge, once again, the guy's license should not have been suspended. Okay, we're presumably. I don't know necessarily. You know, I've heard maybe that, you know, maybe it hadn't been reinstated because he hadn't completed paperwork or fees or whatever. I don't know. I don't actually care. It might have been an administrative error, might not, doesn't matter. What does matter is he was stopped previously and had a suspended license. So he was facing charges for driving on a suspended license. So the information before the court was, this guy has a suspended license. He is driving, therefore he's breaking his bond violations, off to jail. That's the only decision Judge Simpson could have made. It was the right decision. It absolutely sucks for the guy. But he had knowledge that his license was suspended. So until he affirmatively knows that it's not suspended, that even if it's an administrative error, until he has affirmative knowledge that the administrative error has been fixed, he can't be driving. It sucks. It really does. It really does. And the thing is, you know, the other case, the Washington case that I initially thought you were talking about, where, you know, Chief Know Nothing, I want to fire my standby attorney because he couldn't explain to me what an affirmative defense is. this guy had an affirmative defense in his case if he had just not driven. If he had just shown up to court, he had an affirmative defense. That affirmative defense is, hey, it's a clerical error. I was legally driving when I was pulled over, and it was an administrative clerical error, therefore I'm good. And get that clerical error fixed and case dismissed. So it really does suck for him. It really does. It really does. But if you know your license is suspended, right or wrong, don't drive. Don't risk it, especially not on Zoom court. And that's it. Don't drive distracted ever. Don't drive in Zoom court. He could have been hooked up for contempt of court just for that. They usually aren't. They're usually given a warning. But you could be hooked up for contempt of court just for that. So, yeah. Ooh. I did not see that. I did not see that. And thank you for being a member for 5 months, And so, yeah. Yeah, that's basically where we are. So, yeah. But once again, Yannetti, back to the subject matter at hand. Yannetti trying to make it look suspicious that she did her job and only her job. We left off with him. Yeah, we'll get back to the chain of custody. Chain of custody only matters, like, she only documents the chain of custody while it's in her custody. The investigators are in charge of the complete chain of custody. She doesn't have to know where it was before, only how she received it and who she gives it to and what she did with it. So, and Pat's Cats, you're not late. You're not late. You've been here for 5 months. Well, scratch that. Thank you for 5 months, and you're here now. So that's what matters.
I guess let me modify that question. Before it came to your lab, you don't know who had access to that evidence, correct?
Correct.
You also don't know, before it came to your lab, whether the shirts in question were at all times kept separate from the red or clear plastic pieces of, pieces of plastic that were in the possession of certain members of the state police, correct?
Correct.
The chain of custody at the crime lab started with noting the state trooper who actually delivered the evidence to your lab, along with the date, correct?
All right, could you repeat the question?
Sure. The chain of custody at the crime lab starts with noting which state trooper delivered the evidence to your lab.
Because once again, the chain of custody to her, she only documents her custody. Hers. So when it's delivered, that's her chain of custody. The complete chain of custody is not her concern. It's just everything's suspicious.
And the date that he or she delivered it, correct?
Or a crime scene responder, but the person who drops off the evidence to the laboratory, yes.
Okay. And in this case, which particular state trooper delivered the orange t-shirt and gray long sleeve shirt to your crime lab?
I don't know.
Well, which state trooper delivered the pieces of red and clear plastic, pieces, I should say, that you just testified about?
The item 7-5 to 7-19.
Right, the several pieces of red apparent plastic and one piece of clear apparent plastic measuring 1/8 of an inch by 1/16 of an inch. That's what I'm referring to.
Wait, sorry, could you repeat the question?
Yes. You understand what I'm talking about, right? In terms of the several pieces of red apparent plastic and then the one piece of clear plastic that you have the measurements for?
You're talking about the apparent plastic that I noted in the debris of 7-18.18?
Correct. Which state trooper was it that delivered that?
Do you know?
Sorry, that's that's an odd question.
I'm sorry.
I don't know if you want her to repeat it, Ms. Giannetti. Go ahead. You have to repeat that, please.
So evidence is
No,
submitted to,
what you just said that he missed.
oh, I said that's kind of an odd question.
Oh, not for me.
So
Your questions are intentionally odd.
Do you have a record of that?
a record of what?
A record of which state trooper delivered that debris to the lab?
So it wouldn't be delivered as like debris. It would be delivered as the individual piece of clothing, which then got assigned item 7-18, I believe. And then as someone analyzes it, each offshoot of that piece of evidence gets a 7-18 point something. So the debris collected from that shirt is 7-18.18.
Okay, all right. Listen, when those several.
Your question was bad because you asked who delivered that debris to the lab, and she's trying to explain nobody delivered debris to the lab. The lab collected the debris from the shirts. So ask who delivered the shirts, who delivered the package to the lab. The reason she's struggling with your question is because it's a poor question. Ask the right question. But he's intentionally trying to be misleading, and she's not biting, and that's frustrating him.
Actually, let me strike that. It's where I was.
Take your time, Ms. Giannetti.
Okay, so I want to confirm with you that when you were assigned to this case, you were aware that the date of the incident was January 29th of 2022, correct?
Yes.
All right. And it's your testimony that you don't know which state trooper delivered the shirts to the lab, correct?
I could look at my notes because I have a printed chain of custody.
You didn't ask who. You have never asked who delivered the shirts to the lab. You asked who delivered the debris. And she explained the debris was collected from the shirts by the lab. So she has not testified that she doesn't know who delivered the shirts. Because you didn't ask that. You never asked that. You are intentionally misleading. Once again, you never asked who delivered the shirts. Who delivered the shirts and who delivered the debris? Two separate questions.
Sure, if you would check your notes for that, please.
Okay. So. Okay, so submission 7, which is everything that's item 7- in this case, was submitted by Trooper Michael Proctor, I believe.
Oh, that was the answer to my question.
No,
Thank
fuck you, fuck you, fuck you. No commentary. No commentary. No commentary. That was the answer to my question. Because you finally asked the question.
Long after January 29th of 2022, according to your records, did Michael Proctor deliver that clothing to the crime lab?
It was delivered on March 14th, 2022.
Okay, so about 6 weeks or so after January 29th, is that accurate?
Sure.
Given that your lab received this evidence on March 14th of 2022, you can't testify to the chain of custody of the clothing or the pieces of plastic prior to March 14th,
She wouldn't.
2022, correct?
Correct.
That's not
And
her
Except for
job.
the tail light housing that was seized by Maureen Hartnett, except for that, your chain of custody at the lab for the 2 shirts plus the pieces of plastic in 7-18.18, that began on March 14th of 2022, correct?
Correct.
So between January 29th of 2022 and March 14th of 2022, you do not know what Michael Proctor did or didn't do with the orange t-shirt and gray long sleeve shirt, correct?
Objection.
I'll allow it.
I don't know.
Once again, why would she? Why would she? The chain of custody before she receives it is of no concern to her. None whatsoever. It doesn't change how she analyzes it. Trooper Proctor is the one responsible for documenting the chain of custody through every step of the process. Or Trooper Buchanan or Tully or, the evidence sergeant, evidence custodian, whoever. The lab documents what they do with it, where it goes while they have it, who touches it while they have it. And then what do? They hand it back along with their notes to go into the official chain of custody.
Okay. Now, I'd like to discuss with you, if I might, Michael Proctor's submissions of the pieces of plastic that you've testified about.
Apparent plastic.
Your lab received from Michael Proctor several different evidence bags containing red, clear, and black pieces of plastic, correct?
Correct.
Some of those evidence bags contain relatively small pieces of plastic in them, correct?
Correct.
And some of those evidence bags contained larger pieces, right?
Correct.
The evidence bags that you received listed the dates of recovery of those pieces of plastic, did they not?
I believe so.
And the evidence bags that you received also listed the officer who recovered the plastic pieces, right?
I believe so.
And again, when you receive those evidence bags, whatever numbers are on them, your lab assigns them your item number, correct?
Correct.
So I'd like to ask you first about item number 7-8. Do you have a record of that?
Yes.
Now, that evidence bag, item number 7-8, contained multiple pieces of red, black, and clear pieces of plastic, correct?
Okay.
Short line.
Okay, thanks. Okay. Contained 14 pieces of red, black, colorless, and silver colored apparent plastic. Yes.
Okay. And the date of collection was February 3rd of 2022?
Go ahead.
Okay. Item 7-8,
Yes.
February 3rd, 2022.
Okay. And that was, if you have that in front of you, that was also collected by a trooper named DeChico, correct?
Oh, yes, correct.
I may approach, Your Honor?
Yes.
So I show you a photograph. Can you identify what that is?
Yes.
What is that?
That is the handwritten label on item 7-8.
That would have been the evidence bag that your lab received and gave item number 7-8 to it, correct?
Correct.
And that appears to be an exact, photograph.
I don't think there's an
of the actual bag.
objection to it, so we
Yeah,
can
that's
just put
true.
it in.
Okay. May I offer that, Your Honor?
Sure.
Exhibit 435.
May I display that for the jury, Your Honor?
Okay.
And this is.
Well, I assume that's true for Buchanan, and that you're saying, well, yeah, he's going to testify about the entire chain of custody and make Yannetti look like an idiot. But Yannetti, he's making hay while the sun shines. Conspiracy, everything's suspicious, even though it's not actually suspicious if you understand standard investigatory practices. So
That is what I just showed you on the screen, correct?
Correct.
That's where it's indicated what the date of collection was and which trooper collected it, correct?
Correct.
oh no, DeChico.
We can turn the lights on for a minute. And you would agree with me that that date, February 3rd of 2022, was only 5 days after the January 29th blizzard, correct?
I don't recall the dates of blizzards, but
Oh, okay. Well,
sorry.
I mean, I can empathize because, all the free Karen Reed people tell me I'm the world's worst attorney because, I keep saying, let's go off the evidence presented in court and wait until all the evidence is in. So, I have empathy for the witnesses who are clearly the world's worst evidence technicians.
let's put it the date of the incident. You had
Okay.
previously testified that was January 29th, correct?
correct.
All right. And February 3rd was 5 days after that, right?
Yes.
All right. I'd like to show exhibit 279, please.
Good to know.
Okay.
Although I'm surprised you had time to see or hear the evidence, fighting with morons on Discord all day. Well, moron on Discord all day.
Now, exhibit 279, which is displayed on the screen now, this is one of the photos taken of some of the contents of item 7-8, is it not?
That's the entirety of the contents of item 7-8.
Okay. You would agree with me that
No.
those were the pieces that were inside that evidence bag, labeled February 3rd as the date of recovery 5 days after January 29th, correct?
Correct.
Okay. And you see that there are some relatively small pieces that were allegedly found on February 3rd, correct?
Correct.
All right. Now, Your Honor, I'm continually showing photographs. We can turn the lights on and off, whatever the court's preference is.
You can just tell the court officer when you want the lights turned.
Okay, all right. So they get turned on for like a question or two, and then I turn them back off.
However you want.
See, I'm the other way around, trial on that screen, StreamYard on that screen, Discord on my phone.
That's fine. All right, so I'd like to contrast some of those pieces with some of the pieces that were found days and weeks later by Michael Proctor. And I'd like to start first with item 7-13. This is, I'd like to display exhibit 343, which, Mr. Bates, is item 5. Okay, all right. You were previously asked about exhibit 343, which is now displayed on the screen.
Yes.
And that is the first evidence bag submitted by Trooper Proctor, is it not?
So in mine, sorry.
And let me rephrase that. He submitted evidence bags all at one time, correct?
Yes.
All on 314. So when I said the first evidence bag, I meant the earliest date of collection. I should have asked it that way. February 8th of 2022.
Sure. I don't know all of the
The sovereign citizens would be appalled. Corrosive, no badge number.
dates that each item was collected on.
Okay, but in any case, those, according to the evidence bag that you received, the contents of that bag, which were, again, pieces of plastic, correct?
Pieces of apparent plastic.
Pieces of apparent plastic. Those were found 5 days after the pieces that you previously testified were found by the Chico, right, on February 3rd?
Correct.
all right? And February 8th was now 10 days after January 29th, correct?
Correct.
Can I have displayed exhibit 346, which is 5A?
It's almost like they were found in 18 inches of snow. So it took a few days for the snow to melt. I don't know if Yannetti knows this, but snow doesn't melt all at once. Unless you get that thermal mass effect that I can't remember what it's called, but basically it's where the snow and air and everything reach the ideal temperature, and the snow and air are the same temperature, and it just causes the snow to kind of go is the scientific explanation. But you know, in the shade, snow melts slower. I know that's a shocking thing. I know it's wild. You know, I look at the mountains behind me, and even in winter, you can tell exactly where the ridge line is, because on the south side, no snow. On the north side, in the shadow, snow. So at 34 Fairview, near the flagpole and fire hydrant, there's also trees. So in that area, the snow, some of that area, I should say, the snow would be slower to melt. So some of it, let's say on the road, you find those pieces faster than, let's say, if pieces flew onto the lawn. Snow melts off the road faster than it melts off the lawn, usually. So you're going to find pieces under 18 inches of snow gradually. It's not a conspiracy. I mean, if it is a conspiracy, it's the world's worst conspiracy, because if you have the taillight fragment fairy sprinkling them about, wouldn't you find it all at once then? But it's dumb. Dumb, dumb, dumb. D-U-M, dumb. And I'm SMRT smart. And I do know SMRT smart is from The Simpsons. I can't remember what DUM dumb is from. Might also be The Simpsons, but yeah. So, yeah, Mother Nature in on the conspiracy. It goes all the way to the top. I mean, yeah. Julius Caesar is in on it, because we're on the, or no, I can never remember. Are we on the Julian calendar, or did we go off the Julian calendar? And either way, I'm saying Julius Caesar is in on it because the Julian calendar, at the very least, was a thing, and he lent his name to the Julian calendar. Therefore, conspiracy. And that's it. Frankly, he shouldn't be. He shouldn't be able to question her about other people's actions that she didn't witness. But, you know, oh well. That's what I thought.
Okay, looking at,
I thought it was Gregorian. And is it Gregorian because Pope Gregory the something initiated the change? But either way, if it was a pope, that puts the Roman Catholic Church in Boston, mind you, in Boston, all these Irish Catholics. So we've got the Roman Catholic Church, we have Julius Caesar, Rome. It's all coming together. All coming together. It's at the behest of Rome. You know, that meme of Charlie from It's Always Sunny with the, you know, strings connecting everything. This is my Charlie moment. It's all coming together. We've cracked it. We've cracked the conspiracy.
Exhibit 346, you will agree with me that this particular piece found on February 8th by Trooper Proctor was quite a bit larger than many of the plastic pieces that had been found by Trooper DeChico 5 days earlier on February 3rd.
And don't forget Julius Caesar too, JT Davis, because going from the Julian calendar to the Gregorian calendar, part of the conspiracy.
Correct?
I mean, there were a variety of sizes of pieces on the other one, but that is what is that, approximately 4-ish inches?
Right, but my point is, Exhibit 346, what's displayed, that's plastic.
You're right. Julie Albert, Chris Albert's wife. Conspiracy. Julie might be Julius Caesar in disguise.
Piece is quite a bit bigger than the small pieces that were contained in DeChico's collection, correct?
Then some of those pieces, yes.
Okay. Now I'd like to move on to item 7-15, and if I could show Exhibit 352, please, which is item 8, Mr. Bates. Okay. Item 7-15, the evidence bag that supports that lists the law enforcement officer who recovered the plastic pieces as Trooper Michael Proctor, correct?
Correct.
And the date of recovery of those pieces was February 11th of 2022.
And Paul, I think a lot of it is, you know, they just like a good conspiracy. Once this is over, they'll go back to flat Earth or QAnon or whatever, you know. And so I don't know that Xenu is involved yet. But if anyone's named Tom, you know, we'll assume it's Tom Cruise and that. Yeah.
Correct?
Correct.
And again, hearkening back to DeChico's evidence bag from February 3rd, this is now 8 days later that these pieces are found, correct?
Correct.
And it's now almost 2 weeks that these pieces are found after January 29th, right? 13 days?
Correct.
All right, if I could show Exhibit 355, which is 8A, Mr. Bates. You would agree with me that this particular piece found by Trooper Proctor on February 11th is also quite a bit larger than those small pieces that were contained in Trooper DeChico's evidence collection, correct, on February 3rd?
Correct.
All right, I'd like to move on to item 7-16, which is number 9, Mr. Bates.
What exhibit number is this, Mr. Chairman?
And this has not yet been introduced, so I'm about to introduce it. And in fact, why don't I do that first?
Okay.
If I can approach the witness.
Sure.
That's
There's no
probably
objection to
good
this, Mr. Lally?
to follow the
I'll
procedure.
just have the witness identify it and then offer it. Do you recognize what that photo depicts that I've handed to you?
I do.
What is it?
The handwritten label from item 7-16.
Okay, I would offer that, Your Honor.
Okay,
Exhibit 436.
thank you.
Okay, so if I can display Exhibit 436, which is number 9.
Sure.
And again, you just identified that as the bag supporting item 7-16, correct?
Correct.
That also lists the law enforcement officer who recovered the plastic pieces as Trooper Michael Proctor, correct?
Correct.
And the date of recovery of those plastic pieces was February 18th of 2022, correct?
Correct.
So Trooper Proctor is now finding these pieces over 2 weeks after the smaller pieces were found by Trooper DeChico.
And once again, the appropriate person to question about this is Trooper Proctor. She has no information about how these things were found. It's none of her concern.
Correct?
Objection.
Sustained.
February 18th is nearly 3 weeks after January 29th, is it not?
Correct.
All right. If I could show Exhibit 370, I'm sorry, 380, which is 9A, Mr. Bates.
I mean, we had unit before, so, you know, it got Hank Hill all aflutter. Exactly.
You would agree with me that this particular piece found by Trooper Proctor on February 18th is also quite a bit larger than.
This is the Puzzle Master. She's the state crime lab technician, evidence tech 2 or whatever it's called. So basically, she's the one that put the taillight fragments together, taped it up, and fitted into the taillight housing. So yeah, she's not an expert in chronology. Get Mr. Rolex on the stand for this.
Smaller plastic pieces found by Trooper DeChico on February 3rd, correct?
Correct.
This one appears to be about 11 centimeters long, approximately.
Sure.
All right. If I could show Exhibit 376, which is 9B, Mr. Bates. Okay. And you would agree with me that this particular piece found by Trooper Proctor on February 18th is also quite a bit larger than those smaller plastic pieces found by Trooper DeChico back on February 3rd, correct?
Correct.
In fact, that appears to be larger than the piece that you just identified in Exhibit 380, correct?
The one that was just on the screen?
Right.
Yes.
This one appears to be maybe about 18 centimeters long. Does that seem accurate?
I mean, it's longer than the ruler.
Okay, yeah. And finally, if we could show Exhibit 378, which is 9C, Mr. Bates. You would agree with me that this particular piece found by Trooper Proctor on February 18th is even larger than the last one that we just saw, correct?
In length, yes.
Okay. This appears to be about 19 centimeters long.
I mean, longer
It's
than the rule that's up there,
Okay,
but I have the actual measurement in my notes.
sure. Well, and the precise measurement's not important. I'm just getting at the relative comparison.
The precise isn't important. I'm just grilling you on it, but it's not actually important. It's almost like none of these questions have been important. I think he's just trying to get at, well, this larger piece was found after the smaller piece, therefore conspiracy. But once again, snow, blizzard. It's like, you know, we've discussed the relative melting rates of snow. Do you know what also is going to melt slower? So that 18 inches on the grass is going to melt slower than the dense, compacted 3 feet piled up by the snowplow. So it's going to take a lot longer for any pieces that might be in the snowplow debris to get uncovered. And it, you know, you might say, but Joe, surely the snowplow would have broken it and yada, yada. And it's like, well, no, it could be on the bottom and the snowplow threw its debris on top. So
this one's certainly quite a bit larger than the smaller pieces found by Trooper DeChico back on February 3rd, correct?
Correct.
This larger piece of red plastic, like the previous two that you just identified, were all found on February.
We all know anyone using metric is in a conspiracy. I'm looking at you, Linz, European.
About 3 weeks after January 29th, correct, according to your records?
Correct.
And regarding these last three evidence bags, labeled item number 713, 715, and 716 in February of 2022, from February 8th to the 18th, those were all plastic pieces collected by Michael Proctor, correct?
Correct.
And in addition to collecting those pieces,
You turn the lights on, Ms. Giannetti?
I'm sorry,
Okay. And we can take that down, please?
yes. In addition to collecting those,
And sorry, I should have said European scientist lens.
plastic pieces on all those different days, Michael Proctor was also the person to hand deliver those last three evidence bags, all on March 14th of 2022, correct?
Correct.
And you do not know what Michael
I thought there was something sinister about you, JT Davis. I realize multiple usage of the word lefty, but I'm calling you sinister.
Proctor did or didn't do with those evidence bags of pieces of taillight prior to March 14th, of 2022, when your lab received them, correct?
Objection.
I'm going to sustain it. We've already asked that.
Now, the taillight of that Lexus sits in the housing of the Lexus, the taillight housing, such that part of the taillight faces the rear of the car and part of the taillight loops around and faces the passenger side of the car, correct?
Yes.
Sure.
Right, because it's on the corner.
Sure. Yeah.
You'd agree with me that once you received the final pieces on March 14th, and once your lab received that, you were then able to piece together a majority of the taillight, correct?
So I wasn't assigned this case until later, once everything had already been submitted to the laboratory.
Right. So it was true that after Michael Proctor submitted these pieces of taillight on March 14th, it was after that that you were able to do the reconstruction that you testified about, correct?
Correct.
If I could have exhibit 432 displayed, which is image 2151, Mr. Bates. That is the reconstruction, the final reconstruction that you were able to do, correct? You would agree with me that there's one section of that.
What are the units that Grandpa Simpson uses? You know, it's always been 7 rods to the hogshead, and I'll be damned if those commies make me change it, or something like that.
That taillight that was missing completely, correct?
Correct.
And that missing section is noticeably visible in your reconstruction, is it not?
Yes,
And you still have that laser pointer there?
I do.
Would you please point to the section of taillight that's missing?
Oh, you didn't find all the tail light, therefore conspiracy. But once again, if it were a conspiracy, if it were planted, you'd plant the whole damn thing. You'd plant the whole damn thing. Oh, you just live in Europe? Although, I don't know that you've ever specified you live in Europe, just not the US. You could be Canadian. Or whatever, you know.
Appears to be a hole on the upper left side of that exhibit.
Is that a question?
Yes, it actually was. I should have said right or correct, but I didn't.
Yes.
Okay. And you would agree with me, and if we could zoom back out, Mr. Bates.
I could have sworn you'd said Europe, but either way, you've said scientist. Too many people coming and going, and I get them confused sometimes. So, sorry. Although maybe not sorry. Maybe you wish you were in Europe.
You would agree with me that the portion of taillight that you did not have was strictly on the rear side of the taillight, if I can call it that.
I am not sure what orientation that goes on to a car.
Okay. But in any case, to this day, you do not know where the pieces that make up that whole are or what happened to them, correct?
Exactly.
I do not.
I may have a moment.
Okay.
No further questions. Thank you.
All right, Mr. Lally.
Ooh. Yeah, I've never been to Vienna. I I'd go in a heartbeat. I'd live in Vienna in a heartbeat. There's a reason it's considered one of the best cities in the world to live in. I'd happily go to Munich. You know, my Oma is from Regensburg, so she's Bavarian, north of Munich, upriver from Vienna. And like in Germany, you know, the Cologne Cathedral gets the press. Regensburg actually has, in my opinion, the best cathedral in Germany. I'm kind of partial to Durham Cathedral as the best in Europe, but yeah. Regensburg is just gorgeous. And then you've got the Steinebrücke, the old, 1,000-year-old stone bridge over the Danube, and my Oma grew up basically little itty bitty town across the river from Regensburg that has kind of been consumed into Regensburg and would now, I think, be more considered a neighborhood than a town. But she'd, as a kid, into her 20s until she moved here. But also when she'd go back, go wandering in the Bayerischwald, the forest, and just, yeah. So it would be nice. I wish I had. So my Oma, she gave up her German citizenship when she married my Opa because she's like, well, I'm moving to the U.S. I should have U.S. citizenship. So she gave up German citizenship, and she really regrets it, and we kind of do too, because it would be convenient to have, but oh well. And Lynn's, people would say that about Utah as well. So there's that. So you're probably right, Bad Scooter. It's the exculpatory pieces of taillight hidden in the frame defendant filing cabinet. So and yeah, Tracy, that's it. My parents went on a river cruise right at the same time I went to Durham. They were supposed to do one in 2020 that did the entire Rhine through the canal and then the Danube, but they started in Budapest and ended in Nuremberg. So one of the stops was Regensburg, and so they had my Oma's family meet them, and they gave them the tour of Regensburg instead of the, cruise. And the cruise actually let my relatives on, and they had lunch on the cruise ship and stuff, so it was neat. And the thing about dual citizenship is some countries allow it, some don't. The US is funny about it in that if you acquire US citizenship, technically they require you to give it up, but you can be born with dual, but they now don't really make you give it up. But it's all just a big mess. And technically speaking, there's a possibility I could hire a German lawyer and get it, but I might not be able to. But the funny thing is, the easiest citizenship in Europe, one of them, based on ancestry, is the Slovak Republic. Because if a great grandparent was a citizen, you can get Slovak citizenship, is my understanding. So here's my problem with that. So my grosopa, my Oma's father, was Czechoslovakian. He's from Marienbad, which is now called Mariansky. It was Marienbad when he was alive, which is right on the Czech-German border. So he was born Czechoslovakian, but, German heritage. One of the Sudeten Czech. So my Oma actually was born Czechoslovakian in Germany. My grossoma became Czechoslovakian when she married my grossopa. They all became German in 1933 due to world events. So the question is, would I be able to claim Slovak citizenship off of my grossopa because he was Czechoslovakian? I kind of doubt it, since he was Czech side of Czechoslovakia. But that's the kind of thing I think about, because I'm weird. And Corrosive is right. The taillight is in the basement. Colin yoinked it off the car and beat John in the basement with the taillight, put the taillight itself back on the car, and just left the fragments in the basement. I think you've got it. I think you've got it. So, and I've never been to Germany because my Oma is insane. Every time she brought all of her granddaughters, none of her grandsons, to Germany. Some of her grandsons, some of my cousins, have brought her to Germany, but yeah. The problem is, every time I say I want to go to Germany, she gets mad and says, you can't, you don't know our relatives, you can't just show up. But I know for a fact, let's say I go to Berlin, complete other side of the country. I'll get back and my Oma will be mad at me, and our relatives are mad that you were in Germany. They're offended that you didn't visit them, even though I forbade you from visiting them because you don't know them, and it's, how am I supposed to get to know them? And I've met a fair number of them, but it's the catch-22. So I know I can't win. So I've gone other places, but not Germany. So yeah, but well, like I said, my Oma is nuts. And I mean, she's 95 and nuts now, so, but she's always been nuts.
Now, Mr. Lear, in reference to item 7-17 and 18, the orange t-shirt and the gray sweatshirt, fair to say you never actually physically saw those items, correct?
The clothing? No, I did not.
Now, the debris that was...
And I will. I don't have money for it now, but I will. And like I said, I've met them. The 25-year-old, he's third cousin, I think, fourth cousin. My Oma had a brother killed in the war and a sister who had one son. They're dead. But she was closest to her cousin. And so even though it's her cousin, and it's like that cousin's kids are my dad's cousin, and so it sounds third or fourth cousin. The reality is, as far as closeness, take one or two of those degrees away, because it really was like my own sister. But the 25-year-old came to visit because he's really close with one of my cousins. But he actually lives in Copenhagen because, it's Europe. So got family in Copenhagen to go visit too.
Provided, are you familiar with how that process or who got those debris items from those clothing items?
I can look at my notes and tell you who submitted it or who transferred it to our unit.
If you could.
Your witness is ready, Mr. Lally.
I'm sorry. And from your view, who was that person?
Maureen Hartnett.
Now, as far as the 1/8 of an inch by 1/16 of an inch red and clear apparent plastic pieces that you observed within that debris, that was mixed in with other debris as far as dirt, fibers, things of that nature. Is that correct?
Yes.
And the 1/8 of an inch by 1/16 of an inch pieces that were contained within that debris, is that something that you observed visually or microscopically or both?
So visually, I take overall pictures of the debris, and then I'll look through the stereo zoom to see if there's anything that looks different, and then I'll take a picture of that. So that is what I did. I looked through the stereo zoom.
Now, as far as the collection of evidence, fair to say you don't know who was a trooper, who was there when they were collected, how many troopers were there when it was collected, when it was collected, anything to do with that, fair to say?
Yes.
And as far as the pieces that you testified to, as far as fitting them mechanically together, all of
Redirect. This is Lolly, so redirect. And Bad Scooter, thanks for becoming a member. I appreciate it.
those pieces then fit mechanically onto the taillight housing taken from the defendant's vehicle, correct?
Correct.
Nothing further.
Okay. All right, Mr. Lair, you are all set. Thank you very much. All right.
Well,
Judge, do you want to take a morning break now? Or wait?
that
People are
was
saying yes, so we'll take the morning break.
super exciting.
All rise to the court, please.
I appreciate it. Although it'll probably go to paying my bar dues this month. Yeah.
So I'll see counsel for a second at sidebar, please.
Court is still in session.
But well, Brandon, if you're still here, here's your sidebar. You know, we didn't start with a sidebar, but we're ending the Act 1, Scene 1 with a sidebar. But that cross-examination really was a waste of time. He didn't have anything of substance to cross her on, and to me, it just came out as a gish gallop of nonsense, trying to confuse the jury, make completely unsuspicious things sounds suspicious, but it just seemed so wasteful. But either way, so bar dues are extortionate. Here in Utah, they're $500-600, which annoys me. And I'm way behind on it, but I need to do my continuing education hours as well. This trial certainly isn't helping with it. I'm really hoping that the online summer convention will count towards this year like they did last year. I should probably confirm that, but you know, that's going to be $200 for that. And like, the bar is a necessary evil, but I really hate the bar because it's so expensive. So expensive. And yeah. So not a month, per year. It's 500, 600 per year. Some states it's more, some it's less, but you know, look at Artie's corporate fiction. You know, he's New York and New Jersey, and I think New York is over 1,000. Applying to Texas, that's just
You are
a
unmuted.
lot. And favorite drink, probably ginger ale. I'm not a alcohol drinker, so yeah. But Mima, hello. So yeah, being a lawyer is expensive, and it's an ongoing expense. If you're at a big law firm, they pay your dues, they pay for your continuing education. They, you know, it's, but the little guy gets the shaft as always. So, but let's zoom through the morning break, because as I mentioned, yesterday sucked. Therefore, today I am tired, because for those of you who don't know, pain is exhausting. And yeah. So, and as you should be. I mean, within the rules, you know, no personal attacks, but, you know, banter is fun. So, and I have to pay for a Pacer if I get things off of Pacer. Yeah, I have to pay for the can't think of what the Utah system is called at the moment. It's something X. No. Either way, you know, got to pay for the state equivalent of Pacer, got to pay for well, for online filing, you have to pay for the subscription to the online filing service. Filing fees in civil cases, you've got to pay. In criminal, you don't, because, yeah. So it's just all expensive. All expensive. And we have not, I get started late because, frankly, if I started at the same time as the court, it would be 6 in the morning, and I don't do 6 in the morning. So, yeah, we start late and we go at 1 1/4 speed, and this is the morning break. So, we're just gonna come back from the morning break, and yeah. Ooh, fun.
You are unmuted.
I'm not all that familiar with Lana. I've seen mention of her, but the reality is, Vince, like, when it comes to frauditors, I only really know the ones that people I watch cover, because I'm not actually interested in frauditors. They're, as Kfar says, glorified prank channels. They're just, power hungry twerps out to harass people. And to me, there's really not a lot interesting about that. Whereas sovereign citizens, I'm fascinated by the ideology, by the mental illness involved. So it's the sovereign citizens that fascinate me. And frauditors just happen to be sort of a peripheral part of sovereign citizens. So I don't actually follow them. But people I watch that cover both, if the person amuses me, I'll watch their coverage of the frauditors. If not, I really don't care to watch, just because, watching furry potato pepper spray someone isn't entertaining, and it's just gonna raise my blood pressure and make me mad. So yeah. And certainly can I just say how inconsiderate Massachusetts is, holding both the Rise of the Moors trial and Karen Reed trial at the same time. Do better, Massachusetts. Do better. So, and I absolutely agree. Of course, I'm not a large person. I don't fight. I don't run away either. I hop away. But yeah, Paul O'Keefe is not someone I would want to mess with. So
Thank you. Maybe see the photograph.
All right, Mr. Lally, your next witness, please.
Yes, Your Honor, Commonwealth call Ms. Christina Hanley to the stand.
Christina Hanlon, another lab geek, I assume.
Step right up there. Watch your step on me.
Yep, lab geek.
You saw this video, the court and jury, the truth, the whole truth, and nothing but the truth, so help you God.
She has to be a lab geek.
I really need you to keep your voice up.
Okay.
I mean, I don't like commenting on people's looks, but she's dressed as the librarian trope. You know, you take off your glasses and whip your hair out of the ponytail, and suddenly the frumpy librarian is really a supermodel in disguise. She's the librarian trope. She's the librarian trope. So, yeah.
All right. Whenever you're ready, Mr. Lally.
Thank you, Your Honor. Good morning, ma'am.
Good morning.
Could you please state your name and spell your last name for the jury?
Sure, it's Christina Hanley. Hanley is spelled Hanley.
And what do you do for work, ma'am?
I am a forensic scientist at the Massachusetts State Police Crime Laboratory.
And how long have you been at the Massachusetts State Police Crime Laboratory?
I have been there for approximately 16 years.
Now, ma'am, if I could ask you just a little bit about your educational background, starting with where did you go and what kind of degree did you receive with regard to your undergraduate?
Sure. I have a Bachelor of Science in Chemistry with a concentration in forensics from Merrimack College.
And then after receiving those degrees from Merrimack, where did you go from?
I began working at the Massachusetts State Police Crime Lab in 2008.
And from your work there in 2008, what did you do next?
So I began as a chemist 1 in the drug identification unit. Once I completed my training in there, I was promoted to a chemist 2. In 2009, I transferred into the trace unit as a chemist 2, which is the equivalent of a forensic scientist 2 currently. And in 2017, I was promoted to a forensic scientist 3 in the trace arson and explosives unit.
And if you could describe for the jury sort of the difference between a forensic scientist or a chemist 1, forensic scientist 2, forensic scientist 3 within your lab.
Hey, no dummies here.
Sure. So forensic scientist 2 is considered like a bench analyst working on casework.
Hey, Ms. Hanley, I'm going to ask you to keep your voice up really loud, okay?
Of course, I can relate. You know, I look younger than I am, so.
A forensic scientist 3 is a unit supervisor, and I also perform casework.
And how long is it you've been a forensic scientist 3 or supervisor within the trace unit?
I have been a supervisor since 2017 for approximately 7 years.
Keep your voice up, please.
Now, Ms. Hanley, with reference
But you could convince me that she's 25, 26 very, very easily.
to starting in general terms with the trace unit, if you could describe to the jury what is the trace unit and what type of analyses are done within that unit.
Sure. So the type of examination that we do in the trace arson and explosives unit, I examine and compare trace evidence such as paint, fibers, hair, glass, tape, miscellaneous items, and I also
18, because I think technically the bar won't admit you before 18. I think.
do physical match examinations as well as serial number restorations on firearms.
What type of training did you receive at the lab?
So I received in-house training as well as some external training. The in-house training consisted of required readings, exercises, observing other analysts working on casework in the lab. I was required to successfully complete a written exam, a competency test, and a mock trial.
And if you could describe to the juries for what your duties and responsibilities are with your current position at the lab.
Sure. So I'm responsible for the daily operations in the unit, training other new analysts in the unit. I perform technical and administrative reviews of case files. I also work on casework, like I had mentioned, examining trace evidence such as paint, fibers, hairs, glass, tape, miscellaneous items, and physical match examinations and serial number restorations on firearms.
And was your lab, the Massachusetts State Police Crime Lab, is that accredited somehow?
Yes, it is.
And can you describe to the jury what that accreditation means, essentially?
Sure. So an accreditation
It's a formal.
I mean, he's certifying her as an expert, but we already know the Massachusetts State Crime Lab is certified. I mean, maybe we need to hear it's certified for her specialty, but yeah.
Recognition that the lab is in compliance with certain accreditation requirements.
And is the lab that you work for, is that currently up to code or up to speed with regard to accreditation?
Yes.
Now, as far as you mentioned that you work as a supervisor and review other people's casework, is that correct?
Yes, that's correct.
Now, when it comes to this specific area, as far as trace analysis or comparison of items, who, if anyone, reviews your work?
I'm sorry, I didn't hear the end of that.
When it comes to this type of analysis, as far as comparison of items, who is it that reviews your work?
So depending on the type of case, currently we do have an external technical reviewer who is authorized to perform that technical review.
And is that external review, is that essentially as a result of there's no one else at the lab that can do what you do?
With some of the disciplines that I perform casework in, I am the only one. So when I do those types of cases, we utilize an external technical reviewer.
Are you familiar with a proficiency test?
Yes.
Can you explain to the jury what that is and how that plays into either your work at the lab or the accreditation process that the lab goes through?
Sure. So a proficiency test monitors an analyst's performance. It's a quality assurance process, and I am required to complete at least one external PT annually. Due to the multiple subdisciplines in trace, I do typically perform or complete more than one proficiency test per year.
And are the proficiency tests that you take, are they required by the accrediting body, ANAP?
Yes.
And have you passed each of those proficiency tests that you've undertaken over the years?
I have successfully completed my proficiency tests.
Now, turning your attention.
That was a very long way to say yes.
Okay, at some points, did you become involved in an analysis in reference to a lab case number 22-02184?
Yes.
And the name of the suspect on that is Karen Reed, is that correct?
Correct.
And if you could describe to the jury, again, just in a general sense, in any sort of case, when items come into your possession at the lab, how is that done, and sort of what do you do with those items when you first receive them?
Sure. So evidence is submitted to the lab through the evidence unit. It's assigned a unique lab number and barcode. The information for the case is input into our LIMS system, which stands for Laboratory Information Management System. And a chain of custody of the items is tracked in that LIMS system. When I take an item into my custody, I then document it with photos and notes. And then I proceed with sampling and microscopic examination. And
I'm sure Pat's Cats is furiously typing this out, but it's the initials of the victim that Frauditor Wrangler is accused of killing. So
instrumental analysis.
Now, specifically when it comes to, you mentioned you have a variety of sort of subdisciplines or different types of testing or casework that you do, is that correct?
Yes.
Specifically as it applies to an analysis or examination of items of glass, what, if any, experience or what types of cases would it be that you've looked at those types of items in the past?
So I have examined glass numerous times from a variety of different types of cases. For example, a hit and run or a B&E.
Breaking and entering.
And as far as the types of, are there different types of glass that you've performed examinations on in the past as well?
Yes, I mean, there could be a variety of type of glass that I could come across for examination.
And with respect to examination of glass, what are some of the steps, or what is the process, or what, if any, instrumentality are you using to conduct your examination?
Sure. So when I examine an item that is glass, I document it with photos and notes, making general observations of appearance, color. I examine a portion microscopically and observe certain optical properties. And then I will also check to see if it fluoresces under UV light. And I also will sample it for analytical analysis using a GRIM, which stands for Glass Refractive Index Measurement.
If you could explain to the jury the GRIM device, how does that work?
Sure. So it measures the refractive index, your refractive index. Your sample is placed into an oil of a known refractive index, and that then gets placed onto a hot stage of the microscope of the GRIM instrument. And it goes through a process of cooling and heating, and it looks for the match point temperature. And from that match point temperature, we're able to determine the refractive index of the glass sample.
Now, as far as that determination of the refractive index of a glass sample, how is that? Is that something that you're viewing, and how are you viewing it? What are you viewing?
It's viewed through the software that the GRIM instrument uses.
And how does that appear as far as visually when you're looking at it?
So it essentially, you watch the cooling and heating process of the sample, like I had mentioned, and it determines the match point temperatures, and it takes an average, and it then calculates the refractive index for the sample.
Now, is there another device that you utilize in the lab called an FTIR?
Yes.
And can you explain, first of all, what that term stands for?
Sure. It stands for Fourier Transform Infrared Spectrometer. Sorry.
And what is that device, and how is that used in your examination?
So it's an analytical technique that's used for certain types of analysis. Basically, your sample is exposed to infrared light, and it reacts in a certain way. And what's produced is what we call a spectrum or a graph. And it's just a series of peaks and valleys that are representative of the sample.
Now, turning your attention back to this case, 22-02184, starting with, were there some glass pieces that you examined in reference to that case?
Yes.
And what were the item numbers associated with the glass pieces that you examined in this case?
Sure. So the item numbers were...
So presumably, last witness, although she does, puzzle master, she does glass and plastic, well, apparent glass and apparent plastic. Sounds like her focus was the tail light. This witness's focus, I'm assuming, is the glass, so the drinking glass, the alcohol glass, the tumbler, whatever. And I don't know if there's enough pieces to reconstruct or what, or running the refractive index to see, yep, it's a drinking glass, or hey, it's got trace amounts of vodka on it, or what. But yeah, sounds like that's our focus with this witness.
Is item 3-2, 3-3, 7-12, and 7-14.
And if you recall, as far as starting with item 3-2, how was there any other sort of label associated with that beyond just item 3-2?
3-2 was a clear, apparent drinking glass.
And item 3-3?
Item 3-3, I believe, was the clear apparent glass pieces recovered from the bumper of the vehicle.
And then item 7-12.
That was some
Possibly.
clear apparent glass that was recovered. It was recovered from the ground.
In the ground at 34 Fairview Road, is that correct?
Yes.
And lastly, item 7-14.
7-14 was also a clear apparent piece of glass that was recovered from the road.
Now, with reference to item 3-2, the drinking glass, what, if any, observations did you make or did you note during the course of your examination of that?
Sure. So it appeared to have broken, irregular edges. And that was all I had noted at that point.
Did you take measurements as far as height and width?
I did.
Do you recall what those were?
I would need to refer to my notes for that.
Yes, you can use your notes.
So the diameter of the bottom of the drinking glass was 2 3/4 inches. Approximately 2 3/4 inches, and it measured approximately 2.5 inches in height.
In addition to the measurements that you took, what, if anything else, did you note as far as the interior and the exterior of that glass cup?
That there was some dirt debris material noted on the exterior and interior of that item.
Now, as far as item 3-3, the apparent glass on the rear bumper of the vehicle, what, if any, observations or measurements did you take in reference to that, or how many pieces were there?
Sure. So it consisted of 5 clear pieces of apparent glass with broken irregular edges. The largest piece measured.
And all of them are referring to it as apparent glass. They must all be in on the same conspiracy.
Approximately 7/8 of an inch by 5/16 of an inch. And the smallest piece measured approximately 3/16 of an inch by 1/8 of an inch.
Now, within those 5 pieces in items 3-3, were they then given each of those pieces respectively an additional label or marker?
Could be.
Yes.
And was that an alphabetical one, essentially A through E?
Yes, I labeled them A through E.
Now, with regard to piece E from item 3-3, what, if anything, in addition, did you do with regard to that piece?
So what I labeled as piece E, I also used the GRIM instrument for analytical instrumentation.
Now, with regard to item 7-12, or the 14 pieces of glass and clear plastic, what, if anything, did you observe in your initial observations or initial examination of those pieces individually?
So in item 7-12, it consisted of 5 pieces of clear apparent plastic and 9 pieces of clear apparent glass, all with broken irregular edges.
Now, specific to the 9 pieces of broken glass, what, if any, examination did you do of them initially?
So the 9 pieces of apparent glass were examined microscopically.
Now, lastly, with regard to item 7-14, the pieces of glass recovered from 34 Fairview Road, what, if any, did you note during your initial examination of them and observations did you make in regard to that?
Sure. So item 7-14 consisted of 1 clear piece of apparent glass with broken irregular edges.
Now, as far as the microscopic appearance, so when you're putting something under the microscope and you're looking at, what kind of things are you looking for? What kind of characteristics are you looking for when you're examining something microscopically?
So I look at several things. So initially, I look at the color, whether there are like flat, smooth surfaces to the glass, whether it's flat or curvature. And then I may sample some more to examine under a polarized light microscope and check to see if there are certain optical properties.
All the flat earthers that joined the Free Karen Reed movement, they can educate her on, ooh, this is flat, this is curved.
These under a polarized light microscope that are characteristic of glass.
And
I still need to make my parody flat earth video because I think it'll be funny.
in addition to looking at each of these items individually, then what, if any, comparison did you do between those various items, 3-2, 3-3, 7-12, and 7-14?
So between those items, I first examined them to see if there was a physical match between item 3-2 and item 7-12 and 7-14. And then I also did a comparison of
My evidence tells me, Kova, we're on a bowl-shaped earth.
3-2 to item 3-3. And then I also compared item
Everything is.
3-3
We
to
all are.
7-14 for possible physical match. And in addition, I also sampled some pieces for use for examination on the Grimm instrument.
Let me ask you,
That is concave, isn't it, Kova? The way I remember it is concave. You've got the cave. So bowl-shaped would be concave, I think. I'm a lawyer, not a scientician.
just as far as classification go, are you familiar with terms as far as a class characteristic versus an individual characteristic?
Yes,
Can you explain what those terms mean and how they relate to each other within your specific forensic field?
sure. So a class characteristic is when a material can be associated with a group of items that share characteristics. Like for example, fibers or tape. An individual characteristic is when a material can be associated with a single source, for example, a physical match.
Now, with reference to your analysis between items 3-2 and 7-12, what, if any, conclusions were you able to draw from your examination or comparison of those items?
Sure. So, right, there are several items that I'll just have to refer to my conclusion. If that's okay, my report.
Yes, you can go ahead and look at your notes.
Yes. So item 3-2 was found to have a physical match with 6 of
I mean, we're already convinced that Alan Jackson is a lizard person, so this is starting to make sense.
the pieces of clear apparent glass from 7-12. But there was no physical match with the 3 other pieces from 7-12.
Based on that physical match that you determined, what, if any, conclusions can you come to with regard to those items that were physical?
Sure. So item 3-2 and the 6 pieces from 7-12 were at one time together as one unit. So then item 3-2 and all 9 pieces from item 7-12 were examined microscopically. However, there was no physical match found with the piece of clear glass from 7-14. Item 3-2 and all 9 pieces of clear apparent glass from 7-12 were examined microscopically, but no physical match was found with 2 of the pieces from the clear apparent glass from item 3-3.
Now, with reference to item 3-3 and item 7-14, what, if any, comparison examination were you able to do in reference to that?
Sure. So Item 3 dash, so two of the clear glass pieces from 3-3 were examined microscopically. No physical match was found with the piece of clear glass from item 714. One of the pieces that I had labeled as piece E from item 3-3 was found to be consistent in physical and instrumental properties with examined portions of the piece of clear glass from item 714. So accordingly, the examined portion of the piece of clear glass that I labeled as E from item 3-3 could have originated from the examined portion of the piece of clear glass from item 714 or from another source with the same characteristics.
Now, Ms. Hanley, you used the term in there as far as instrumental properties. Can you explain to the jury what that term means and how it relates to your examination in this case?
So the instrumental properties, that's referring to the Grimm analysis that I did. So in comparing the refractive index from 3-3 versus 7-14.
So the clear apparent glass from item 3-2 that was recovered from the scene was a physical match for 6 pieces from 7-12, which were additional glass pieces found from the scene, correct?
I'm sorry, say that again?
Sure. So the the drinking glass from item 3-2 was a physical match for 6 of the pieces from item 7-12, which was glass recovered from the scene, correct?
Correct.
And then the 2 of the pieces from item 3-3, or one of the pieces, excuse me, piece E from 3-3, which was from the bumper of the defendant's vehicle, was consistent with a piece of clear glass from 7-14, which was found on the ground, correct?
Correct.
Come on, Vince. You know you're riveted.
Now, Ms. Hanley, in addition to that trace analysis that you performed with regard to the glass pieces, what, if any, other excuse me, additional examination did you do with regard to items of debris?
Sure. So I also examined item 3-1 and 7-18.18.
Now, starting with item 7-18.18, what, if any, other description did you have as far as what that item was or where it came from?
So 7-18.18 is scrapings, trace material recovered from the victim's clothing.
And that would be both an orange T-shirt and a gray long sleeve shirt, is that correct?
Correct.
And those particular items, as far as the debris, that was provided to your unit within the lab by whom?
I believe it was Maureen that did the scraping of the clothing and had those scrapings transferred to our unit for further examination.
And that would be Maureen Hartnett, is that correct?
Yes.
And then as far as what, if any, items, the other item was 3-1, is that correct?
Correct.
That was the actual sort of taillight housing from.
So Maureen Hartnett, there's an actor named Josh Hartnett. Tom Cruise is also an actor. Therefore, Xenu is on it. We've got the connection to Xenu. So there you go.
The vehicle, was that correct?
Yes, that's correct.
And according to your notes, who, if anyone, provided that piece of evidence to your unit or to your lab for that comparison purpose?
I would have to double check who, I believe it was Maureen, but I'm not, I would have to double check in my.
Go ahead, you can go ahead.
Okay. Oh, okay. I'm sorry. It was Trooper Christopher Moore that had that item delivered to the lab.
Now, with reference to item 3-1, the passenger side.
Christopher Moore. Ooh. Guess it's time for a new battery in my earphones. But Christopher Moore, Moore's Law, Moore founded Intel. Therefore, big tech is in on it. Right, I know it's shocking, absolutely shocking, but yeah, I'm gonna hurry and change the battery and Okay. Hopefully this isn't the dead. Nope. This wrong battery. Wrong battery. Because I'm pretty sure one of these is a good battery. But maybe not. Maybe. Okay. Hopefully it's good. Hopefully. I thought that I put I thought I put the spare battery in the headphone case. But apparently I just put it on the desk, but I also put the old battery just on the desk. And yeah. It's jarring though when the noise canceling flickers in and out because you're like, oh God, I'm deaf. And then, no, I'm not. Yes, I am. And I don't like it. So, but problem solved, hopefully. So let's continue.
Taillight from the vehicle. What, if any, observations or things did you note in regard to your sort of initial examination of the taillight?
So I did notice that there were portions of the taillight and red that had broken irregular edges. It appeared to be that there was damage to it.
Now, with reference to your examination just of the taillight now, what, if any, instruments did you utilize in the course of your examination of the taillight?
Sure. So during my examination, I used a stereo zoom microscope, a polarized light microscope, a comparison microscope, as well as a FTIR with a microscope attachment and a microspectrophotometer, also known as a microspec.
Now, the Graham and the FTIR, I believe you've already discussed in your testimony. As far as the microspec is concerned, can you explain to the jury sort of what that instrument is and how it's used and how you used it in this examination specifically? Sure.
So a microspec is used to examine items that have color. So essentially, your sample is exposed to visible light, reacts in a certain way. Some of the light gets absorbed, some of it gets transmitted, and we get a spectrum, and it's representative of the dye or pigment in the sample.
Now, with reference to item 7-18.18, that being the debris from the victim's clothing, what, if any, observations or measurements did you take in reference to that particular item?
I assume, Paul, from when you get to this, of course, it's a drinking glass. So presuming it's Karen's vodka tonic, her DNA might be on it. Of course, they collected a straw, so she's probably sucking through the straw, but touch DNA or fingerprints or whatever, because assuming it's her glass. Of course, it being broken and mixed in the debris, presumably John also handled it, but we'll see.
Sure. So I noted that there was some clear plastic material, as well as some red plastic material. And I would have to refer to my report for exact measurements of those items.
You can go ahead and do that.
Thank you, Ron.
I don't actually know. One of my pet peeves when I was in Durham. So most indoor smoking had already been banned in England, but smoking in pubs, the ban had just gone into effect right before I arrived. But so my college bar had windows that were, the hinge was on the top, so they'd open outward. So in the rain, people would go out to smoke. They'd have their feet outside, they'd be under the window, basically smoking into our college bar. But hey, we're outside, so it's legal. And oh, it drove me nuts.
So the piece of clear plastic measured approximately 1/8 of an inch by 1/16 of an inch. And the largest piece of one of the red plastic pieces measured approximately 1/16 of an inch by less than 1/16 of an inch. And the smallest piece from that measured approximately less than 1/16 of an inch by less than 1/16 of an inch.
As far as measurements go, as far as your examination, as far as the lab is concerned, is 1/16 of an inch sort of the bottom row as far as measurements go?
Yes,
So if something is less than that, it's just sort of noted as less than 1/16 of an inch. Is that correct?
yes.
And with regard to that debris, the clear and red plastic from the debris, what, if any, examination or what, if any, instruments did you use to conduct your examination just for those pieces?
So I examined a portion of the clear plastic as well as one of the pieces of the red plastic. I examined them microscopically, and I analyzed portions instrumentally using an FTIR and a microspec.
And based on those examinations, starting with the clear plastic material that you observed, what, if any, conclusions did you come to with reference to comparison of the clear plastic material to the taillight housing?
So the clear plastic from item 7-18.18 was found to be consistent in color and instrumental properties with the examined portion of the clear plastic from the taillight. So accordingly, the clear plastic from 7-18.18 could have originated from the clear plastic from item 3-1 taillight or from another source with the same characteristics.
Now, similarly, with from your examination of the red pieces of plastic in the taillight versus the red pieces of plastic contained within the debris, what, if any, conclusion will you come from your examination of comparison of those items?
Sure. So the examined portions of the red plastic from item 7-18.18 was found to be consistent in color, microscopic appearance, instrumental properties with the examined portions of the red plastic from the taillight item 3-1. So accordingly, the red plastic from 7-18.18 could have originated from the red plastic from item 3-1, the taillight, or from another source with the same.
All right, so I speculated slightly wrong because not only is she doing the drinking glass, the broken glass, but she is actually testifying about analyzing the plastic. But it sounds like, previous witness was the puzzle master. She put the plastic together, but this witness did the scientific analysis of, yes, the plastic is the same source. So the first witness, well, yeah, the plastic fit together. And this witness, well, it came from the same source. So fits together and the same source. Hey, it's probably from the same thing.
Characteristics.
Thank you. May I have one moment, John?
Yes.
Thank you very much, ma'am. I have no further questions.
Right. Actually, Mr. Jackson, before you begin, why don't I see you look at the sidebar vote?
Is this sidebar going to be? So we don't need to hear any more about lab accreditation, do we? We know the Massachusetts State Crime Lab is accredited. Can we just skip that part on future witnesses? Get things moving? not have all this cumulative evidence, please? I don't actually know what this sidebar is about, but could be something like that. Let's see. All right, it's not super long, so we'll continue staring at Karen Reed, because I know you all love that. All the comments on how gorgeous she is and how lucky Turtle Boy is to have her. And may I just say, for the first time today, how much I dislike little Alan Jackson.
Well, the approach from actually is just to take VP for identification.
Which one?
Victor, Victor. May I inquire?
Yes.
Thank you. Good morning, Ms. Well, almost afternoon, Ms. Hamlin.
Good morning.
I'd like to show you a document just to begin our conversation this morning, if I may. May I approach?
Yes.
This has been previously identified as VV, as in Victor Victor. And I'd like to ask you, first of all, to take a look at that and tell me if you generally recognize what that document is.
Yes, it appears to be a chain of custody of
Oh, well, I was about to. I was too slow pausing because Pat's Cats distracted me. I was on my way to pausing when I highlighted Pat's Cat's comment. But I was about to say, what are the odds that this cross-examination is more nonsense about chain of custody that doesn't actually apply to this witness? And shock of all shocks, it is.
several items.
Okay, and is that a chain of custody document reflective of the crime lab's case number in this case? Sort of a clumsy question. Do you understand what my question is?
It is the chain of custody for 22-02184.
And is that the case number that the Massachusetts State Crime Lab, Massachusetts State Police Crime Lab is still assigned to this case that you're testifying about today?
Yes, that's correct.
And you've seen reports like this before, correct?
Yes,
They're routinely used in the crime lab to track evidence and maintain chain of custody, at least at the crime lab. Is that right?
that's correct.
And the information contained in the report is entered at or near the time of the event that's memorialized.
Yes,
Okay. And it's relied on generally by the crime lab as a business record, correct?
uh,
As a record of the event memorialized.
She's like, business record? We're not a business. But business records kept in the ordinary course of business is a hearsay exception. So that's why Jackson is asking. But she's like, what the hell are you talking about?
yes, it's a record of the chain of custody of items within the lab.
Okay. And my question is it relied on by the lab for truth and accuracy, as best you can maintain it, to track items of evidence within the lab?
Yes, it does track items.
And the information contained in the report is presumed by you and other supervisors at the lab to be accurate. Is that right?
Yes,
Your Honor, move for the admission of BB as an exhibit.
Objection.
See that, we'll see you at side.
Does Mr. Lally not think it's a record kept in the ordinary course of business? Interesting. Interesting. And they absolutely are painful to listen to. That just, ooh. And as I've said, defendants are entitled to a vigorous defense, are constitutionally guaranteed. You don't have to be an annoying putz to give a vigorous defense.
Unmuted.
I'm sorry, Your Honor, my request at sidebar is reserved.
Yes,
Thank you. May I inquire?
yes.
Ms. Hanley, I want to draw your attention.
It sounds like little Alan Jackson lost that objection. You heard him. Our discussion at sidebar is preserved. That means he lost. Because if he won, he wouldn't be asking that it was preserved for appeal. He wouldn't care. So that's why he's now asking her questions about it, but not publishing it for the jury.
Specifically to the glass pieces that Mr. Lally asked you about. Would you agree that there's a lot of numbers that were discussed, correct?
A lot of,
I compared 3-2 to 7-12 and sub A, B, C, and D of 712 were compared with 3-2 and 3-3. A lot of numbers, right?
yes, there are a lot of numbers, items.
It's that I'm gonna need to get a new battery, I think. But it's that gish gallop of nonsense. It's throwing out numbers for numbers' sake. And I'm going to be back momentarily. So, yeah. Amuse yourselves, but behave. And I will be back with a fresh battery so that I don't go insane. So, once Okay, I'm back. And now I'm really annoyed because I bought a large pack of AAA batteries like 2 weeks ago, and someone has hidden them. Someone hid them. They're not where they're supposed to be. So hopefully these loose batteries that were in the bin where that large new pack I just bought were supposed to be, hopefully these are good batteries and not old or, crappy or whatever. I'm annoyed. But I'm back. So, yeah. Let's hit play.
Okay, I want to try if I can, see how well it goes,
And
to clear that.
that's it. I was going to blame Pope Gregory because it's part of the conspiracy.
Up and categorize those.
Sure.
Perhaps, would you agree that we could put the items that you compared and examined in your analysis in 4 categories: 3-2, the cup or the glass; 3-3, the bumper glass; 7-12, the 9 pieces of glass recovered by a trooper named Bupnik at the scene; and 7-14, a single piece of glass recovered by a trooper named Proctor at the scene. Would you agree that those 4 categories are basically what you analyzed between and among each other?
Yes, there's 4 total items.
Okay. And within those items, there were some subcategories of items in some of those, correct?
Yes, because some of the items just had multiple pieces, so they were labeled just to keep track of the pieces.
Okay. So if I could ask you to take those one at a time, pardon me, 3-2, under that column visually, that would be a single item, just the cup, correct?
Correct.
3-3, under that single item, the bumper, there would be 5 sub-items, A, B, C, and D, and E.
Yes, that's correct.
Public school education. Under
He's learned the alphabet. How special. I mean, he managed to get beyond the Jackson 5, ABC 1, 2, 3, but only barely.
7-12, the third column, there's 9 pieces, correct? A, B, C, D, E, F as in Frank, I, K, and L are the 9 glass pieces, correct?
Correct.
They're close to being alphabetical, not quite toward the end, right?
Correct. I would have to look at my report for the exact letters, but
Sure, go ahead and look at your report.
so the 9 pieces of clear apparent glass were labeled as A, B, C, D, E, F, I, K, and L.
Okay. And then, of course, the last category would be 7-14. That's a single piece of glass that was recovered at the scene by Trooper Proctor, correct?
Correct.
All right.
Objection, Your Honor, just
So I'm
I feel called out for ADD, undiagnosed.
going to see Councilor Tybar for just a minute on this.
And once again, this is all a gish gallop of irrelevant nonsense. It's, oh, you labeled them with letters, not numbers? How suspicious. And the thing is, so there's plastic pieces, A, B, C, D, E, F, I, and J. Were G and H plastic pieces or glass, different pieces mixed in, and you just don't mention them?
You are unmuted.
Yeah, Your Honor.
Yes.
All right. So the last category we were talking about, 7-14, that was a single piece of glass, correct?
That's correct.
Okay. First of all, I'm going to ask you to take your comparisons one at a time, if I can. You compared the cup in 3-2 to the 9 pieces recovered at the scene. A, B, C, D, E, F, I, K, and L, correct?
Is that 7-12 you're talking about?
7-12. Thank you.
Sorry, can you say the letters again? I just don't know if I heard all of them.
A, B, C, D, E, F, I, K, L.
Yes, that's correct.
Of those pieces that I just mentioned, the cup was a match to A, B, C, D, F, and K, correct?
Yes, that's correct.
Pieces E and I were compared to each other, and you matched them, correct?
So I believe I'd have to look further in my notes, but I believe E and I were found to fit together by,
Problems, meaning mechanical problems.
yes, but I would have to check my notes, but I believe it was the previous analyst that looked at 7-12 that found the physical match between E and I.
But that wasn't you?
Is it okay if I look at my
Yes.
notes?
Sure, I don't want to get bogged down, but yes, please.
You do want to get bogged down, though. That's been your cross-examination strategy with all of these witnesses, getting bogged down. That's your strategy. And Kevin, I have absolutely no idea what's for dinner. None whatsoever. Lasagna sounds good. You've missed all the excitement. All the excitement. We're still on Lab Geeks, putting puzzles together. And the defense doing a gish gallop of nonsense as their cross-examination, trying to confuse the jury. But the last witness, the gray-haired analyst, Yannetti cross-examined her about the chain of custody before she had it as his big gotcha, which she didn't handle the chain of custody before it got to her, and her never seeing that would be normal. I understand, though, that, we'll hear about the actual chain of custody from the troopers, so that'll be fun. I don't want to get bogged down, but let me throw some gum in these gears.
So item 7-12 was previously examined by another analyst in the trace unit. Specifically, E and I received, when I opened this item for examination, E and I were taped together.
Conspiracy.
They were found to have a physical match by the analyst who previously examined the item.
Great. Importantly, E, I, and L, however, were not found to match the cup in 3-2, correct?
That's correct.
All right. You also compared the cup in 3-2 to the 5 items recovered on the bumper in 3-3, correct?
I'm sorry, say that again?
You also analyzed the cup in 3-2 against the 5 items, A, B, C, D, and E in 3-3, the bumper glass, correct?
I did examine, I compared item 3-2 to 2 of the pieces marked as A and B from item 3-3,
And those
which
were
was
deemed not to match the cup, correct?
correct.
And you did not analyze C and D, correct? I'm assuming that's because of size.
No comments. I'm assuming that's because of size.
So the rest of the items were not used for physical match examination due to size and condition.
So as you sit here, none of the items on the bumper were deemed to match the cup, correct?
Correct.
All right. So you did end up analyzing one of the items on the bumper, item E as an echo, and you analyze that against the single piece of glass found at the scene in 7-14, correct?
Correct.
And you used both, well, you used a variety, it sounds like, of analyses, including microscopy, UV light, the glass refractive index, GRIM process, correct?
That's correct.
You also used the FTIR, is that right? Infrared spectrometry?
That's incorrect.
Okay, you did not use FTIR in this analysis.
I did not.
Okay, but in the analysis that you did use, you found that there was a match between item E on the bumper and the single piece of glass in 7-14, correct?
They
can see he's an ass even without the assumptions.
found to be consistent. They were found to be consistent in physical and instrumental properties.
Okay, so importantly, you also compared the single piece of glass in our sort of visual column 4, 7-14, that single piece of glass to the cup. You found that it didn't match, correct?
Correct.
All right. So lastly, you tested the single piece of glass found in the 4th column, 7-14.
This is little Alan Jackson on cross.
Against the 9 pieces of glass found in 7-12, A, B, C, D, E, F, I, K, and L, correct?
Because he's a jackass and he knows how to do her job better than she does.
I did compare item 7-14 to item 3-2 and the 9 pieces in item 7-12.
So another way to put that would be you analyze column 4 against column 3 now, correct?
I examined them for a possible physical match.
And they did not match, correct?
There was no physical match to item 7.
Because that would upset me even more. That's why.
14.
Okay. You want to be a coach briefly?
Okay. Want to show Mr. Lally what you know?
Sure. I'm looking for the one that was already.
Come on, Jackson. You know the rules.
May I approach court magistrate and ask if he's got WW by chance?
No, I do.
May I borrow that from the court? Thank you. I'd like you to take a look at that document. Just glance it over for a second and let me know when you've had an opportunity to study that.
Okay.
You've taken a look at that single page document?
Yes.
Does that appear to accurately reflect in sort of a visual manner what you just testified to about your analysis of each of these pieces, irrespective of the text on the item, just the analysis of the items specified in that document.
I'm not quite sure what. I've never seen this before. I'm not quite sure what.
I think you have to move along, Mr. Jackson, for all the reasons we talked about at sidebar.
I understand.
So basically, I'm gathering this is a defense summary put together in a misleading way. And she's like, I don't know what the fuck this is. I can't testify about this. I didn't prepare it. I don't know what it is. So she can't testify about it. Judge is right. Move on.
My question is a relatively simple one. Is this a
Fuck
and
you?
if you don't understand something on the document, just say so.
Fuck you. My question is a relatively simple one. If you don't understand it, it's because you're dumb and you don't understand your job. Because my super simple question should be simple to answer. Fuck you.
Is this a visual representation, an accurate visual representation of what you just testified to in terms of what matched and what didn't match? Where the green matches, the circle with the red through it doesn't match.
I would need to go through my conclusion and compare to confirm.
Fair enough. It is accurate to say, use a cheat sheet for a second. It is accurate to say that the cup.
My question is very simple, but let me use a cheat sheet because there's nothing simple about it.
Was not found to match any items that were found on the bumper. That's correct, correct?
That is correct.
Okay. Also, it's fair to say that the piece recovered under 714, the single piece of glass recovered under 714, does not match either the cup, nor does that piece match any of the 9.
Well, I mean, there have been multiple, but once again, the judge doesn't want to discuss anything in front of the jury, so.
Pieces in 712, correct?
And you can look at your notes if that's easier for you. We just want the right answer, Mr. Jackson, right?
Of course.
So take your time with your notes if that's easier for you.
So I'm sorry, can you just repeat the last question that you asked for?
The single piece of glass under 714 neither matches the cup, nor does it match any of the 9 pieces found in 712. In other words, it stands alone.
Well, the thing is, there was glass on the bumper, and there was like the base of the drinking glass under John, or by John. So I think he's trying to make it sound like there's a second source of glass, which, you know, goes back to my question when I forgot about the drinking glass is, you know, was there a glass component inside the plastic part of the taillight housing? Was, you know, was it, was John holding Karen's crack pipe and that's the unmatched glass? I don't know, but I think that's what he's trying to get at, but we'll see. And that's the problem though, because there are in modern cars, it's not a bulb. Like they don't use incandescent or halogen anymore. It's LEDs because it's a 2021 Lexus. So I don't think LED would have glass. And it certainly not in the size we saw on the bumper. It wasn't a big piece, but you know, modern taillights are hundreds of LED cells, basically. So
So that's correct. So
Okay.
714, there was no physical match between 714 and 3-2 or any of the pieces in 7-12.
Thank you, Scott. And then my final question is, the only piece of material, glass material, that was recovered from the bumper, item E, the only thing that any piece on that bumper matched was the single piece of glass found in 714. Correct?
I've always said, Brandon, it's the normal ones that scare me because they're the Stepford wives, and you know. Ugh.
So piece E from item 3-3 was the piece that I examined microscopically and instrumentally. It was found to be consistent in physical and instrumental properties with 7-14.
And that's the only piece of material on that bumper in that section. In other words, in 3-3, that matched anything else in your analysis. The piece that was found singularly at, under 714, correct? The only one.
Yes, it was found to be consistent.
Thanks. That's all I have. Thank you, Your Honor.
Okay. Lally?
Briefly, Your Honor.
Like I said, I think she's the you know, ugly duckling to swan librarian trope. So
Ms. Hanley, within item 7-12, there were 9 pieces of glass and 5 pieces of plastic, correct?
Correct.
And as far as a comparison analysis that you're conducting is concerned, why is it, as far as the pieces of plastic are concerned?
There was a broken bulb in my bathroom a week and a half ago, and I just found another piece last night, I think, or night before. It was a broken light bulb. Conspiracy. And Brandon, there are a lot of words I'd use to describe you. Normal is no. Abby-normal, but yeah. So, all right. Be good while you're gone, Pat's Cats. We'll be waiting. I'm sure we'll still be here.
Why is that not part of the comparative analysis?
I did not examine the plastic pieces for physical match because there were no other plastic pieces for comparison for physical match. So I examined the glass pieces for possible physical match.
What are some of the differences between, from an elemental standpoint, as far as plastic versus glass?
Plastic is it's a type of polymer. A different type of analysis would be conducted if I was examining plastic versus glass. Something like a plastic, something that we refer to as anisotropic, or glass is isotropic. So they are different types of material.
I'm not the one that broke it, Kevin, but I believe it was just clumsiness changing the light bulb. So it was out of the fixture. So no need to use the potato trick.
Now, as far as characteristically speaking, from plastic and or glass, what are some of the commonalities of those items as they're found in general?
Objection.
Beyond the scope?
Yes.
Sustained.
Now, again, from the drinking glass that was recovered on scene, that was a match for 6 of the pieces of glass that were found on the roadway or on.
So that's a question he could have asked on direct. But since this is redirect and it doesn't relate to anything that was asked on cross, that's why it was beyond the scope.
On the ground at 34 Fairview Road, correct?
I believe it was 6. I just would have to confirm in my
Go ahead
report.
and you can go ahead and look at your notes.
Yes, it was 6 pieces from 7-12.
And then it was piece E from item 3-3 from the bumper of the defendant's vehicle that was found to be consistent with clear glass that was found on the ground at 34 Fairview Road, correct?
Yes, that's correct.
Nothing further.
Anything?
Nothing further, Your Honor.
All right, thank you very much, Ms. Hanley. You are all set.
Exactly. Exactly. All coming together.
Jim, remember all the Post-its? Can you give me them?
Yeah, that's good. Thank you. Your next witness, Mr. Lally?
Your Honor, may we approach?
Okay.
Is he really? Is that for the Social Security office where Delete Laws egged him on to go in out of the vestibule? And like where he actually made federal case law? Is his sentence finally being executed? Interesting. It's almost like when people kept telling frauditors, yeah, once COVID is not a concern and the jail's open, you're all fucked. So, yeah. Yeah. And yeah, no idea what this sidebar is, but this could simply be about timing. Who's the next witness? How long are they going to be? Should we take our lunch? Could be as simple as that, but we'll see. Well, I assume when he says DMA, I took that to mean Denver Metro audits. God, he's annoying. Like I've said, to me, they're prank channels. They all have little man syndrome and want to take out their aggression on underpaid government workers. And so I really don't actually follow them. It's just other people that cover them and sovereign citizens. I'll watch both. And, you know, contrary to, you know, what might actually believed, I'm thoroughly uninterested in Delete Laws. Like, he gets me views. That's it. Talking about his lawsuits. I actively avoid watching him because, oh, he's annoying. So annoying. But, yeah. So, well, I may have seen it. I might be conflating that with one of the times that both you and Paul were on with KFAR, but either way, yeah, it's been, you know, we've all seen it coming. So, uh-oh. Hopefully the jury didn't see it. Hopefully the jury didn't see it. So, and that's it, Vince. They're like, it's entertaining, but you know, of the cases I follow, I much prefer Schofield versus Guillard, the girlies, you know, anything else, but you know, DeCastro gets me the views, which is also kind of unfortunate because it's almost like right from the start I got typecast because so much of my audience only comes for that. And so I think in the like it helped my channel grow, but it stunted some of the growth because people aren't interested in the other stuff. And so you know, I try to focus my channel sort of between Law Talk with Mike and Emily Baker, sort of the more law tubey side than, you know, the reacting to sovereign citizens side. But, you know, you get what you get sometimes. And yeah, so I'm sure most people do dramatic readings better than I do, but thank you.
Yes, Your Honor, the Commonwealth calls Sergeant Yuri Buchanan to the stand.
Hey, Sergeant
Andrew, do you want
Buchanan.
that envelope, Mr. Lally? I have it.
So here we go. This is where the story should start coming together. Because as I've said, you know, my preference would have been to hear from Sergeant Buchanan from the start, or Trooper Proctor, or whoever. But you know, I'm guessing a big part of the reason they didn't is they'd get objection, facts not in evidence, and so they needed to wait until those facts came into evidence. But I would have liked someone to give us the big picture from the start. This is the start of the big picture. This is where we should start to have all the pieces of the puzzle, like rapid fire. They've been building the pieces. Now the puzzle should be put together. So, yeah. I mean, I'm not tall either, but I don't have little man syndrome, so I can laugh at DMA and DeCastro for it.
The court and jury, the case evidence, the truth, the whole truth, and nothing but the truth, so help you God. I did.
And we will get back to it, Bad Scooter. We're just distracted at the moment.
Whenever you're ready, Mr. Lally.
Good afternoon, sir.
I mean, Vince, did you see my comment in Merb's stream yesterday when I think it was Paul that commented saying someone's restreaming you, and you know, so Stoned Vat was restreaming MERB reacting to restreaming MERB reacting to Wrangler reacting to an idiot. So MERB reacting to an idiot, But I commented and said, well, I'm going to restream Stoned Vet, restreaming you, reacting to, and just do the chain.
Good afternoon.
Could you please state your name and spell your last name for the jury?
Yes, sir. My name is Yuri Buchanek, spelled Y-U-R-I-Y, last of B-U-K-H-E-N-I-K.
Okay. I'm going to slow him down just for a few minutes. I'm detecting a Russian accent with a Boston tinge. I want to see on normal speed.
And how are you employed, sir?
I'm employed by the Massachusetts State Police.
And how long have you been a trooper with the state police?
I've been a trooper since 2012.
And what?
All right. Yep. We've got the Eastern European. I'm saying Russian, but it could be Polish, Ukrainian, whatever. But he definitely has an accent, but there's also a little bit of masshole in with him. So, but don't you know, Bad Scooter? Me not saying from the beginning that Karen Reed is factually innocent makes me the worst lawyer on the planet. Because reasons.
Prior to being employed as a trooper with the state police, excuse me, what, if any, other employment or background do you have as far as law enforcement is concerned?
My law enforcement career began in 2003 when I graduated from the military police school at Fort Leonard, Missouri, while I was enlisted in the United States Marine Corps. From there, I was stationed at Quantico, Virginia, with the Marine Corps Presidential Helicopter Squadron. I provided security for the presidential helicopter and assets, attaining a top secret Yankee White clearance. I was promoted meritoriously to corporal and sergeant.
Yankee White clearance. Ooh. But security on the presidential helicopter, that's pretty cool. And my cousin is married to a Bosnian, and so I'm definitely familiar with a Bosnian accent. Utah, during the wars, Utah took a very large number of Bosnian refugees. Well, technically after the war, most of them went to Germany first and then came to Utah. But I think proportionally, we were on the high end. So, and most of them went to my high school, the school age ones, because for some reason that's of the 3 Salt Lake City high schools, they got sent to mine. So yeah, lots of Bosnians here, which I think is good. Bosnians make good food.
And had a platoon of 44 Marines. From there, I was stationed in Kent County, California, where I was a patrol supervisor on base as a military police officer. Once my enlistment ended.
I mean, I joke that I'm like 3.5 feet tall on my left side. It's I've got a bigger shoe lift than little Alan Jackson. But
I decided to come home and pursue a law enforcement career here in Massachusetts in the communities that I grew up in. I first worked for the VA hospital police, where I attained a secret clearance, which was a requirement.
A big part of it, Vince, is number one, Utah historically has been very welcoming to refugees. Oh, I think a little less so recently, but historically has been very welcoming to refugees. But also because of the Mormon Church, the Utah is more multilingual, I think, than most of the US because, for a while, 60% of the men and, less women served Mormon missions. And so our bilingual people aren't just bilingual in Spanish. My cousins speak Spanish, Armenian, Korean, so there are people here that would have served missions in Yugoslavia before the war that, are able to help them get settled. And Dante, my fellow Utahn, knows the score. The Mormon Church also is welcoming to them because they're going to love bomb them on arrival, hoping to convert them. So, yeah.
Of the employment. After that, I worked at the Attleboro Police Department in uniform patrol, as well as the SWAT team with Attleboro, Massachusetts Police Department. In 2011, I applied for the Massachusetts State Police, graduated, and worked at the Sturbridge Barracks, Millbury Barracks, and Foxborough Barracks. In 2015, I was selected to come to the Norfolk District Attorney's Office with the detective unit and worked homicide cases as a trooper. 2021, December, I was promoted and took on a supervisory role within the unit.
Now, with respect to your work within the unit of the detective unit at the Norfolk District Attorney's Office, what, if any, specialized training did you receive in regard to your work there?
I've attended numerous homicide conferences, training in various aspects of digital device analysis and investigations in major crimes, homicides, drug investigations, and so forth.
Now, were you working in that capacity with the State Police Detective Unit on January 29th, 2022?
I was.
And were you on call that day?
I was on call as a supervisor.
Now, can you explain to the jury as far as the on-call system within the detective units? Well, let me ask you this first. What, if any, duties or responsibilities do you have as a sergeant or as a supervisor with reference to on-call duty and sort of how that works?
As a supervisor on call, responsibilities include answering the detective that's on call any questions that might arise. Obviously, we don't all have the same experience, so we put our heads together, and if it's a situation or case, a scene that they have not been exposed to before, they call the supervisor for guidance, suggestion, or bounce questions off of them in order to help them navigate that case.
And who was the on-call detective on this particular date of January 29th?
January 29th, the morning hours up until 7 a.m., it was Trooper Michael Proctor.
And do you know?
And if Paul is correct and Trooper Buchanek is from Bosnia, that other experience that it could be, well, boys, this is how you deal with lots of snow. Because Bosnia, my cousin's wife, not from coastal Bosnia, she's inland. She's like, yeah, Salt Lake's winters are very little snow. We had tons. Of course, you go up in our mountains and there's tons too. But so Trooper Buchanek could be used to, dealing with 5 feet of snow.
Trooper Proctor?
I do.
And how long have you known Trooper Proctor?
Since he came into the office in 2019, I believe it was September, October 2019.
And have you supervised Trooper Proctor sort of throughout his work within the office?
I have supervised him throughout my supervisory position. So his entire time in the office, while I was a supervisor, I've supervised him directly, yes.
And as far as that on-call system or that on-call rotation is concerned, how is that determined or how does that sort of come into existence?
The on-call system is formulated, it's compiled the month prior. So for example, if it was December, beginning of December, the troopers in the office would submit their days requesting not to be on call due to trials, training, personal reasons, or vacations they had planned. Those days are submitted in the beginning of the month, and then if it's in the beginning of December, for example, the on-call schedule for January is then compiled a month in advance, really.
So these are generated well in advance of whatever specific date a trooper is on call, correct?
That's correct.
And as far as the
So basically, so you organized the schedule well before the date of the murder so that Trooper Proctor, who went to a wedding with someone who wasn't even at the scene 10 years ago, to make sure he'd be the one taking the case, right? This was all pre-planned because conspiracy.
detective unit within the North County District Attorney's Office, who, if anyone, is your supervisor?
Currently, my supervisor is Lieutenant Fanning, and the unit commander is Detective Lieutenant Brian Tully.
And that sort of pecking order, if you will, was that the way that it was set up in January of 2022 as well?
Yes, it was.
Now, on this morning of January 29th, 2022, at some point, do you get a call in the morning, and from whom do you initially get a call?
I received a call approximately 6:44 in the morning or so from the H Troop headquarters.
6:44 or so. I like how he gives the exact time or so.
Which is the field headquarters for the Metro Boston area, which also covers our county. And they advised me that there was a body in the snowbank in Canton. I asked for further details and then advised them that I was not on call, but I would call the on-call trooper and let them know that there was a call out requesting their assistance. So that's what I did. I called Trooper Proctor and advised them to contact Canton Police.
And following that initial contact that you had from the H Troop and then your call to Trooper Proctor, what happened then?
Trooper Proctor began making phone calls, gathering information.
Sustained. Next question.
I mean, I do like being absurd sometimes myself, so, you know.
What was the next thing that happened as far as your involvement was concerned?
I was
Here, we'll slow it down again to normal speed, and you'll hear it.
advised of the circumstances under which the body was located and what was transpiring. And I told Trooper Proctor that I would start shoveling out during the blizzard and then proceed to meet him in Canton to begin our investigation.
So, look, to me, I'm hearing Eastern European and masshole. It's definitely a combination to me, but I'm hearing it.
And where was it that you and Trooper Proctor first met up on that particular morning?
We met at the Canton Police Department.
And do you recall approximately what time it was that you arrived at the Canton Police Department?
It was approximately 9:15. Due to the amount of snow that was on the ground, the time that it took me to shovel out the main roads, actually no roads were plowed at the time during my track. So I decided to drive my personal truck to Canton Police Department because it was a 4-wheel drive and meet Trooper Proctor there.
Now, as far as your personal truck versus you have a work vehicle as well?
That's correct.
And you mentioned that the truck is 4-wheel drive. What is the difference between your personal truck and its capabilities in weather versus the work vehicle?
Well, at the time, there was approximately 10, 15 inches of snow that had accumulated already. My work vehicle is a sedan, low to the ground, low clearance, front wheel drive. It would not be able to navigate the road conditions at the time. My 4-wheel drive vehicle is higher clearance from the roadway and was able to navigate the conditions at the time.
And sir, when you arrived, so at approximately 8:22 in the morning or so, where is it that you were at that point in time, if you know?
At 8:22, I would say I was still blowing the snow out of my driveway, clearing the path for my truck to leave the driveway.
And when you arrive at the camp,
Okay. Vince, I would like, what would a mid-Pacific accent be? Because so the mid-Atlantic accent, for those of you who don't know, is sort of the upper crust American that, you know, think New England private school, boarding school, trying to sound English. So think Kelsey Grammer, Alan Alda, the sort of Katharine Hepburn is an absolute, you know, iconic mid-Atlantic accent. So what would the mid-Pacific be? What would it be like upper crust surfer bro? The wave was gnarly, old chum. Like, what would mid-Pacific be? Because I think we need to invent that, because it would be hilarious. I think it would be hilarious.
Police station, you mentioned that you met Trooper Proctor there. Do you recall who arrived first?
Trooper Proctor was in the parking lot in his vehicle, and I pulled in, backed in next to his, and we walked in together into the police department, I believe.
And when you walked into the Canton Police Station on that morning, sometime after 9 a.m., where is it that you went? Who, if anyone, did you talk to when you first got there?
We walked into the police department, were guided to the detective department division of the PD, and we met with the detectives from Canton and Sergeant Good, who was the uniform patrol sergeant, and having been the first responder to the scene as well.
Now, without reference to anything that was communicated between the two of you, at some point prior to getting to the Canton Police Station, did you have conversations with Trooper Proctor?
Yes, I did.
And did Trooper Proctor make you aware of conversations that he had with other people prior to getting to the Canton Police Station?
Objection.
Well, I'll allow that. That's a yes or no.
So, did he make you aware of conversations that were had? Yes. What were those conversations? What was said in them? Hearsay. So,
yes.
And so you get to the Canton Police Station, you and Trooper Proctor then proceed to talk to Sergeant Good, is that correct?
That's correct.
And again, without any reference to what was said to you by Sergeant Good, he relayed some information to you as well.
That's correct.
No, I'll allow that.
That's correct.
And if you know about how long was the period of the conversation that you had with Sergeant Good at the Canton Police Station?
The conversation with Sergeant Good was probably 25 to 30 minutes. He walked us through his...
Next question, please, Mr. Riley. I'm going to stop you from answering that, Sergeant.
Yes, Ron.
So Sergeant Koenig, reference...
Because he walked us through would be the contents of the conversation, hearsay.
To, at some point, did you learn the name of the body or the person that was found on the lawn on Fairview Road?
Yes, I did.
Who did you learn him to be?
Mr. John O'Keefe.
And in reference to where Mr. O'Keefe's body was at that point, what, if any, information did you receive about that?
Objection.
I'll allow that.
We learned that Mr. O'Keefe's body was transported to the hospital, Good Samaritan Hospital in Brockton.
And in reference to the Good Samaritan Hospital in Brockton, who, if anyone else, were you told had been taken to that facility as well in relation to your response that morning?
Objection.
I'll allow that.
The defendant.
And just to be clear, at some points over the course of your investigation, have you had interactions with Karen Reed?
Yes, I have.
And to be clear, when we say, as far as Karen Reed, the defendant, you see her in the courtron today?
Yes, I do.
Can you identify just as to where she's seated or an article of clothing that she's wearing?
She's seated between her legal defense team wearing the white blouse.
Your Honor, does the record reflect identification of the defendant?
Yes.
So upon having that conversation with Sergeant Good at the Canton Police Station, where is it that you and Trooper Proctor went next?
From the Canton Police Department, we proceeded to the McCabe residence.
And that was over on Country Lane, is that correct?
That's correct, number 12, Country Lane.
And when you arrived there, as far as transportation to that, is it you and Trooper Proctor in the same vehicle?
Yes, I made the decision to drive us. That way we only take one vehicle. In addition to Trooper Proctor being able to make phone calls and facilitate other logistics as necessary, allowed him that freedom to do so while I operated the vehicle in the dangerous snow conditions.
And the snow conditions that you were talking about as far as clearing out the driveway, the drive to the Canton Police Station, did those conditions persist throughout the day of the 29th?
Yes, they did.
And so you make your way over to the McCabe residence, again, without anything that was said. Who, if anyone, did you speak with at the McCabe residence that morning?
We first spoke with Miss Jennifer McCabe. We then spoke with Mr. Matt McCabe, and then we spoke with Mr. Brian Albert.
And with reference to each of those conversations, were they done collectively or separately, or how were those interviews conducted?
Each interview was conducted separately. We first interviewed Miss Jennifer McCabe with request of Mr. McCabe to give us privacy. He proceeded upstairs. Once we were done with that interview, Mr. McCabe came downstairs, and Miss McCabe gave us the same courtesy. And once that interview was over, Mr. Brian Albert had arrived, and we interviewed him briefly.
Is that sort of the typical process of how at least your unit conducts interviews with respect to civilians?
Yes, with cooperating civilians, we typically advise them we schedule an interview. We proceed to their location of convenience and separate them and get their version of recollection of events that we are inquiring about.
Now, after you spoke with those three individuals, yourself and Trooper,
What are the bets that the defense cooperating witnesses? Oh, how are they cooperating? Conspiracy.
Proctor at the McCabe residence, where is it that you and Trooper Proctor went next?
We proceeded to the Good Samaritan Hospital in Brockton.
And where within the Good Samaritan Hospital did you go?
We went to the emergency department.
And within the emergency department, were you led to a specific room?
Yes, we were.
And what, if anything, did you observe when you were in that room?
Once in the room, we observed Mr. O'Keefe's body on the medical bed or gurney, and his clothing, which had been cut off of him, were on the floor at the foot of the bed, a couple of feet away at the foot of the bed.
Now, first, with regard to the clothing, what, if anything, did you do with regard to that?
After viewing Mr. O'Keefe's body, we proceeded to identify the clothing items and bag them into evidence bags, notating which item and the brief description about each item of clothing.
So let me ask you just a little bit about that as far as that process is concerned. So when an item of evidence is collected by you or by your units during the course of an investigation, is there sort of a policy or protocol, or how are things, what do you do with things when you collect them and take them into custody and evidence?
If we deem an item to be of evidentiary value, we identify the item, we take a brief description of it, and we label the evidence bag with that description. We notate who's taking the item into custody, typically who located the item, the time that it's located, and the location from which it was seized or taken or collected.
And with regard to items of clothing, is that something that would be placed in just one big bag of clothes, or like how would those be packaged in evidence bag?
Mr. O'Keefe's clothing, which was already in one big pile on the floor, we packaged all.
Okay, jurors, feel free to stand up and stretch.
What's wrong with packaging John O'Keefe's clothing off of a pile on the floor? It's not hearsay. It's relevant. I don't see how it could be more prejudicial than probative. It's hard on Mrs. O'Keefe. I mean, is this, there's no chain of custody. It was just dumped off the ambulance onto the hospital floor. We don't know that those were John O'Keefe's clothes. I just, there's not really an objection there. At least not one that I see. Of course, as I've said from the start, I have not seen the pretrial motions and rulings, so there might be some evidentiary ruling that they're brushing up against here. So, but yeah, I absolutely feel bad for the family. It's terrible. And made even worse by the ghouls that make it a sideshow.
And so I'm sorry, Sergeant Mechanic, when you come into the hospital room where Mr. O'Keefe's body was, there's clothing items that are on the floor, is that correct?
That's correct.
Okay, that's what the objection was. It was Mr. O'Keefe's clothing. It's objection. No one's identified them as Mr. O'Keefe's clothing. How dare you? So it was assumes facts, not in evidence. It was okay. Just needs that extra step.
And do you recall how those clothing items were in relation to each other, in relation to the floor?
They were positioned on the floor in a pile stacked on top of each other, and they were in a condition of being soaking wet.
And with respect to those clothing items, do you recall what those clothing items were individually?
Yes, sir.
And what were they?
They were a plaid pair of boxer underwear. It was a orange colored design print t-shirt. It was a blue pair of Lucky Brand jeans, a belt, two-tone gray, light, thin hooded sweatshirt, and a right sneaker, black in color with white design and a Nike brand.
And how many sneakers were there contained within that property?
One right sneaker.
Did he mention the jeans
And what
and
any
belt?
observations did you make of the condition beyond them being soaking wet?
I also recognized, due to the aroma and visual observations, traces of vomit on the clothing.
And with regard to those items that you observed on the floor, what, if anything, did you and or Trooper Proctor do with reference to those clothing items?
Objection.
I'll allow that.
Once we went through the clothing, we collected each item and
What did you do? There's no objection there. What did you do? What next? That's unless it's objection for vagueness. But what did you do next? That's
and put it into a large evidence bag. We double bagged it due to the wetness of the clothing, so it would not seep through. We also identified the fact that there was only one sneaker. So I requested that Trooper Proctor contact the paramedics that transported Mr. O'Keefe from 34 Fairview to the hospital and have them once again check their ambulance to see if there was another sneaker inadvertently left behind in the ambulance vehicle.
Now, prior to sort of physically touching this or any other piece of evidence, what, if any, other sort of precautions do you take prior to handling, tactile handling any piece of evidence?
Anytime we handle evidence, which obviously we take great caution not to destroy, alter, or discard any evidence, we also put on gloves in order to help preserve that item.
And in reference to these items or items of anything of evidentiary value that you seize as evidence, once you take it and secure it into an evidence bag, what happens to it from there?
Once it's secure in the evidence bag, it is
hey, we're getting the chain of custody. Wow.
sealed and logged into our evidence storage facility at the office. And then as necessary, it is signed out, shipped off for processing, review, or court proceedings.
And as far as that sealing is concerned, how are bags or boxes of items of evidentiary value, how are they sealed?
Once the bag is,
I'll allow it. I'll
What?
allow it.
thank you. Once the
How
bag
are
is
they
sealed,
sealed?
it's utilized, we utilize tape, typically red or yellow tape. Once it's secured, we initial and date the tape on the edge. And that procedure helps identify the time and date.
Is this objection, Your Honor? He's stealing our thunder for Cross. We wanted to, question him about the chain of custody to make it sound suspicious. He's doing our Cross. Objection.
It was sealed, and by who? With the initials.
And then once that bag or box is sealed, if that bag or box is subsequently opened at a later time, what if any notation or what if any recordation of that is made?
Anytime a piece of evidence is signed out for review, it's logged in the tracking system. In addition, anytime a piece of evidence is open, with a container being a bag or a box is open and the tape is cut, it is then resealed, reinitialed, and dated by the trooper or an individual who's signing that evidence out and then returning it.
As far as
Greta.
the evidence bag or box is concerned, when it's been opened, is that something that is noticeable based on the sealing and resealing of that particular receptacle?
Yes, sir. It is definitely noticeable, and it's noted in the systems.
Now, with regard to, you mentioned or made some mention earlier in the testimony in regard to evidence storage facilities at your office.
Yes.
Can you describe what those are and who, if anyone, has access to those evidence storage units?
Within our office, we have 2 troopers that are designated as evidence officers. Those individuals have access to the secure rooms designated strictly for evidence storage. Those rooms are inventoried and kept under not just lock and key, but also digital access control and alarm systems. They are the only ones that have access to those facilities, in addition to our unit commander. But I'll tell you that our unit commander does not access that room without the evidence officers. I myself, even as a supervisor, do not have access to that room.
You don't have access to that evidence room, is that correct?
That's correct.
Trooper Proctor, is he one of those evidence officers? Does he have access to that room?
He does not.
As far as at the time in January of 2022, who are the troopers within your office who did have access to that?
In January 2022, that would be Trooper Jeff Kakowski and Trooper David DeChico.
And that would be in addition to Lieutenant Tully, is that correct?
Detective Lieutenant Tully, I believe.
There you go, Vince. There's an Italian, and on the conspiracy, David DeChico
has access to it, but I cannot speak to that. I just believe that he does as a unit commander to facilitate any next assignment.
Now, with reference to any items that you were physically present for that were taken into custody or taken into evidence, including that clothing from the hospital on January 29th and any other items throughout the course of this investigation, when they were taped and sealed, what happened with each of those items once they were taken back to your office?
Objection.
I'll allow it.
Each item that was sealed, it was processed in, it was logged in, and then it was stored. After processing, it was stored in the evidence room.
Now, returning back to the Good Samaritan Hospital, within that hospital room, you mentioned that you secured items and that you made observations of Mr. O'Keefe. Is that correct?
That's correct.
And can you describe for the jury, as far as Mr. O'Keefe's body, what were those observations that you made?
Mr. O'Keefe's body was laying on his back. The observations I made were of bruising to the eyelids of his face. Based on my experience and having cases with head trauma, I can tell you that during subdural hematoma,
Yeah, I'll sustain the objection. You can build a foundation if you can, Mr. Lally.
He's not a medical
Over
expert.
the course of your work with this unit,
He's not a medical expert, so he can't say, well, John had a subdural hematoma. Now, were you ever informed? You know, were you told there was a subdural hematoma? But, yeah. But all the objections before that had been nonsense because, as Ann said, it's just Jackson trying to break the stride, slow the flow, throw him off, make him forget the question.
in particular, if you know about how many homicide or let me step into it this way. As far as your work within this unit, as far as it's concerned, what, if any, jurisdiction does the State Police Detective Unit of the District Attorney's Office?
But the way he was answering, Vince, was, from my experience, it looked like a subdural hematoma, and it shared the same look as cases I've worked on that have had subdural hematomas, or however he worded it. So that was objection speculation. Now, if he can build a foundation, either that he's an expert in subdural hematomas, or the foundation that, yes, the medical professionals diagnosed he died of a subdural hematoma, then it comes in. But the way he was answering, that was speculation.
Have with reference to not only homicide, but death investigations within Norfolk County?
By statute, Chapter 38, Section 4, each county, the district attorney's office is provided jurisdiction over all death investigations. As a result, the law enforcement entities that are assigned to that Norfolk or that district attorney perform the investigations. In Norfolk County, those individuals are members of the Massachusetts State Police assigned to the State Police Detective Unit within our office.
And so as far as death investigations, what exactly or what type of investigations would that encompass?
Death investigations that we have jurisdiction over are all unattended deaths. Unattended death means that a physician, a doctor, is not overseeing the individual that passes. Those deaths would be suicides, homicides, overdose type deaths, natural deaths, accidental deaths, and so forth. Any type of death that is not overseen by a doctor at a medical facility or in a hospice type situation.
So as a result of your assignment to this unit and that sort of exclusivity of jurisdiction over unattended deaths within Norfolk County, if you know approximately how many death investigations have you been a part of over the course of your work with the State Police Detective?
4.
Over the last 9 years, I would venture to say it's over 500 death investigations that I was a part of.
I was close.
And Sergeant, over the course of your involvement within those investigations, if you know how many of those investigations involved some indication or some type of head trauma?
Scores of investigations that involve some sort of head trauma.
Scores.
And through the course of your investigations, in those
That's interesting. Not dozens, not hundreds, not, scores. All right, Abe Lincoln.
cases that have involved scores of head trauma, have you been privy to information as far as medical findings, autopsy reports, things of that nature in relation to those prior investigations?
Yes, sir, I have been.
Now, with regard to your observations of Mr. O'Keefe, with regard to his items, what if any observations did you make, and what if any, just with physical observations, what if any physical observations did you make of Mr. O'Keefe's
Exactly.
face and body in general?
On a scale of 1 to 10 billion, it was the difference was just a rounding error, not even a rounding error. Close is just a matter of scale. But Lolly is really trying to build a foundation for him to say, hey, from my past observations, I observed John O'Keefe's injuries appeared to look similar to me to the subdural hematoma investigations I have done in the past. So
his face, I observed the swelling and the discoloration being produced through the blood pooling in the eyelids.
Yep, so just your observation, so the swelling and discoloration. I'll strike the remainder of what you've said.
I also observed a cut to his nostril and an eyelid, which was very small in size, which would have been produced by a...
Objection.
Yeah, so we'll leave it at that. Next question, Mr. Lally.
can't testify how it was produced.
Based on your training experience, what if any conclusions or what if any opinions that you have in regard to the swelling around the eyes?
Objection.
Yeah, I'll see you at sidebar here.
Because speculation calls for speculation. He's not an expert witness. Expert witnesses can speculate. Well, they can give their opinion, is how I should say it. They can't speculate. They can give their opinion based on their expert observations.
Yes.
So Sergeant Mechanic, with reference to your prior death investigations, have you had occasion to make observations of bodies that there was a later determination of some sort of subdural hemorrhage?
Objection.
I'll allow that. Have you made those observations? Have you been part of those investigations?
Yes, Your Honor. Yes.
And what you observed in regard to Mr. O'Keefe, was that consistent or inconsistent with what you had observed on those prior investigations?
Objection.
That I'll allow.
It was consistent.
Now, in
So-
addition to the injuries.
So you'll notice it wasn't, so Mr. O'Keefe had a subdural hematoma, correct? Objection. He can't diagnose a subdural hematoma. But the question was worded very specifically. Based on your past observations, this had similar characteristics to those cases you have observed in the past. So it's not, so this was a subdural hematoma. It was, so this was consistent with what you've observed in the past. It's a very small distinction, but it's there. It's there. And Lolly shouldn't have needed a sidebar. He should have known how to get this out. But Jackson was going to demand a sidebar one way or another because he was going to object one way or another. And without speaking objections, you have to go. You have to have the sidebar. So, yeah.
That you observed to Mr. O'Keefe's face. What, if
Okay,
any, injuries
yeah.
did you observe to?
Why the fuck is she laughing at this? Like, so we discussed earlier. I don't expect her to be, oh, boo-hoo, poor Johnny, this whole trial. I don't. Sitting stone-faced, though, maybe doesn't help. But laughing in front of the jury, yucking it up with Yannetti as they're talking about your dead boyfriend's injuries, not a good look. This is where you sit stone-faced. Yeah, knock, knock. Who's there? Subdural hematoma. Subdural hematoma 2. Subdural hematoma 2. Subdural hematoma, John O'Keefe. Ha 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 ha. I realize that was very poor taste and not funny at all. But why is she laughing? Why is Yannetti making her laugh? Not a good look.
To his extremities.
His extremities produced abrasions to his upper forearm and lower bicep area on his right arm.
And just as you use that term, I'm not asking for any sort of medical definition, but as far as you use that term abrasions, what do you understand that term?
It was the absurdity of it. Like, that's the only way it was funny, was the absurdity of it.
I understand that term to be a injury sustained through blunt force trauma or friction to the epidermis of the skin, where a crushing of the vascular system occurs and produces that type of sign on the skin.
And from your observation of the injuries to Mr. O'Keefe's arm, which arm was this again?
It was his right arm.
And as far as your observation of those injuries to his right arm, what, if any, as far as the consistency of those injuries, what, if anything, did you note or observe in reference to those?
Consistency with what? With the,
Let me rephrase this.
Yeah.
How were the abrasions that you're describing positioned in relation to each other?
Each abrasion appeared to me to be.
Oh, poor little mommy couldn't be in the courtroom and listen about her beloved son's injuries that killed him. Oh, that's funny. Could be that, Paul. It could be that. That poor little Mrs. Snowflake couldn't handle
Be
it.
linear and concentrated in a specific location on the arm. It didn't go any further north of a point and did not go any further south of a point. So it was concentrated in the elbow few inches below the elbow, few inches above the elbow on the right arm.
Now, while you were at the Good Samaritan Hospital, did you endeavor to speak with Ms. Reed?
We did attempt to, yes.
And was she present at the hospital at that time?
No, she was not.
And at some point subsequent to that,
Okay, he's got to be careful here because he can't comment on her invoking her Fifth Amendment. Now, her trying to resist subpoenas for her phone, resist warrants for her phone, that's another matter. But can't comment on her pleading the Fifth. So, did you make attempts to speak with her at the hospital? You're on thin ice.
did you receive, or what, if any, information did you receive as to her whereabouts?
We were made aware that she was located at 345 Country Hill Drive in Dayton at her parents' home.
And where did you go from the Good Samaritan Hospital once you left from there?
We proceeded to that location.
Now, sir, with reference to the items of clothing that you recovered from the Good Samaritan and Mr. O'Keefe, do you have those items of clothing with you here today in court?
Yes, I do.
Your Honor, with the court's permission, I would ask as a witness.
All right. So thus far, we've had photos. Now we get the clothing, because the clothing itself, it's an exhibit or multiple exhibits. So, and CJ5, good to see you. So, yeah, he is the witness that would produce the clothing because he's the one that collected it. So the lab nerds that analyzed the clothing, took pictures of the clothing, that's what they could produce in court. But this is the witness that collected it, so it's his physical evidence to present. And no, what I was commenting about Karen Reed resisting or attempting to resist the search warrant for her phone. So for all the nonsense that the defense gave the other witnesses, oh, so you only gave part of your phone? You didn't hold on to your old phone? You did Oh, so they didn't seize your phone? Well, they didn't have probable cause to seize their phone. They didn't have search warrants for their phone. They did, my understanding, have a search warrant for her phone, for Karen's phone, the suspect's phone. But for all the nonsense from the defense, so you didn't want them looking at your phone? Neither did she. So, and that's it. From the hospital, he went to Karen's house, Karen's parents' house, because by this point, she's already been released from the hospital, gone to the O'Keefe's house, potentially tampered with evidence at the O'Keefe house by deleting videos and taking stuff, left the O'Keefe house, taking her Lexus, and gone to her parents' house. Because this is in the afternoon, because, Trooper Buchanan wasn't activated until the afternoon. So that's where we are.
Be allowed to retrieve those items and display those items?
Okay, are they in the courtroom?
I believe so, yes.
Okay, yes,
May I approach?
yes.
Yep. First day of trial or nothing. First day of the investigation or nothing. Well, they were spoiled brats, don't you know?
How many items are we?
Oh, are those gloves part of an exhibit? Conspiracy
talking about?
Fully run.
Okay. Jurors, if we go a little past 1, my intention would be to still just take a
Hey.
half-hour lunch today and come back. So I'd rather just go through this if we could.
They've got to get all those Zoomers, interested in the trial. And now today, we're going to have an unboxing.
Sergeant, presenting you with this item, do you recognize that?
Yes, I do.
And what do you recognize that to be?
The sweatshirt from the hospital room where Mr. O'Keefe was
That's
located.
not a sweatshirt. That's a
And,
bag.
Your Honor, call Mulder to introduce and admit that as the next exhibit.
Okay, any objection, Mr. Jackson?
Sort of need to see what's in the bag before I can object, but I'm
So-
hold up.
All right, so you've received photos of all of this, right?
I assume what's in the bag is what's been photographed, but until I see it, I won't know.
All right, so let's go ahead and open it.
With the board's permission.
Yes.
Mukbang just sounds so dirty to me. The thing is, though, it's extremely relevant. So, if she has concern for the jury, it has to be for the welfare, the well-being of the jury, not for, it being prejudicial to the jury. So, yeah. Yeah. Yep, that's the sweatshirt.
No objection.
So Lally, why don't you come take the bag? Yes,
Put it back in the bag.
it's in the bag, and we'll put that back in the bag.
Yeah, I'm sure the Shabusiness jury saw much worse. And the guy, like last name guy, that boiled his mom's head, that would have been a lot worse.
437.
Okay.
And even there, it's depending on which evidence rule, it has to be considerably more prejudicial than probative. Some it's, a balanced scale. If it's more prejudicial, it's out. But most things, it's considerably more, substantially more. So.
Madam Pro Tem.
Yes.
I need you another item, sir. Do you recognize that item?
Yes, I do.
And what do you recognize that to be?
It says it's a one orange.
It's evidence because it's what John was wearing. So the jury gets to see it. Otherwise, it's not evidence.
T-shirt.
And Your Honor, with court's permission, if the witness could remove that item and display for the jury as well.
Yes.
Ugh. Headphone warning. Okay, we never saw the back of the t-shirt.
No objection.
Most likely.
Was it 438?
It's an exhibit, so it'll at least be available to them.
Your Honor, may I approach?
Yes.
Another item, sir. Do you recognize that?
Yes, it's the right sneaker recovered from
And by CGI, I assume you mean the creaky blinder. CGI.
the hospital room.
Your Honor, with court's permission, if the witness could remove that item from the
Yes.
bag.
I saw that there were interviews, but I haven't watched any of them. So
Okay.
and what did they need to approach about here? Unless it's for the jury instruction that Anne has alluded to. Oh, that was a sneer. That was a look of contempt. Come on, yeah, Paul's not a happy camper. I was going to make a joke about the Seinfeld, if the bra doesn't fit, you must acquit. But Paul, well, all of them. All of them. I don't know who's behind him, but she looks like she's struggling. Aaron doesn't look happy. And that's what I've said from the start. The evidence will show whether I think she's guilty or not, but just based on her actions around the case, I don't like her. But that makes me incredibly biased and terrible, world's worst attorney. And yeah. Maybe they should have gone to lunch. Looks like it's almost over though, but
Continue, Sergeant.
You are unmuted.
I know. Shocking.
All right, Mr. Lally.
Yes, thank you, sir. If you could return that to the back, please.
That's a mighty clean shoe.
Yes, I'm going to, thank you.
May I approach one at a time? My apologies.
Of course, that's the right shoe, so it was only out in the snow for 5 hours, not days. So, Vince, settle down.
You know, I guess I should have said no objection.
Exactly.
What we discussed.
I understand.
Exactly.
Your Honor, may I approach the witness again?
Yes.
What's wrong with New Balance? Of course, I used to wear Nikes in high school, but they all had high arches that drove me nuts. So New Balance is comfortable. Of course, you know, that's only a half a problem now, but shoes in general are a problem on that side too, because it's really hard getting a dress shoe that works, because the heel makes it so my knee buckles and it just doesn't work.
You recognize that?
Yes, it's a bag containing a
blue jeans, black.
So, Paul, Zappos, I think, does sell single shoes for most. The the Nike, but once again, I find Nike's uncomfortable, will send one free single shoe a year, I believe. But you know, like I said, other than dress shoes, I get both anyway because I wear both. Not all the time, but I do.
Belt and plaid boxer shorts.
And, Your Honor, with the court's permission, may the witness remove just the jeans and the belt from the back?
Yes.
I'm sure the Turtle Boy crowd made snide remarks about the condition of the boxers.
Thank you, sir.
And
You can return that to the back, sir.
very likely,
Your Honor, call him up.
and like I said, I'm sure the Turtle crowd made snide remarks about it.
The next exhibit.
Okay.
No objection, Your Honor.
Thank you.
Me too, but I have limits.
So are you not displaying the third item, but it's going into evidence? Or is it just the jeans and the belt going into evidence?
Jeans and the belt into evidence, Your Honor, with the court's permission.
So we can mark the bag and we'll remove the third item during a break. Thank you. All right, so Sergeant, you'll be with us this afternoon. Why don't we take our lunch and recess? It's only going to be about half an hour.
Thank you, Your Honor.
All right, so folks, we'll see you back here, let's say no later than 1:40, okay?
Court, all rise for the jury.
As in, I'm snide, but I know where the line is and I don't cross it
You are muted.
usually. Yep. Smile, smile, smile. Hopefully the jury sees as they're walking out. It doesn't look good.
Hey there, Karen Reed, trial.
It's Jesse Weber. But yeah, like I've said, I don't expect her to sit there crying and, you know, oh, poor John, won't someone, you know, think of John? But this is gross. I don't like it. I don't like it. But that's me. And most of you, I realize, but ugh. So let's zoom through lunch because I want to finish sometime this week. I mean, for Jackson, this is like his Super Bowl. You'd think, well, for most attorneys it would be. You know, he's had higher profile clients and, you know, prosecuted higher profile people, but none of those were televised because I'm pretty sure when he represented Weinstein and Spacey, neither of those was televised or streamed. So, like, he does have higher profile cases, but this is the most visibly high profile, and but even still, I think you should at least have tact when you're in the courtroom. But that's, once again, that's me. And I realize I fast forwarded to almost the spot, but didn't hit play. So we'll do that.
Thank you. Maybe see the quarterback session.
All right. All right, Mr. Lally.
Yeah, may we approach this briefly?
Okay.
Of course. Of course. Not a good look, scratching your cheek with your middle finger aimed at the jury. Not a good look. Not a good look. Assuming the jury's already out there, but since she said, all right, Lolly, you know. But if the jury saw that, they can interpret that as she just flipped us off, that bitch. And it was also the Nicholas Cruz attorney move, but Mrs. O'Keefe looks like lunch helped, but only a little. And I don't know. Well, I guess she's able to laugh a little too, but the person behind her, the girl in black, also looks like she's having a hard time. Who would have thought? Who would have thought? Well, it looked like she did laugh momentarily right before the camera left her, but you know, it happens. It happens. It just shows her emotions are genuine. You know, she's crying, but someone next to her tells a joke. You're still going to laugh through the tears. So, yeah. But, and that's it. It could have been, but it looked like she cracked a momentary smile. So I think the beardy guy next to her said something to make her laugh. I mean, it could have been something as simple as, you know, hey, think what Johnny would say right now. You know, something like that. And yeah. Yeah. But and yeah, that pause. She's got the furious eyes for someone behind her. Probably not daddy. It's probably the blogger sitting next to mom. And it could be that she was too drunk. She doesn't remember it. All right. Jennifer, I hope work treated you well.
Okay,
Good
you
to
can
see
go
you.
ahead, Mr. Lally.
Yes, thank you, Your Honor. Sergeant McCann, those items, as far as the clothing items that you displayed for the jury just prior to the recess, those were the same clothing items that you recovered from the hospital room of the Good Samaritan on January 29th, is that correct?
Yes, sir.
Now,
If you weren't able to listen along at work, I realize not being able to participate in chat, but if this is the first you arrived today, Jennifer, this is Trooper Buchanan, Sergeant Trooper Buchanan, and he is still on direct. He just unboxed Johnny's clothes, so that's where we are. And we just got back from lunch break.
you had mentioned earlier in your testimony that those items had been placed into one bag initially. What, if anything, happened with those items as far as their keeping or their bagging once you got back to the office or to your where the evidence room?
Due to the condition of those items after they arrived at the office, the items were laid out on butcher's paper that we utilized for evidence
Butcher's paper
viewing and allowed to dry naturally because they were soaking wet.
And as
I think he would have been even a little young for that, but yeah.
As far as when they were done with that sort of drying process, how were they packaged from there?
They were packaged in the bags, sealed up, and stored for transport and processing.
And so those would be bags individual for each clothing item, is that correct?
Each item the way that it was packaged, the pants with the belt and boxers, and then so on and so forth with the sweatshirt and sneakers.
And we'll get to this a little bit more in a moment, but at some point there were pieces of plastic, red and clear plastic, that were recovered by you and other troopers from Fairview Road, is that correct?
That's correct.
At any point in time, were pieces of clear and red plastic that were recovered from 34 Fairview Road ever placed inside the same evidence bag as any piece of clothing that you recovered?
No, absolutely not.
Now, with reference to the hospital of Good Samaritan, in addition to yourself and Trooper Proctor, were there other members of the state police or other units of the state police that arrived at the hospital at some point?
Yes, sir. Lieutenant Mello came to the hospital to document the victim and the clothing, and he's assigned to the state police crime scene services section.
Now, as far as the crime scene services section, or CSSS, what, if any, role do they have with relation to your investigation in this case, or your investigations in general as far as documentation is concerned?
Crime scene services section assists us in documenting scenes through video and photographs. They also assist in collecting latent prints, fingerprints. They assist in collecting impressions, like foot impressions.
So basically, CSI.
In mud or soil. And those types of missions.
Now, there are a number of different troopers that are assigned to that particular unit, is that correct?
That's correct.
And as far as over the course of this investigation, how many occasions approximately were there that a member of the crime scene services section responded to memorialize or photograph different scenes or different areas throughout the course of your investigation in this case?
Just off the top of my head, there would be 4, 5, maybe 6 instances where a trooper or sergeant from crime scene services responded to the scene to assist us in this investigation.
Now, at any point in time over the course of the investigation,
Yeah, I hear 10 years ago, and I think like 1998.
when crime scene services troopers responded to document anything, was it ever the same trooper more than once?
No, it was not.
And so with regard to January 29th back at the Good Samaritan Hospital, there were Sergeant Mello arrived to document a photograph of Mr. O'Keefe, correct?
That's correct.
And Your Honor, may I approach the witness?
Yes.
I think he's getting there, Ann.
Mr. Lally, do you want me to give my instruction now or in a few minutes?
Just about 30 seconds.
Okay.
Yeah, I was told I'd have a flying car by now, Vince. I want to speak to the manager. Where's my flying car? Hell, where's my hoverboard? Let's start there.
So Sergeant Mechanic displays 3 photographs before you. Do you recognize what's depicted in those 3 photographs?
I do.
And what do you recognize those to be?
That is Mr. John O'Keefe.
And what's contained within those photographs is that a fair and accurate portrayal of what you saw of Mr. O'Keefe's body at the Good Samaritan Hospital on January 29th.
Yes, it is.
Your Honor, may I approach again?
Yes.
So, obvious trigger warning. If you don't want to see John O'Keefe's body, maybe just listen for the next little bit. Maybe.
Your Honor, the Commonwealth seeks to introduce an amendment.
All right, so there's no objection, right? All right, so folks, the Commonwealth is introducing into evidence through this witness certain photographs that are not pleasant and may be considered graphic photos. Sometimes evidence is presented that creates an emotional reaction in jurors. For example, it's natural and understandable to feel sympathy and empathy when you hear about a person who was injured in some serious way or suffered in some way or who has passed away. But as jurors, you've taken an oath to follow the law, and
I'm waiting for Elon Musk to go to Mars and take his Musk heads with him.
I instruct you that you must separate any emotional reaction on your part from the informational value and weight of the evidence. You must not be influenced in any way by the nature of some of the testimony, and you must find the facts in this case based only on the evidence. You can't find facts or base your decision on sympathy, anger, passion, or prejudice or pity for or against either side in this case. Rather, your verdict must be based solely on the evidence and my instructions on the law. All right, with that, Mr. Lally, those photos will be in evidence.
Thank you. Your Honor, with the court's permission, may I publish just briefly each of the three respective photographs?
Yes,
It's 441.
thank you.
And Ms. Gilman, if I could have photograph 2866. Sergeant, direct your attention to the screen. Is that?
I'm fine with that instruction. It's, you know, you've got to go based on the evidence, not on outrage, not on how grotesque it is. It's the thing about flying cars, though, Grey Duck, is adding the third dimension creates space. Unless, of course, you know, you have the travel lanes and it's just, you know, hovering lane markers and yada yada. So, yeah.
What's displayed on there now is marked as Exhibit 441. Do you recognize that?
Yes, I do.
And using the laser pointer on the desk before you, if you could draw the jury's attention to what, if anything, of significance you observe in this particular photograph of this rookie.
I observed the swelling of the eyelids, slight laceration of the nostril and the eyelid, the blood pooling on the bed, and that depiction of Mr. O'Keefe.
Ms. Gilman, can I have photograph 2857?
Okay, I like
Again, Sergeant, do you recognize
focusing.
the screen is now marked as Exhibit 442?
I like focusing the camera on Karen so that we can see her reaction to these photos. Because frankly, we don't need to see them. But seeing Karen's, yeah.
I do.
And some of the prior exhibit, if you could, using the laser pointer, direct the jury's attention to what, if anything, is significant to observe in this photo.
I observed the parallel lacerations, abrasions and markings on the skin of Mr. O'Keefe, limited between that point there and that point there, as I described earlier in my testimony.
And then still invited up to 2859. Again, Sergeant, do you recognize what's up on the screen? It is now marked as Exhibit 443.
I do.
And this is what do you see in this photo?
It's the same abrasions to Mr. O'Keefe's right arm, just further up on the bicep, tricep, shoulder area.
Thank you, sir. Ms. Gilman, you can take that.
True, but still looking disinterested in front of the jury when the O'Keefes are breaking down tends to make you look heartless.
Now, Sergeant, taking you back to January 29th, 2022, after you left the Good Samaritan Hospital, where is it that you went?
Went to 345 Country Hill Drive in Dayton.
And that was the residence of Ms. Reed's parents, is that correct?
That is correct.
Now, on your way from the Good Samaritan in Brockton to the residence in Dayton, what, if any, communication did either you or Trooper Proctor have with regard to the Dayton police?
I advised Trooper Proctor to contact Dayton Police Dispatch and advised them that we would be responding to the location, 345 Country Hill Drive, and seizing a vehicle. And we were requesting uniformed patrols to assist us in that mission.
And why was that request made of the local PD?
We were going into their jurisdiction. There was a blizzard going on. We were considerate of the circumstance and wanted to be courteous to the Reed residents and not just show up without any uniform presence. We have never met the Reed family. They have never met us. And with the clothing that we were wearing, it would be difficult for them to see that we were law enforcement.
And so,
you know, as sovereign citizens like to point out, how do I know you didn't just buy this police officer uniform on eBay or on Amazon or whatever? So, well, when you just have a badge and show up with a warrant, it's like, fuck you, I don't believe you. But you show up with marked cars and uniformed policemen, knock on the door and say, yeah, so we're all here. It helps.
you arrive in that area of the residence in Dayton, where did you position yourselves and when did you arrive in relation to the marked unit from Dayton?
We called them while we were still on the highway and gave them an approximate time of arrival. GPS was not accurate due to the conditions at the time on the roadways. Once we arrived to Dayton, I positioned my vehicle at the top of Country Hill Drive, awaiting a marked uniformed officer from Dayton to meet us there.
And if you know, about how long approximately did it take you to get from Brockton to Dayton on that particular day?
From Brockton to Dayton, it took us about 45 minutes to an hour to travel that distance.
And if you know, about what time was it that you arrived at the residence in Dayton?
We arrived approximately on the street at 2:30 or so in the afternoon, and we waited for a significant amount of time for the uniform patrol to arrive.
And when the uniform patrol arrived, at some point, did you learn the name of at least one of those officers that arrived at the residence with you?
At the time, I did, yes.
And was that an Officer Barrows?
Yes, it was.
And so when Officer Barrows arrived, where did you then proceed with Officer Barrows on his way?
Well, the road was only plowed the width of one vehicle. So even though he and his partner were in a F-150 or 250 marked police cruiser, we could only travel in single line. We traveled up to the cul-de-sac, turned around and positioned our vehicles facing back out to the way that we entered the roadway or that street. We parked on the roadway since the driveway was not plowed, and we waded through the snow to the front door of the residence.
When you say the driveway was not plowed or you waded through the snow, can you describe to the jury sort of the condition of the driveway as you made your way from the street to the house?
With the blowing winds and the drifting snow, there were locations along our walk to the property with snow varying from knee-high to up to my waist. For reference, I'm 6'1", so it was quite deep in some locations.
And as you made your way to the home, what, if anything, did you observe in the driveway?
As we walked up to the driveway.
Wait, he's 6'1". John O'Keefe is 6'2". Conspiracy.
Driveway in front of the garage, we observed a large Lexus black in color SUV bearing Massachusetts registration 3GC684.
And subsequently, did you come to find out whose vehicle that was?
Yes, once we queried the plate, we learned that the vehicle was registered to the defendant.
And as you're going by this vehicle, what, if any, observations did you make of the vehicle as you were walking past it toward the home?
I observed a damaged rear right taillight fixture on the vehicle. From my vantage point, I also told Trooper Proctor to approach the vehicle closer and confirm what I was seeing, which he did.
And as far as that damage to the right passenger taillight area, can you describe sort of what it was that you saw during that initial phase?
Absolutely. During the initial phase, I observed snow compacted and caked onto portions of the taillight casing. There were pieces missing, and I knew that because the left side taillight was intact.
And as you made your way past the vehicle to the home, at some point, are you greeted?
So once again, snow caked on the broken taillight. Says, yeah, it's been broken a while.
Or do you need someone in the area of the home?
Yes, once we walked up to the front door, I rang the doorbell, and Mr. Reed opened the front door with the glass storm door, unable to open due to the level of snow on the ground and on the front steps.
And so where were you directed to enter the home from?
Mr. Reed directed us to the garage door, at which point it opened up and Trooper Proctor and I entered the garage. We were once again greeted by Mr. Reed and invited into the home.
And Officer Barrows, where did he remain when you and Trooper Proctor went in the home?
He remained outside with the vehicle. During our time in the home, Officer Barrows came in and asked if...
It's not in evidence. We've heard from the plow director, but the Free Karen Reed crowd has been chanting that for a while. The plow driver, but it's not actually in evidence yet, I don't think. So
what the plan was and offered to have DPW plow out the driveway because the tow truck was not able to maneuver into the driveway in order to retrieve that vehicle.
Now, as far as during any time that you were on scene or at this residence in Dayton, did you yourself or did you observe Trooper Proctor touch that vehicle at any point in any way while you were there?
No.
And did you observe Officer Barrows or any other personnel beyond the...
No touchy. So you didn't, bump out a few shards to go sprinkle at 34 Fairview a week later?
Tow truck driver touched the vehicle in any way?
No.
As far as the tow truck driver was concerned, did you observe that individual touch anywhere in the rear passenger side area of that vehicle at any time that you were there?
No.
When you proceed inside the home and when you get inside the home, where did you go and who, if anyone, did you speak?
We were directed by Mr. Reed to the living room where the defendant was seated on the couch. She had her laptop on her lap and her phone resting on the right armrest of the couch.
Now, in addition to the defendant and her father, who, if anyone else, was present when you talked to Ms. Reed?
The defendant's mother, Mrs. Reed, was also present in the home.
And the defendant's mother and the defendant's father, were they present throughout the course of your interview or your discussion with Ms. Reed?
Yes, they were.
And at any point in time, did you ask them to leave or anything like that?
I did not know.
Now, with respect to, can you describe sort of the demeanor or the tone of the conversation that you had with Ms. Reed that afternoon?
It was polite, courteous. She had just went through a traumatic event, so we were considerate of her losing her boyfriend. And we had a normal tone conversation. We were in the information gathering, fact-finding portion of the investigation. We simply wanted to collect her recollection of events that she remembered.
And so throughout the course of this interview, how are you standing? Are you seated? Or how are you positioned in relation to Ms. Reed, and how is she positioned in relation to you?
She was sitting on the couch. We were standing across the room. I don't recall if there was a coffee table, but if there was a coffee table, we would be standing on the opposite side of that coffee table, if there was one present. I do not remember if there was one present, but that's the distance approximately from me to the defense table.
And if you could describe to the jury, sort of how did that interview or how did that conversation begin? What was said?
First things first, we introduce ourselves, advise the individual we're speaking with, who we are, where we work, and what we're looking to find out. The defendant was advised that we're looking to get a recollection of the events.
And this is non-custodial. Non-custodial. So no Miranda.
What happened, what she observed, what she remembers from the night before, and to walk us through the last 24 hours or so of activity.
And prior
Do I need to give an instructions to Riley? I'm not sure exactly. Why don't I see counsel at sidebar for a minute?
And that this instruction could be so if she stops talking, you can't hold that against her because she has the right not to. Could be what's coming up. And the judge is just proactive about making sure they're not walking into that. And it's not much longer, so I'm not going to. It's kind of hard scrolling on a 7-hour stream. It's a lot easier to be precise on like a 7-minute stream. Because just like we said, 44 out of 400, not even a rounding error on a scale of 10 million or 10 billion. On a scale of 400, it's a pretty big error. So they did it just for you. Just for you. And since this one was initiated by the judge, well, you don't watch a lot of 7-minute streams, but when you're reacting, like that moron sovereign citizen down in Texas that I tend to refer to him as Lucky the Sovereign Citizen because he reminds me of Tom Petty's character Lucky on King of the Hill. His videos tended to be like 3 minutes long, the long ones. So, like, if I was reacting to one of those, it was real easy to skip around because, it took a third of the scroll bar as 1 minute. Whereas here, a third of the scroll bar is 2 hours, 3 hours.
All right, so I interrupted you, Sergeant, and I'm going to instruct you jurors, okay? We're about to hear testimony about statements allegedly made by the defendant, Karen Reed, allegedly concerning the crimes that are charged in this case. Before you may even consider any...
No, that's Lucky Laptop News. This guy is like him, but he's the one that sits in his shack that... Fuck, I'm still describing Lucky Laptop News. But sits in his shack with unpainted drywall, just mud, with a grow lamp behind him. So that one.
Such statement is evidence, the Commonwealth must prove to you beyond a reasonable doubt that the defendant made the statement that she's alleged to have made, and that she made it voluntarily, freely, and rationally. In determining whether any statement made by the defendant was voluntary or not, you may consider all the surrounding circumstances. These include when and where the statement was made, the nature of any conversations with the police or questioning by the police, and the defendant's physical and mental condition, including her intelligence, age, education, experience, and personality. Your decision does not turn upon any one factor. You must consider the totality of the surrounding circumstances. I'll instruct you about this again at the end of the case, but for purposes of, as you hear the testimony, that's the lens that you have to sort of hear it through. All right, with that, Mr. Lally?
Thank you.
So,
Now, Sergeant Mechanic, when you...
It can't be suppressed because, it's non-custodial. But the jury still gets to decide, hey, was this coerced in some way? Is she in her right mind? We get to consider these things. So
you began to speak to the defendant prior to any sort of substantive conversation. What, if any, conversation did you have with her about the conversation you were going to have?
I just asked her to recount any events and the history between the actions that were taking place.
And how did she initially respond to that?
She stated that she's willing to answer our questions. She just doesn't want to go into too much detail about what transpired. And given the circumstances, that she had just lived through, I understood and gave her that courtesy.
And as far as that interview or that conversation went, can you describe that conversation or the contents of that conversation?
And once again, these are statements against interest, so they're not hearsay. He can recount her statements word for word, and it's not hearsay, even though it's an out-of-court statement being offered for the truth of the matter asserted. Not hearsay. So this is why, remember, the Miranda warning says anything you say can and will be used against you. It doesn't say can be used for you. It does not say it can be used to help you, because it can't. Because for the defense, her statements are hearsay. For the prosecution, they are not. That's why defense attorneys say, do not talk to the police. Do not talk to the police without a lawyer. Because the only way they're coming in, your statements, is through the prosecution using them against you. Because they're statements against interest. So the good stuff you say isn't a statement against interest. So you can't get that in. You might be able to, based on some other hearsay exemption, like, prior consistent statement and yada, yada. But chances are it's not coming in. So shut the fuck up and get a lawyer.
With to the jury.
Absolutely. The conversation was normal tone of voice, like I am speaking to you right now. Ms. Reed responded in the same tone of voice, answered questions. The content of the conversation began with her saying that, as I stated, she doesn't want to go into too much detail, but she was willing to answer our questions. We asked what she had for plans, what she had for as far as activity the night before, leading up to.
And he could have done that. He could have done that. He still might. That there might be an agreement to let the father sit in the courtroom, support his daughter, yada yada. But he still might.
Mr. O'Keefe being discovered. She stated that she was in a relationship with Mr. O'Keefe that morning, meaning the 28th of January. She got into a fight with Mr. O'Keefe over what the niece and nephew were being fed for breakfast.
Prior inconsistent statements. We love that.
Or what they had for breakfast. She went on to say that she met Mr. O'Keefe at C.F. McCarthy's approximately 9 p.m. the night of the 28th of January, 2022. She stated that the gentlemen were drinking, consuming beers, Bud Lights, and she was drinking vodka soda. Prior to moving on to the bar at Waterfall, the defendant was asked where she parked her vehicle. She told me that she parked her vehicle on Washington Street across the street from C.F. McCarthy's facing northbound. So the vehicle was on the side of Waterfall Bar and Grill.
Vince, spousal privilege. No family privilege, spousal privilege. And in most states, spousal privilege only exists if they're your spouse, if you are married. So, and the spousal privilege is funny. And this is, what you tell them. You can't force the spouse to testify about what you told them in a criminal case. Spousal privilege is funny because it's kind of bifurcated. So if the spouse declines to testify, the prosecution can't force them onto the stand. And that is for the spouse to decide. But the spousal communication, so what the defendant told the spouse, is the defendant's privilege. So even if the spouse says, hell yeah, he's murdering scum, I'm going to testify against him, the defendant can still protect communications between them. If you divorce in the meantime, the spousal privilege, basically being able to decline to testify, I believe it's been a while, but I'm pretty sure, no longer exists. The state can force you to testify. They're no longer your spouse. Anything you were told after the divorce is not privileged. But anything you were told before the divorce, still privileged. Spousal privilege, of course, is not constitutional. Well, it's constitutional. It's not a constitutional protection. It's either a statutory protection or a common law protection, but it does have the force of law. So, yeah. But no daddy-daughter privilege. So, when I mentioned an exemption, an agreement, I was talking to the exclusionary rule, meaning that's why daddy is allowed in the courtroom through the whole trial, but might be on the witness list. I don't know if he's on the witness list or not, because I haven't looked at it, because once again, I'm a juror who happens to be a lawyer. So the exclusionary rule is in effect. Usually that exempts the victims of the crime, and in a murder case, the immediate family would count as victims. Remember the kerfuffle up in Idaho with Lori Vallow's trial, where JJ's adoptive grandparents, whose names I can't remember off the top of my head, initially weren't labeled as victims, and they were going to be witnesses, so they were going to be excluded, and that wasn't right. So they, in the end, they worked it out, but so, like, the O'Keefe family, they're the victims. Niece and nephew, definitely the victims. They could sit through the entire trial before they testified. Daddy O'Keefe, or Daddy Reed, is not a victim. So, by the, written exclusionary rule, if he's on the witness list, he's out. But if the prosecution's like, yeah, whatever, let him stay in, he, his daughter needs his support, and that's part of a fair process. We want her to, fair trial. We want her to have due process, and her dad being able to support her is part of that due process. I could see that. I'm not saying that is what happened. I'm not saying that is how it's being handled. Just, all right. So this has officially become a fundraiser stream to fly Joe to Australia because I want curried lamb and lentils. So set a place for me, CJ5. Once the rest of you raise the money, I'll be there for dinner, and 3 years. So, yeah. But let's hit play.
We went on through the conversation, the interview, to the Waterfall restaurant, at which point she was asked if she left C.F. McCarthy's with a beverage or a container from that establishment, to which point she stated that she did not. She also confirmed that Mr. O'Keefe did not have any injuries on him when she interacted with him at C.F. McCarthy's or the Waterfall. He did not get into any verbal or physical altercations with anyone to have sustained those injuries.
So did I tell you guys? I think I forgot to tell you, because the day I would have told you was the day that I missed due to it being a bad pain day. But so that birthday dinner I went to a month ago was at the Mumbai House here in Salt Lake City, our local Indian restaurant. Frankly, the best Indian restaurant in Salt Lake, in my opinion, run by real Indians. But so they annoyingly have gone to that, the QR code menus. And I was just going to order my standard chicken tikka masala, delicious, medium heat. So wasn't going to look at the menu because my phone wasn't getting internet signal in there for some reason. And I'm like, fuck it, I know the menu. It's fine. My sister, on the other hand, was like, fuck this, I want a paper menu. So they brought us paper menus. And I'm like, well, since it's in front of me, and I opened it up, and I noticed something new on the menu. And it was titled, I believe, Mumbai Chicken Masala. So not chicken tikka masala, but Mumbai Chicken Masala. The difference being, instead of the traditional white meat in a chicken tikka masala, it was thigh. It was dark meat. Oh, that was so good. Because the chicken is always the weak part in the chicken tikka masala. Always the weak part. Like growing up, I never liked chicken because, chicken breast, it's dry and flavorless and gross and ugh. But chicken thighs in it, so good, so good. Dante, if you're still here, I know it's a bit of a drive from where you live, but Mumbai House right at the mouth of Parley's Canyon, so good, so good, so good. And yeah, I agree with you, Anne. It's gross, but it shows you that they are working hand in hand. And as Mr. Diaper on the back road, Tom CPU, for those of you who haven't seen it, corrosive commentary, Publica something or other on here, does an impression of Tom CPU on one of Kate's streams. And I almost needed a diaper listening to that because I laughed my ass off. But yeah, it's not journalism, it's activism. It's activism. Now, as I've said, it would be a lot more lucrative for me jumping on the free Karen Reed bandwagon, but my integrity is more important, even if I am eating ramen tonight instead of flying down to Australia to, be really, 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 really hungry by the time, I get to Australia. But yeah. And I did know that. Chicken tikka masala. There's a reason it's the national dish of England and not India. Frankly, it probably is the best thing to come out of British cuisine. I do love a good haddock and chips. The mushy peas, ugh. But, you can't get good haddock and chips here in Utah. You just can't. And I crave it. Even not just going to a proper chippy, but even the standard pub fare haddock and chips was so good. So good. Of course, the best I had was in Tynemouth, middle of February, so it was cold. We were across the street from the beach on the North Sea, but it was raining and cold, and it was so good. Of course, we'd just gone to the aquarium, so we joked we were browsing, looking at the menu, and that's bad choice, Kevin. Bad choice. Cauliflower is gross. It's gross. Aye, man. Yeah. My friend is, as I've mentioned, from Birkenhead, so, within a stone's throw of where Paul here grew up, and did his undergrad at Nottingham, I think, and then, master's and PhD at Durham. And so he picked up little bits of, regional bits from each place. And so in order to say yes, he'd just go through the list of all three, yeah, whatever. I don't remember, but it was funny. And we're going until I catch this damn squirrel. So we better press play.
She stated that once at the
Damn it, Vince. That was entirely your fault, Vince. That was entirely your fault.
I just asked her to recount any events and the history between the actions that were taking place.
And how did she?
Okay. We're close enough. I blame you. Vince, as usual. But this time I really do blame you. Your name isn't really Guy, is it? But yeah.
Should we respond to that?
She stated that she's willing to answer our question. She just doesn't want to go into too much detail about what transpired. And given the circumstances that she had just lived through, I understood and gave her that courtesy.
And as far as that interview or that conversation went, can you describe that conversation or the contents of that conversation to the jury?
Absolutely. The conversation was normal tone.
I mean, it's not her family, it's her. The basic reality is those are her seats for her family, but they're her seats. So it's not her family invited DUI guy and the glare and Mr. Diaper, and it's Karen invited them. And yeah.
A voice like I am speaking to you right now. Ms. Reed responded in the same tone of voice,
Oh.
answered questions. The content of the conversation began with her saying that, as I stated, she doesn't want to go into too much detail, but she was willing to answer our questions. We asked what she had for plans, what she had for as far as activity the night before, leading up to Mr. O'Keefe being discovered. She stated that she was in a relationship with Mr. O'Keefe that morning, meaning the 28th of January. She got into a fight with Mr. O'Keefe over what the niece and nephew were being fed for breakfast, or what they had for breakfast.
Donut.
She went on to say that she met Mr. O'Keefe at C.F. McCarthy's approximately 9 p.m. the night of the 28th of January, 2022. She stated that the gentlemen were drinking.
Well, Grey Duck, it's technically in trials, they'll block off a family section for the victims, for the defendants. They'll block off a section for the media, and then whatever is left over is general admission, public. But since they're in this tiny courtroom at the defense's request, there's no space for the general public. So, but in the portion that is blocked off for the defendant's family, the defendant gets to choose. In the portion that's blocked off for the O'Keefe family, for the victim's family, the victims get to choose. Now, here, is it Paul O'Keefe? Is it Daddy O'Keefe? Mom O'Keefe? The niece and nephew? I would guess it's probably the parents, but let's say, John was a responsible person, and especially considering he'd been through the tragic loss of his sister and brother-in-law, the kid's parents, John certainly had estate plan. So it could be, Paul O'Keefe is the executor of the estate, therefore he speaks for the estate and he gets to choose. But and I should say it properly, Kova, as Birkenhead, because you've got to be scouse about it.
Consuming beers, Bud Lights, and she was drinking vodka soda. Prior to moving on to the bar at Waterfall, the defendant was asked where she parked her vehicle. She told me that she parked her vehicle on Washington Street across the street from C.F. McCarthy's, facing northbound. So the vehicle was on the side of Waterfall Bar and Grill. We went on through the conversation.
Nope. It's specifically Vince's fault for this one. So
conversation, the interview to the Waterfall restaurant, at which point she was asked if she left C.F. McCarthy's with a beverage or a container from that establishment, to which point she stated that she did not.
Maybe.
She also confirmed that Mr. O'Keefe did not have any injuries on him when she interacted with him at C.F. McCarthy's or the Waterfall. She did not get into any verbal or physical altercations with anyone to have sustained those injuries. She stated that once at the Waterfall, they stayed for approximately an hour, hanging out with acquaintances. And then they left the Waterfall. She drove them to, after they were invited to a residence, she drove them to a location in Canton, where she dropped Mr. O'Keefe off. She was asked if she saw Mr. O'Keefe walk into the home at 34 Fairview, and she stated she did not. She stated that she made a 3-point turn after dropping him off and left. She was asked whether or not Mr. O'Keefe excuse me, let me back up. She was asked if she knew, how she found out about the damage to her vehicle, to which she stated, quote, "I don't know, it happened last night," end quote.
I don't know, it happened last night. So she hadn't invented the, oh, I frantically backed into Johnny's SUV when I went to go look for him yet.
Now, at some point earlier in the interview, what any indication did she give as to who Mr. O'Keefe was with when she arrived at Steve McCarthy's and sort of how long he had been with those respective people?
She indicated that Mr. O'Keefe was with Mr. Camarano, Kurt Roberts, at which point she was asked to provide contact information, meaning phone numbers for those individuals, at which time she picked up the phone on the right armrest of the couch, manipulated the device, entering a passcode, and provided that phone number to Trooper Proctor and I.
At any point in time in the conversation or interview you had with her, what, if anything, did the defendant say in regards to why she had not gone into the residence of Fairview Road herself?
The defendant stated that she was having stomach issues and did not want to enter the residence.
Now, what, if anything, did she tell you about the later on that morning of the 29th?
She stated that when she woke up, she began looking for Mr. O'Keefe. And when she found him in the snow, she began CPR on Mr. O'Keefe.
And what, if anything?
Laying across his body is different from the CPR I learned. I admit it's been a while, but it's not the CPR I learned.
What did she say to you about any observations she made of Mr. O'Keefe later on that morning as far as any injuries to Mr. O'Keefe?
The defendant stated that while she was performing CPR, Mr. O'Keefe had sustained injuries and was bleeding from the nose and the mouth.
And if you recall, what, if anything, did she say about Mr. O'Keefe's eyes at that time?
The defendant stated that Mr. O'Keefe's eyes were swollen.
Is that both eyes? Is that correct?
That's correct.
Now, as the interview progressed, at some point, did you ask questions seeking further details?
Yes, I did.
And details about what specifically were you asking?
Once we got to the point in time where the defendant told me she did a 3-point turn, I asked,
hey, that's a good point, CJ5. Hey, let's go to D&D. Let's go make pizza. Let's go make pizza. Let's go make pizza. Oh, my stomach hurts because your ex-girlfriend was mentioned on the drive here.
Asked her to walk through step by step of her operating the vehicle and exactly what she did. Prior to that, I asked her, excuse me, so she was asked to give a step-by-step recollection of how she, what she did in manipulating the vehicle and leaving the scene.
And at that point, was the interview terminated?
Yes, it was.
Now, once the interview concluded or was terminated, what, if anything, did you do with reference to Ms. Reed's?
I mean, like, the few times I've had enough painkillers to make me a little high, I haven't liked it. There's a reason I don't recreationally take drugs. There's a reason I don't drink. And but laying in the hospital bed, feeling the hospital bed fly away with me on it, I didn't like. Not at all. So I'll bring it when I show up for the curried lamb.
Phone and the defendant's vehicle.
Once the interview was terminated, I advised Ms. Reed that her phone was going to be seized as evidence and her vehicle was going to be seized as evidence as well.
And did you subsequently seize both of those items, sir?
Yes, we did.
And similar to the clothing of Mr. O'Keefe, as far as evidence was concerned, was that packaged and taped and transported back to the office in a similar fashion?
The vehicle was transported via tow truck that was dispatched by Dighton PD on our request.
And so when you get back outside of the residence after the conclusion of your interview with the defendant. What, if anything, did you observe going on with regard to the driveway and or any other vehicles that weren't there when you went into the house?
During our interview, I glanced out the window and I saw flashing amber lights and a tow truck plowing the driveway. So the driveway was plowed, and the tow truck was, plow truck was plowing the driveway, not the tow truck. And the tow truck was loading the vehicle.
And I actually should say, so I've had trying to get the phantom pain under control. They've tried nerve blocks, and one of them was the lumbar sympathetic nerve block, which is not fun. They sedate you for that, and they sedate you with fentanyl. I don't get taking that recreationally. I hated it. Ugh.
Vehicle onto the flatbed.
And from at any point in time when you were outside of the residence, what, if any, observations did you make as far as cameras or anything like that on the exterior of the home?
I did not see cameras on the exterior of the home at that point in time.
Subsequent to that date, did you become aware that there were exterior cameras that record on the exterior of the home?
Subsequently, yes, we learned that there was video recording of the residence and the driveway.
Interesting.
May I approach?
Yes.
I'm showing you a disc. You recognize that, sir?
Yes.
And what do you recognize that to be?
I recognize it to be Dighton videos as it relates to the location where the interview and the vehicle was seized from.
And what's contained on that, as far as the video is concerned, is that a fair and accurate portrayal of what you observed as far as the defendant's vehicle being loaded onto a tow truck?
Yes, it is.
Thank you. Can I continue on?
Yes.
I want to see if you introduce the minutes of next exhibit.
Objection.
And this is another good reminder. Get motion activated security cameras. Good reminder for me too, because yeah, you never know when some drunk bitch is going to hit someone in front of your house and try to throw you under the bus for it. So yeah, get motion activated security cameras. This video is not sponsored by Ring or anyone else. So
And Your Honor, with the court's permission, if I could publish
That's awful.
those two short clips for the jury.
Yes.
That's awful.
Just coming, if you could, click on it and pause when it, please.
We're not all boring, Kevin. Of course. So one of my friends at Durham, real smart guy, you know, undergrad, did physics at Oxford, and he was hired by a Big Four accounting firm as an actuary, and we teased him, actuaries for when accounting is too exciting for you.
Still, Ellie, you need to keep your voice up.
Yeah, that's a lot of snow.
Now, the sergeant mechanic from this particular point of the video.
So 2:14 in the afternoon, that's the Lexus, and the snow is above the bumper. So that's a lot of snow.
Do you recognize the vehicle that is just pulled into the driveway?
Yes, I do.
Is that the same driveway that you would walk up from the street to the house in Dayton on that morning?
Yes, it is.
As far as the vehicle is concerned, what do you recognize that vehicle to be?
DeCastro has one for sale if you want it, CJ5.
That would be the Lexus SUV owned by the defendant, Bear, Massachusetts, registration 3 GC 684.
How many feet press right in there?
And Karen was the
Two individuals
passenger.
just exited that vehicle, is that correct, Sergeant?
That's correct.
Do you recognize who those individuals are as far as who they are, from what part of the vehicle they exited from?
Well,
Yes,
bear in mind, he was found 10 hours before this, so presumably 10 fewer inches of snow. But still, you know, 6 inches had fallen, presumably, between the time he was struck and found. So 6 inches of snow, you're just going to see a lump in the snow, a bump in the snow. So Karen, seeing him as they drive by, I think she knew he was there.
the passenger side exit was the defendant, and then the driver's side vehicle was Mr. Reed.
And the father, is that correct?
That's correct.
Just don't if you could please. Yeah. Now, Sergeant, towards the end of that video, did you observe the defendant and her father in any specific area in relation to that vehicle?
Yes, I observed the defendant and her father at the rear right taillight, gesturing or signaling towards the affected, damaged, and missing parts of the taillight.
Objection.
I'll allow just the direction that they were signaling out.
Move to strike the remainder.
Okay?
As far as that vehicle's position within the driveway, is that essentially the position that you observed it in when you and Trooper Proctor and Officer Barrows were walking up the driveway to the home?
Yes, it was.
And Ms. Gilman, if I got a second of those two videos. If you could pause it there, please. Again, Sergeant Mechanic, if you could describe to the jury what you observed of significance within this particular video.
This video captures the vehicle being moved into position to be loaded up onto the
This is 2 hours later, and the snow is even higher.
flatbed for transport from the.
And we speculated the other day that it wouldn't have been, you know, the hook and grab tow truck where, you know, you lift two wheels, because 4-wheel drive, it messes that up. I said I'd be surprised if it was a enclosed tow truck. So it is a flatbed, but it looks like it's being brought onto the flatbed rear end first, which means the wind could be an issue on the rear bumper, caking snow and, you know, any debris, but also any debris would be blowing against the tailgate, not away, if that makes sense. So, yeah.
scene.
Gentlemen, if you could play for them.
Oh, nope, never mind. Never mind. They drove it up, so never mind, never mind.
I'm sorry.
I assumed they were gonna put the strap and pull it on, but no, they drove it on, so it did go front first.
I just asked for applause, right?
Yeah, you really have to keep your voice up.
Yes. Sergeant Mechanic, from this still image from this video, what, if anything, is significant to you observe in relation to the vehicle at this time being loaded on?
The rear taillight is illuminated. You could see a white light coming from that taillight.
If you could, using that laser pointer you have before you, just direct your attention to the specific area you're talking about.
Right there.
Just go ahead and give it play this through. Let's go and you can take that down. Now, Sergeant Mechanic, as far as when you left the residence in Dayton, where is it that you went?
Can we turn the lights on, Mr. Lally?
Yes, my apologies.
Oh, she looks a little bit emotional about seeing her Lexus towed away. stone-faced about John and his injuries, but her baby Lexus, she looks a little sad. She looks a little sad about the Lexus going away. The poor dear.
Once we left the residence in Dayton, we proceeded following the tow truck back to the Canton Police Department.
And was there anywhere else that either you or the tow truck went between Dayton and the Canton Police Department?
No, sir.
And when you say we, it's yourself and Trooper Proctor, is that correct?
That's correct.
Now, once you arrived at the Canton Police Department, where did the vehicle go?
The vehicle was unloaded and put into a heated sally port located at the Canton Police Department.
And in reference to the Canton Police Department and putting it in the sally port, why was it that it was taken to that location?
It's a location that serves as a storage for a vehicle that would suffice for the size of the vehicle. The location is, as it related to the crime that took place was investigated, was in that town. So we utilized their facility. It was also a heated facility to help melt the snow that had been accumulating on the vehicle.
Melt the snow. So evidence tampering. Oh, the horror. The horror. So, yep. When it's about her, hey, that's a problem for her, but you know.
And at some point, as far as some point subsequent to this, did you learn that there are exterior cameras of the Canton Police Department as well as cameras within the Sally Port garage area?
Yes, I did.
And have you reviewed each of those respective cameras prior to your testimony here today?
Yes, I have.
May I approach, Your Honor?
Yes.
I'm showing you this, just have to look at that a couple of minutes. Do you recognize that, sir?
Yes, I do.
What do you recognize that to be?
The Canton Police Department driveway with video.
And what's contained on that is that fair and accurate portrayal of yourself and the tow truck pulling into the Canton Police Department driveway on that afternoon or early evening of January 29th.
Yes, it is.
May I approach, Your Honor?
Yes.
Almost, you can introduce the minutes of the exhibit.
They have just a moment, Councilman.
Okay.
Mike.
I mean, it's no 85 Camaro, but you know, it'll do.
Thank you for that, Your Honor. No objection.
Okay.
And Your Honor, with the court's permission, we publish that video to your agency.
Okay.
And just for reference points, in regard to this view of this camera, Sergeant, you're familiar with the Canton Police Station?
Yes, I am.
And so where is this camera view in relation to the Canton Police Department and the Sally Port garage where the vehicle eventually goes?
This camera is capturing the driveway entrance to the Canton Police Department. As viewed from Washington Street, that driveway there is on the left side of the structure. The camera itself is pointing towards the entrance of the driveway to the Canton Police Department. As you can see, the brake light illuminated in the shot. That is a Canton Police cruiser sitting at the edge of the driveway right by Washington Street.
So for orientation purposes, as far as the tow truck and your vehicle, is that coming from the top of the screen to the bottom or the bottom to the top?
It's coming from the top left to the bottom right of the screen towards the rear of the building where the Sally Port is located.
Thank you, Mr. Yeoman, if you could. Pause there, Mr. Yeoman. As far as what's depicted in this still shot in this video, Sergeant, what if anything do you observe?
That is the tow truck transporting the defendant's vehicle arriving at Canton PD. My vehicle with Trooper Proctor inside, me operating, are following closely behind as we did the entire way from Dayton all the way to Canton.
Gentlemen, if you could play that to the end.
Imagine that. The missing footage that was never actually missing. It just hadn't been entered into evidence yet. Shocking, I know. I hope a few free Karen Reed heads exploded.
Okay. Now, as far as the interior of the Sallyport garage,
Put the lights, thank you.
as far as the interior Sallyport of the garage, you mentioned that that is a heated area, is that correct?
That's correct.
And as far as the heat within that, do you know how that is produced or how hot it gets in there as far as the time that you spent within there?
I do not know, but it was a standard garage heating system that blows hot air. As far as temperature, when the doors were open, that day it was freezing cold. It was, I believe, like 18 degrees with winds blowing. So inside the garage inside the Sallyport with the doors open, it was quite cold. Once the doors shut, the temperature rose above freezing, and the snow began to melt off of the vehicle.
And from the arrival of that vehicle into the Sallyport garage area, are you aware or have you reviewed video in reference to that?
Yes, I did.
And Your Honor, may I approach?
Yes.
Showing you another disc.
I love the absurdity of showing a CD. And so, do you recognize this? Well, yeah, it's the video of this, and it's absurd, but they have to do it.
Sir, if that's going to review that, we'll finish.
It was on the same soundstage that Kubrick used for the moon landing. So that's how high this goes.
And do you recognize that, sir?
Yes, I do.
Does that contain the video that you were just testifying about as far as the arrival of the vehicle at the Canton Police Department Sallyport garage?
Yes, it is.
Thank you. May I approach, Your Honor?
Yes.
How about proceed to introduce in minutes and exhibit? No objection, Your Honor. Now, Sergeant, before we get to that video, if I could just ask, if you know, approximately what time was it that you left Dayton following that tow truck back to the Canton Police Department?
We left Dayton approximately 4:15, 4:20, and we followed the vehicle back to Canton.
And how much weed did you smoke since it was 4:20? Conspiracy.
Arriving probably around 5:30 or so p.m.
Thank you, sir. And Your Honor, with the court's permission, if we could publish that video for the jury.
Okay.
Exactly. It's all CGI. It's a lot of snow.
Ms. Kevin, if you could just pause there for a moment. Sergeant, direct your attention up to the video on the screen.
But it's not 4:20 where you are, JT Davis. So I was inquiring of Buchanan.
Just for orientation purposes again. First of all, do you recognize what's depicted in this video?
Yes, I do.
What do you recognize it to be?
That is the Sallyport two-bay garage at Canton Police Department with the antique Canton Cruiser on the bottom of the screen, and the open spot for a vehicle in the middle of the screen with the four-wheel drive all-terrain vehicle at the top.
Now, as far as, again, for orientation purposes, the driveway that the jury just witnessed in the prior exhibit, is that to the left of the screen, the right of the screen, or something else?
The driveway is to...
That's a good point. That's roughly the time that they did the line search, the grid search, CERT was there at 4:30 because that's roughly the time they gave was 4:30 because that was our speculation of, you know, how dark it was at 4:30 and yada yada. So obviously it took them time to dig down and find it, but they got started at 4:30. Now, of course, you know, they left at 4:30, but you know, in theory, someone, you know, one of the uniformed Dighton officers could have, while Sergeant Buchanan was interviewing Karen, one of the uniformed Dighton officers could have, you know, yoinked a piece off and rushed it back to Canton to bury untouched beneath the snow. And I mean, it's all completely ridiculous, but in theory, but that's the thing about reasonable doubt is it has to be reasonable. You don't craft fanciful narratives to say, well, this could have happened. It could have been aliens. That's not reasonable doubt.
The right of the screen.
And this vehicle, defendant vehicle is sort of taken into the garage from the opposite side, or from the left of the screen, is that correct?
Correct.
Ms. Gilman, if you could, stop waiting.
You want to maybe approach briefly?
No,
Okay, could you pause that, Ms. Gilman?
no, you may not approach. We need to get through this eventually. Okay, that woman sitting next to Aaron O'Keefe reminds me of someone, and I think it's Jeremy's love interest in Peep Show, who is actual royalty. I think she's married to Freddie Windsor. But she kind of reminds me of that actress, I think. Let's see. Yeah, Sophie Winkleman, Big Sue's.
A short afternoon break on our
Kind
long
of.
days at about a half an hour, but I think the better use of our time is to give you a 10-minute break now. And then we'll go straight through to 4 o'clock. But if anybody needs a break,
All rise for the court, please.
Follow me, please.
Jim.
But it's like part Big Sue's, but part someone else too that I can't think. But either way, let's. Oh, I thought we were going straight into a break. Never mind. We're having a break in a minute. Yeah. Good thing the jury's out. Got to play a little grab ass with Jack.
Got it. May the witness leave the stand just for a moment.
Sure.
Oh, okay.
Yeah, we'll see you back here in about 10 minutes.
Okay, so jury sent to break. Argue about the video, then court will go into recess for their break. So that's the problem.
You are unmuted.
Okay, so you want us to watch this now?
If you please, the board, yes. May I get just a little closer?
Sure. Can we turn out the lights, please, Dave? Thank you.
So they're took a photo of the front. Okay, it's turned off. Lights went off. Shoveling the snow out of the sally port. Very suspicious. Are we looking for like a time jump? A glitch in the matrix? That's exactly what it is. It's the Lexus LX 570 is a Land Cruiser, just more expensive. It's the crash test dummy we saw the other day. Okay, closing the doors. Putting up crime scene tape. Hanging the little orange man. They're using a dolly hand truck as the post by the taillight. And it's definitely not an HD video. There do seem to be skips in the frame, but that's security camera for you. Probably.
Is that the end of it, Mr. Lally, or
I believe so, yes.
is that the end of it, Ms. Gilman? Okay. All right, lights on, please, Dave. Thank you. All right, so I have a copy of the printed docket on 424. Paper number 347 was the Commonwealth's Notice of Discovery XL. I just asked Mr. McDermott to print it for me. Our printer up here doesn't work. All right, so that was before we impaneled. That was the day, I believe, of the long motion to eliminate trial.
So is this, hey, we didn't get this in discovery, therefore you can't use this? Is that what this fight is? Of course, then what happens is the defense is like, hey, it's not on video, therefore they were able to tamper, and then the prosecution on redirect is like, so yeah, we have this video that, you know, they opened the door, this is rebuttal, therefore yada yada, and it's not exculpatory. So
All right, so we'll take a 5-minute break, okay?
Thank you, Your Honor.
Hey there, Karen Reed, trial watch.
Still Jesse Weber. All right. We'll go right there. So 7:44. God, how are we still this far? How are we this far? And yeah, pretty much. Well, I think the garage video they're talking about, though, is when the evidence technician was there and the solo cups, you know, she swabbed inside the solo cups. I think that's the portion they're alleging is missing, but I don't know because I don't listen to the free Karen Reed crowd because they're morons. So, yeah.
And Sergeant, as far as the condition of the vehicle as you observe it in this sort of pause still shot of the video, is that fair and accurate portrayal of the condition as far as the
Okay, well done. Well done, Law and Crime. Well done. Well done. Maybe Court TV or whoever, but I love having testimony with the title card up. Well done.
snow or ice or anything you observe on that vehicle when it came into the Sally Port garage?
Yes, it is.
There's no way you could type in there. No, if you could just pause there for a moment. Sergeant's following in video.
All right, so keep your voice up.
Sergeant Mechanic, with reference to any individuals you see in this video, do you recognize any of those individuals?
I can recognize Trooper Proctor and myself. Other than that, I don't remember exactly who else was present at this moment in time.
If you could start using the laser pointer before you just direct your attention to where you observe yourself and where you observe
That's Trooper Proctor and myself. Yeah.
At any point in time when you were present with this vehicle in the Sally Port garage this evening of January 29, 2022, did either yourself or did you observe Trooper Proctor touch or manipulate in any way the right rear passenger side area of that vehicle?
No, we did not.
Ms. Gilman, if you can play the hearing.
hey, this is what we just watched. Everyone else in Canton is, so why can't Trooper Buchanan be intoxicated too? And it looks like the Sally port is drive in, drive out, like door on each side. Oh, I've said from the start, I absolutely think that there could be conspiracy charges in her future. And frankly, a superseding indictment for Turtle Boy, adding the witness intimidation or conspiracy for all the charges he already has. And, you know, win or lose, I could absolutely see Karen facing these conspiracy charges. If her phone shows evidence that her attorneys orchestrated it, they could face the charges. And they're like, the attorney-client privilege for this case would still exist, but there wouldn't be any attorney-client privilege for the conspiracy case because it doesn't exist for planning and committing crimes. So if there's evidence that links her attorneys to it, if there are texts from the attorneys to Turtle Boy, let's say, there could be problems. And her parents and, you know, the diaper man, all of them. It's depending on what it shows, there could be problems. And absolutely, they would be at each other. And in that case, it's a race to the prosecutor to get the best deal. So, yeah. And I'm not saying that there is a conspiracy. I'm just saying there could be. There could be. Nah, if she's not, if there's no sex or Lexus in it for him, Turtle Boy absolutely would squeal. I agree.
Dr. Mechanic,
I mean, so I have no problem with YouTubers in the media section as observers. No problem with that. I've done it before. well, not media section. I was just general admission. But you know, I sat through an afternoon of the Gwyneth Paltrow trial. No problem with that. But inserting yourself into with one party or another, you're no longer a journalist, you're an activist, you're a party, and I don't like that.
You're observing in this video what you've seen or what you recall from this. What is it that you and Chief Proctor and some of the other officers are doing now?
We're establishing a perimeter around the vehicle with yellow tape in order to prevent or alert and advise anyone in the area to stay away from the vehicle.
Going to give this play to the end, please. You can take that down, Mr. Officer. We can have the lights back on. Now, Sergeant Mechanic, are you aware of a warrant that was executed on that vehicle on February 1st of 2022?
I am aware.
And you yourself were not present for that? Is that correct?
I was not present for the execution, no, sir.
Trooper Proctor was, as far as you're aware. Is that correct?
That's correct.
Now, the next time that you were within the Canton Police Department Sallyport garage with the vehicle was on February 2nd. Is that correct?
That's correct.
And on that day, where did the vehicle go from the police station?
From the Canton Police Station, I escorted the vehicle to the Milton Barracks for safekeeping.
And why was it taken from the Canton Police Station on February 2nd to the Milton Police Barracks? What had occurred in the intervening part between January 29th and February 2nd?
The Canton Police Department had recused themselves from interviews and in that portion of the investigation. And now that the vehicle had been processed, we needed to free up the Canton Sallyport so they can utilize that facility for transporting prisoners to their facility and booking.
So, you know, to chase another squirrel, I was asked way earlier by Brandon about the viral Judge Simpson clip, and I said, yeah, it's the guy's fault. Even if his license shouldn't have been suspended, he knew it was, and therefore he shouldn't have been driving. Judge Simpson was right. Turns out he might not have had a license ever. Turns out Judge Simpson called him out on it. So all these channels that did their quick retractions saying, whoopsie daisy, shame on us. Maybe need to do a unretraction. Sounds fun. I might just have to make a video on the entire situation this weekend. Could be fun.
So we stored the now processed vehicle back at the Milton Barracks in a unheated garage.
And Your Honor, if with the court's permission, if I could publish just a very brief portion of what's been marked as Exhibit 34,
Okay.
Which is the Canton Police Department Sallyport's garage camera.
Okay.
And I'm just going, what you have up there, sorry, February 2nd, 2022, approximately 8:09 a.m. I'm just going to ask you to play that through till about 8:10:26.
So 2-2. Couple days later, dark as fuck.
Sergeant, just for orientation purposes, again, this is another camera from within the same Sallyport garage, is that correct?
That's correct. It's the opposite view from what we just viewed in the previous video.
And as far as any of the people in this video, do you recognize any of the individuals in there?
I believe that's myself and then another officer. I don't know who that other officer is.
And just again, using a laser pointer, if you could, direct your attention to where you see yourself.
And that's why, as I've said, I see this as unfortunately, the beginning of the end of live streaming trials, because YouTubers have abused the privilege. The media has abused the privilege. And I could see in cases of great interest, just recording it and releasing everything after, which sucks. But, ooh, I guess you're excused for being late. That sucks. I only remember one tornado in my lifetime here in Salt Lake. Ripped right through downtown, and that was in 1999, because, you know, dry mountains, we don't get many. But, I hope everyone is safe and accounted for, and except maybe Josh, but hopefully he wasn't on your street. So, yeah. Ugh. It was here. The one in downtown Salt Lake was a 1 or a 2, but it was during the Outdoor Retailers Association trade show. So there were a lot of people downtown in a giant tent. So that was bad. Very, very, very bad. So, yeah. But now that you're here, though, Kfar, apparently that Judge Simpson viral clip just gets more and more fun as the days go by. And Judge Simpson was more right than we knew. How fun.
As far as the condition of the vehicle from January 29th, when you saw it on that day, to February 2nd, when you saw it on that day, as far as the exterior of the vehicle, what if anything was different, or what if anything you noted or observed?
I noted the taillight removed and the evidence collected.
As far as the snow and cake on ice that you observed on that prior day, was that still present on February 2nd?
No, that had melted away.
And I was assuming if you put it in, I'm sorry, just wait through the 8/10/26.
About what the Corey Richens court hearings are from me. Yeah. Yeah, they're going to start having stronger gag orders. I mean, look at the Koberger case, and if it hasn't been set in open court, there's a gag order. And I think that's going to become more standard. And it's unfortunate, but we've abused the privilege. I think this is them removing the tail light. I think it would be nice if they turned lights on. Oh, they're moving the car. That bottled water is sure fluorescent in this light. All these next to the classic cruiser
Take
are
that down.
cases of bottled
And Mr. Officer,
water.
we can have the lights back on. Thank you. Now, Sergeant Mechanic, with regard to Mr. O'Keefe's house at One Meadows Avenue in Gay, at some point did you become aware throughout the course of your investigation that there were exterior cameras affixed to that residence as well?
Yes, I did.
And those were Ring cameras, is that correct?
That's correct.
Now, with respect to investigation, what if any steps were taken in order to secure any of that footage from the exterior of the house from the Ring?
Objection.
No, I'll allow it.
We applied for multiple search warrants.
Objection.
All right, I'll see you at sidebar on this.
Yep, I've been covering that technically it's the TikTok bullshit, Ashley Giard, the TikTok psychic, but I'm behind on it because of this, but Schofield versus Giard, absolutely, bizarre case. And I feel so bad for Professor Schofield. She's obviously going to win, but I doubt she ever collects a penny, unfortunately. But yeah.
Muted.
Don't defame people.
And so, sir, during the course, let me ask you this, as far as this or any other investigation is concerned, how is it that members of your unit sort of work through an investigation or work on a case?
We,
Objection, Your Honor.
No, I'm going to allow them.
as a case comes in, we address each case on individual basis based on the evidence that is presented through testimony and physical evidence that is recovered. That is what guides our investigations, and we then develop leads and process information collected. Sometimes information needs to be collected from third-party holders of data or service providers, at which point to access that data, we apply for search warrants, which are guided.
Okay, so leave it, move on from that. So you apply for search warrants, we'll move on from that.
So this could be, calls for legal conclusion or, talking about the search warrants, or we applied for a search warrant but didn't get it, so we weren't able to get this information, and, yeah.
Sorry, my question is more geared toward as far as individual personnel within your unit. How is an investigation conducted as far as one?
I think Turtle Boy and Ashley Giard, I don't see much difference. They're both doing it for clout. I really think they're both just doing it for clout. So
Does everything, or is it a collaborative effort, or how is that?
The reason I say we is because every investigation takes the entire unit typically to put an effort in to conduct interviews, analysis, and so forth. So it's a team effort each and every time. No investigation is a one-man show. That's why we call it a case officer, not a lead investigator, because the case officer organizes the individuals to assign different tasks and collect and organize the data that comes back from the third-party providers and from the interviews that are conducted.
As far as the interviews that are conducted through the course of this or any other investigation, is there ever an interview that's conducted just by one trooper or one person in any investigation that you've done with this unit?
No. We conduct interviews with two people, whether it's a trooper and a local detective, or two troopers assigned to our office, other state police agent unit within the agency.
Now, as far as the case officer, who was a case officer on this particular investigation?
The case officer in this investigation was Trooper Michael Proctor.
although Giard, there have been consequences, from Giard's defamation. Like my understanding is Professor Schofield, has been contacted by the crazies, and that's part of the problem. So that's it. They're clout chasing grifters, and the reality is most people don't have a lot to offer. They have their opinions, but they don't have a lot to offer. It's, do you have personality? That's what most people have to offer. I would hope I'm offering a little more than that. Not a lot more, but a little more than that. But it's just, it's a problem.
And Trooper Proctor works under your supervision, is that correct?
That's correct.
So as far as a search warrant for the ring video from One Meadows Avenue, who specifically sat down, put pen to paper, and wrote the search.
Trooper Proctor was the affiant.
And as far as from that search warrant, are you aware of the materials that were provided by Ring in response to that search warrant?
Objection.
I'm going to allow it.
I am aware of it.
And have you reviewed both the material as well as the videos that were provided by Ring in response to that search?
I did.
Now, with reference to those videos, specifically,
Okay. So potentially, remember, we saw some Ring videos from the O'Keefe residence through Paul O'Keefe. What he was able to get off of John's computer. We assumed that certain videos of Karen arriving and leaving on the motion activated camera, the reason we didn't see those is because in her 15 minutes at the O'Keefe residence, she deleted them, was our assumption. You subpoena Ring, there's a reason they're so vociferously objecting. They don't want this in. Because this could be damning. Potentially. I don't know. I haven't seen them. But it could be bad for Karen. Assuming they get it in and got it from Ring off of their servers and all that fun stuff.
did you observe if you know, with respect to those videos, how were they sort of ordered sequentially, when in the manner in which they were provided as far as date, time, things of that nature?
Ask it differently. Ask it differently, Mr. Lally.
Leading.
So the videos that you received from Ring that you reviewed, correct?
Yes, I did.
Objection.
No, I'll allow that. So he's reviewed videos from Ring. Next question.
What, if any, information did they contain as far as date or time?
The data provided back from Ring provided videos. There was no date and time on the labeling of this, the identifier, unique identifier for each video, but it was presented in a sequential order, knowing that the last video presented from the provider was the last video within the scope of our request, and the first one being the first in that timeline.
In the scope of your request, the scope of the request of the warrant, what time frame are we talking?
Objection.
I'll allow that.
The first warrant we requested from January 24th at midnight through January 30th at midnight.
And with respect to those videos that were provided, you reviewed each of those, is that correct?
That's correct.
And Your Honor, with the court's permission, I would ask to publish certain of those videos for the
Objection.
Why don't we come to Sapphire?
Objection. It's devastating to my case. Therefore, she knows he's going to object because he's been objecting every step of the way, trying to lay the foundation. So just preemptively, let's have a sidebar. And as you can see, it came in. Oh, and yep, that's McCarthy's there. Just getting a little sneak preview. Hey. Her dad kind of reminds me of a poor man's
You are unmuted.
Clint Eastwood. Of course, he's, I assume, 20 years younger than Clint Eastwood, but he looks like a poor man's current Clint Eastwood. Very. I mean, can you get more of a douchebag look than that chin strap mustache or chin strap beard? It's ugh. He just looks douchey.
Ms. Gilman, if I could have from what's been previously marked as Exhibit 6, first video 119. If you could pause there, Ms. Gilman. Now, with reference to this particular video, number 119 in Exhibit 6, Sergeant, What, if anything, can you tell the jury as far as the timing of this particular video?
Based on the appearance of the driveway, we know that this recording took place prior to the blizzard of January 29th.
And as far
Maybe.
as anything that you observe in this video, as far as vehicles or people within those vehicles, what, if anything, did you observe within this video?
I observed Mr. O'Keefe's car parked in the same location as he typically parked it, and then
Objection.
I'll strike the as he typically does.
and then
His personal knowledge wouldn't extend to how John typically parked it. Unless, of course, he'd been told through his interviews, yeah, John always parked in that back corner there. But yeah.
a black SUV parked perpendicularly to Mr. O'Keefe's vehicle, adjacent to the entryway to the garage.
Please tell me if you could press play on that. Please tell me if you could pause it. At some point in the course of your viewing of this video, the video surrounding it, you able to identify the operator of the vehicle, black SUV?
Yes, that is the defendant operating her black and colorless Lexus SUV bearing Massachusetts plate 3 GC
So
684.
the niece in the passenger
And,
seat,
Ms. Gilman, if you could
presumably.
play.
She was that close to driving on the lawn. What would Nebuchadnezzar say? Ooh.
Now, Sergeant Mechanic, are you also aware from your review of the ring videos from One Meadows Ave, another video depicting the defendant leaving the house sometime shortly after 5 a.m. on January 29th?
Yes, I am.
And Ms. Gilman, if I could, also from Exhibit 6, ask for, video 153. If you can just pause there for a moment. Now, Sergeant, with reference to this video and the one just previously from 119, where is Mr. O'Keefe's vehicle parked in relation to this video vis-a-vis the other video?
The vehicle's parked in the back corner of the driveway along the fence in the same location as it's parked in the previous video.
And at some point, do you see the defendant's vehicle back out of the garage in the same directionality that it did?
If only it had been this driver's side tail light that had been broken. Because we can tell that it's intact from this video, but we can't see the passenger tail light. At least not yet.
See it in the prior video 119.
Yes, you do.
Ms. Gilman, if you could address.
Oh.
Pause there for a second. Now, as far as the operator of that vehicle, are you able to observe who that operator is within that vehicle?
I observed the vehicle being operated. I cannot identify who the individual is, and then from that shot right there.
From at any point in the shot of the video that you observed, are we able to recognize the operator?
Not from that shot, no.
Now, with respect to the timing of this video, what time in the morning is this video?
This the timing of this video is approximately 5:07 a.m. when the defendant left the home through the garage via her vehicle.
Ms. Gilman, if you could play through that.
So looking at the tire tracks, at best, it would be a glancing blow. But the taillight is broken. right there. It's 100% broken. Because remember, I commented earlier, the white lens is only rear facing, not on the side whatsoever. Here we have white on the side. It's broken. I do not see any taillight fragments on top of the snow. I do not see any taillight fragments near John O'Keefe's SUV at all. I don't see them. This is where they'd be on top of the snow. This is at 5:07 a.m. Anne. And there.
Now, from this particular pause portion of the video.
So there we have an even better view of the broken taillight.
Sergeant, what, if anything, of significance do you observe within the still shot of this portion of the video 153?
The portion of this video in the still shot presented identifies a missing, damaged rear right taillight, exposing the white light coming from the right side of that taillight.
And if you could, using the laser pointer before you draw the very attention to what you're talking about as far as that area of the defense vehicle. Now, earlier in that video, did you observe the defendant's vehicle coming close to or coming into contact with Mr. O'Keefe's vehicle?
Yes, I did.
And as far as Mr. O'Keefe's vehicle, at least from this video, what, if any, damage did you observe to Mr. O'Keefe's vehicle?
No damage.
And as far as the ground area around.
So she might have slightly, but you look at the tire track, they stop almost parallel with the side of the vehicle, and they would extend almost parallel along the rear of the vehicle. So if she struck it, I think it would have been with the side of the lens, but the lens to me looks like it's broken from behind. It's broken on the side, but it looks like it was behind. And that's it. To me, if it struck, it's the bumper. And I did pay attention to the overhang from the rear wheel. So part of her car, I think, did go behind John's. But I really, I didn't see John's SUV rock or anything like that. So if she struck it at all, it was very, very, very light. Now, is that enough to break a taillight? Maybe. Probably not, but maybe. But once again, if that's where the taillight broke, where's the taillight? Conspiracy? Seriously. Did the Alberts already steal the taillight somehow to sprinkle later on? Because it's not on top of the snow. It's clearly not there. So exactly. So Trooper Proctor preemptively, before he was even activated, somehow knew to, someone's under John's SUV to catch the debris and pull it under the SUV just to keep it off that snow, so that they can go hide it. So, and snowblower came later. I don't think he snowblowed over this way. Of course, if she did strike it, it could have been dropping fragments as she pulled away. Doesn't all have to fall right at the same time, but there's no trail. There's nothing by John, by his car. So that's it. Proctor controls the weather. Conspiracy. But this is a problem for Karen Reed. This is a big problem. The taillight is broken and it's not here. So where is it, Karen? Where is it, Jackson? This is why he was fighting tooth and nail to keep this video out. This is why I'm assuming Karen deleted this one and not the others, because this one was incriminating, the others not. She didn't count on the state being able to subpoena Ring. Whoops.
Found where Mr. O'Keefe's vehicle was parked, specifically the rear of that vehicle. What, if any, red pieces or anything?
Well, I think he was fighting tooth and nail to stop him from building the foundation, so that when he moves to introduce, objection, no foundation. But he got there in the end, Lolly, in building the foundation.
Did you observe on the ground around Mr. O'Keefe's vehicle?
Nothing was observed.
It's coming to the rest.
And that I paused it at a bad time, but that question was about the taillight. Nothing was observed. No taillight fragments in the snow. So but the reason he was trying to keep it out so hard was because it's damning. It's devastating to his case. And it is a little bit of a fisheye lens, so it is a little difficult to tell exactly the perspectives. So,
Went from Exhibit 6, if I could have video number 165.
and I'm just assuming she deleted. I don't know that for sure. I'm assuming, because otherwise, I commented way back on day one of the trial when Paul O'Keefe testified. I commented because they played the Ring video of the after hospital party. And this is the video I wanted to see, and it wasn't included. But Paul O'Keefe couldn't have laid a foundation for this. So, assuming it was deleted and only obtained through subpoena, because the only reason they need to subpoena it is if it's been deleted somehow, if there's been evidence tampering. So, yeah.
You can pause there, please. And Sergeant, have you reviewed this video as well?
Yes, I have.
And when time-wise, in relation to January 29th,
I think
was this video?
It's approximately like 12:30 in the afternoon.
And as far as the vehicles in the foreground area from this particular camera shot, you know whose vehicles those are?
Yes, the vehicle in the top left corner is Mr. O'Keefe's vehicle. Vehicle in the middle left is the defendant's vehicle. And I do not know who the other two vehicles are.
So this is after the hospital, and we heard from the owner of this vehicle. It's the Forerunner. I can't remember whose it was. And I think this is the McCabe's, maybe. Can't remember. It's been too long.
I was telling you to press play. pause there just for a moment. And Sergeant, from the two individuals exiting from that vehicle, do you recognize who those individuals are?
Yes, I do.
If you could, just using the laser pointer, direct the jury's attention to whom you recognize and identify who that person is.
That there is the defendant, and that there is Mr. Reed.
Again, Mr. Reed, the defendant's father, is that correct?
That's correct.
And Ms. Gilman, if you could press play.
Of course, Mr. Reed had to pop out right as I was shoving food in my mouth. So thanks for that. And I didn't see it. And I was specifically looking for signs of an impact. I didn't see any at all.
Thank you. Ms. Gilman, if you could pull up video 166 from the same exhibit 6. Ms. Gilman, if you can pause there just for a moment. Sergeant, do you recognize the person that just exited from that vehicle and behind the defendant's vehicle?
Yes, I do.
Do you recognize that to be?
As a defendant's brother.
And then Ms. Gilman, if you could press play.
It's a family affair. I'm getting closer. I'm getting closer. I'm getting closer.
Thank you, Ms. Gilman. If I could have from the same exhibit 6, video 171.
True.
Ms. Gilman, you can take that down. Mr. Officer, we can have the lights back on. Sergeant, from your review of those videos, at various points you observed the defendant's brother cleaning off the defendant's car.
It's definitely been a bad day to be Karen Reed. Of course, the free Karen Reed crowd is probably, oh my God, how could they have charged her this?
Correct?
That's correct.
At any point in time, did you observe the defendant's brother cleaning off the area of the right rear passenger side's taillight of the defendant's car?
I did not.
Now, Sergeant, turning your attention to February 1st of 2022, yourself and Trooper Connor Keith, is that someone you're familiar with?
I am.
And he works within your unit as well?
Yes, he does.
And at some point, did you and Trooper Keith on that day go to the CF McCarthy's establishment?
Yes, we did.
And what was the purpose of your visit to CF McCarthy's on that day?
The purpose of our visit was to retrieve surveillance video during the target time in question that we knew the victim and the defendant had visited the establishment. Also, any
Right. So we've had part of the CF McCarthy video. As I've said, I want to see how many drinks. I want to see receipts. This is who can give that to us. So this could be bad. This could convince me of DUI manslaughter. I won't say guilty or not guilty until after the defense has rested. But this could be what clinches that bit for me.
transaction receipts that we could collect from that location.
Exactly.
And were you able to retrieve both video as well as transaction receipts from?
I should say, since I put that on, subscribe to Mad Catster. He does good work.
That establishment?
We were.
And I'm sorry, my apologies. Before I get into that, may I approach the witness, Your Honor?
Yes.
I'm allergic to cats too. They don't make me sneeze or break out or anything. I just don't like them because they're assholes. Except yours, Pat's cats, I'm sure.
And Sergeant, I'm showing you a series of 14 photographs or still shots. If you could just list those and look up when you're finished.
I'm a dog person because they understand me. Little dopey, but yeah. Growing up, my Oma's cat was evil. Absolutely evil, psychotic. It was Karen Reed in cat form. And yeah, I don't like them. I don't trust them.
And do you recognize those, sir?
I do.
And what do you recognize those to be?
I recognize these to be still photographs of the ring video that we just watched.
And that would be video 153, the one with the defendant backing out sometime after 5 a.m. on January 29th.
That's correct.
May I approach, Your Honor?
Yes.
Come up, take to introduce and admit as the next exhibit.
Okay.
No objection.
Thank you.
Gotta get the stickers. Sergeant came prepared. He's testified before. He knew to bring the water bottle.
It's 447, it's in 460.
Thank you.
And presumably we don't have to see them go over the stills in excruciating detail. They're just putting them in as exhibits. Since we saw the video.
That's in 461.
Thank you.
Thank you so much. Your Honor, with the court's permission, may I publish just a couple of these photographs?
Okay.
No. I just got finished saying we don't have to see them in excruciating detail.
Mr. Gilman, if I could have photograph number 30.
I think we're getting close with the state's case. We've still got medical examiners. We've still got accident reconstructionists. Maybe a couple more troopers, but, you know, Trooper Tully, maybe Trooper Proctor. But I think we're on the home stretch of the prosecution's case.
And Sergeant, you recognize what's up on the screen now as exhibit 456?
I mean, one of the window lickers in the mass hole Discord literally said that. She's like, she was asked, what would it take for you to believe Karen hit John O'Keefe? Video proof. Do you need video proof to believe that the McAlberts did it? No, I believe that. So, yeah, nothing is going to get them to change their mind, but they're a cult at this point, so.
I do.
And Ms. Gilman, if you could just move towards the rear of the vehicle.
Good point, Paul.
Yes.
I still think we're in the home stretch.
And Sergeant, what's up on the screen now? If you could direct the jury's attention with that laser pointed to the area of the rear passenger side tail light that you were describing damage. Thank you, sir. Ms. Gilman, you can take that. Thank you, sir. Mr. Officer, you can have the lights back up. Thank you, sir. So Sergeant Mechanic, if I could take you again, I'm sorry, back on February 1st to CF McCarthy's. You secured video and receipts from that.
The thing is, if it were video, it's just a deep fake CGI
establishment on that day?
That's correct.
And as far as the video and receipts, were you
Still-
then able to subsequently review those at some point?
Yes, I was.
Now, first, starting with respect to the video, you know what I mean, approach?
Yes.
In that case, let's empty the prisons.
I'm showing you two photographs, still shots, just actually look at those, look up and finish. And do you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Those are still shots of the CF McCarthy's surveillance video that we collected from that establishment from the dining room camera angle.
May I approach again, Your Honor?
Yes.
I'm about to state to introduce in a minute.
No objection.
Thank you.
It's 161,
Thank you.
Your Honor, with the court's
And like, let's just say it's manslaughter. I'm not saying she needs to go away for life. She probably does need some punishment. It's, you know, you can't be convicted of a serious crime and get off scot-free. I think in general, American prison sentences are probably too harsh. Not enough focus on rehabilitation. But there needs to be some consequence beyond the, you know, $1 million spent on a defense.
Commission, if I could ask those to be published to the jury at this point.
Okay.
And the thing is, you know, there's multiple theories of punishment. There's retribution. You did wrong, we want to punish. But a big one is deterrence. You did wrong, we'll punish you so that other people in the future know if they do wrong, they'll get punished. And the third major is safety. Hey, dangerous people get locked up for society's safety. But there's no deterrence if the attitude is, well, hey, it's not bringing Johnny back, so what you gonna do?
And Sergeant Kennedy, you recognize what's up on the screen?
Yes, I do.
And if you could, using the laser pointer, draw the jury's attention to what, if anything, of significance you observed this still shot from CF Parkers.
We observe the victim, Mr. John O'Keefe, here. Appears to be communicating with the defendant here. Mr. Camerano is over here as well. Mr. Sullivan is down here as well. Mr. O'Keefe is wearing the gray light two-tone sweatshirt that I held up earlier, as well as the jeans.
And the next still shot is going to. And
problem is, knowing them, they just make it up. They'd be the paid actors, and that's the scary bit.
similar to this, similar to the previous one, excuse me, Sergeant, do you recognize what's depicted in this still shot here?
Yes, it's, again, the victim on the other side of the defendant, still dressed in the same outfit, and the defendant standing in front of him.
And as far as the bar area adjacent to the defendant, what, if anything, of significance do you know there?
A vodka soda.
The bar area is located near the taps, the draft beer taps at C.F. McCarthy's. So if you were to look at the bar from the street, that is the left side of the bar orientation on the way to the restrooms.
And I'm sorry, I should have been more specific. As far as the sort of shelf of the bar immediately adjacent to the defendant's left arm, what, if anything, do you observe that?
Do you see a drink?
Here, I observe a cylindrical vase-style cocktail glass on the bar, as well as other beer bottles.
Thanks.
That has struck me multiple times through this, Grey Duck. And no pun intended, obviously.
Just coming, you can take that down. With reference to the C.F. McCarthy's video, Your Honor, with the court's permission, I would ask to publish certain portions of that. It's already been marked as Exhibit 50.
Okay.
Yeah.
Ms. Gilman, if you could, from
Yeah.
the first video.
I mean, did he bring it in the house, get beat down, bring it out, and dump it under him? Did it somehow get broken on the lawn as he's getting dropped off, and he just happens to be dumped on top of the bar glass? It just doesn't make any sense. So, and that glass, the tall vodka tonic glass, that looks like it's the type that we saw the base to, the thick base. So she absolutely did. It was a boys'
If I could ask you to
night
pull it up
out.
to about 7 minutes and 50 seconds. And Ms. Gilman, if you could pause just for a moment, I'm just going to ask you to play from 7:50 to about 8 minutes and 20 seconds in, but I may ask you to pause it. Gilman, if you could pause there.
As I've said multiple times, that everyone was Boston sober. Not a problem unless you hit someone.
As far as just, again, for orientation purposes, with reference to the entrance or exit, point of ingress, egress to the bar, do you observe that somewhere within this video?
Yes, at the top of the screen is the front door to C.F. McCarthy's bar. And as we just viewed the two gentlemen walking in, they walked in through the front door, heading to the taps area, draft beer location of the bar.
And if you could, just using the laser pointer, direct your attention to that front door area that you're talking about.
The front door area is located right here.
And with respect to those two individuals that came in, do you recognize those two individuals?
Yes, that is the victim, Mr. John O'Keefe, dressed in the same outfit as before, and Mr. Camerano.
If you would play that to about 8:20. Gilman, if I could ask you from the same exhibits, same exhibit 50, from the third video now. If I could ask you to go to about 6 minutes and 10 seconds in. And I'm going to ask you to play that till about 6 minutes and 43 seconds. If I could ask you to pause just there. As far as the individuals around Mr. O'Keefe and Mr. Camerano, do you observe or recognize anybody else in the bar area around them at this time?
Mr. O'Keefe is sitting next to Mr. Camerano. I believe Mr. Kurt Roberts is there as well, next to Mr. Camerano.
Now, from this time, we're at about 8:51 p.m. or so within the video. Is that correct?
That's correct.
Now, as far as the timestamp on this video, what, if any, information were you provided when you retrieved this video on February 1st in relation to that time and its accuracy to sort of what time was?
During video surveillance extraction, we verify the time and date on the system, and that is to show us how far behind in the past or in the future. Sometimes devices are timestamped that's in the future. It hasn't happened yet in real time, but the video is stamped so. So what we do is, prior to extracting video, we identify the difference in time between real time and video time. In this case, C.F. McCarthy's video was 12 minutes behind real time.
And
That's good to know. Setting your VCR is difficult. Putting a timestamp, an accurate timestamp on your video is difficult. Of course, there is the time creep in clocks, unfortunately.
thank you. And Ms. Gilman, if you could play this to about 6 minutes and 40 minutes.
They must have given him a Cosby cocktail. He couldn't fight back.
Just pause there briefly, Ms. Gilman. As far as anyone else within the area of the bar, in the area, Roberts, anyone else you recognize in that area at this point?
I recognize the defendant walking in and interacting with the victim, Mr. John O'Keefe.
Now, Ms. Gilman, if you could, within that same video 3, I would ask you to go to about 13 minutes and 15 seconds. And I'm going to ask you to play from here to about 14 minutes and 45 seconds. Pause there. Now, from your review of this video, what, if anything, of significance do you observe in this part of the video?
This part of the video, I observed the defendant reaching over and retrieving a cylindrical, tall cocktail glass from the bartender.
And again, given the understanding that the video is about 12 minutes off as far as the timestamp.
So John is right here. It looks like he must have gone to the boys' room. He's in the Nike ball cap. The blue ball cap on the other side of Karen is not John. I think it's the friend.
The defendant entered about 8:51 p.m. and is receiving this drink about 8:58 p.m. Is that correct?
That's correct.
And if you could, Ms. Gilman, play that too. Now, Ms. Gilman, if you could go up to about 32 minutes even in to the same video.
First drink
Now I'm going to ask you to play
here.
that for the next 30 seconds or so, to about 32 minutes and 30 seconds. And Sergeant, during that about 30 seconds or so, what, if anything, of significance did you observe the defendant to receive at that point?
A cylindrical cocktail glass.
And so that would be the second drink, is that correct?
That's correct.
And that's at approximately 9:15, is that correct?
That's correct.
So 17
And
minutes
Ms. Gilman,
later.
if you could go forward to about 37 minutes into the same video. If you could play that for about the next minute or so, to about 38 minutes.
Of course, are those doubles is a question. That's a shot. Oh, poured a shot into. Poured a shot into the tall glass.
Now, Sergeant, again, from that about 1 minute portion from that video, what, if anything, of significance did you observe the defendant receive and do with any items?
She received the shot glass beverage and poured it into the tall cylindrical cocktail glass, and then Mr. John O'Keefe stirred it for her.
And so that would now be the third drink, is that correct?
That is correct.
And that's about 9:20.
Fun fact, Chumbawamba was my very first CD. Followed very shortly later, like later on Christmas Eve, Bob Marley Exodus. I had cassettes, but it was my first CD. Received my first CD player the next morning on Christmas morning. But Chumbawamba, very first CD.
8 p.m. Is
I'm only slightly embarrassed by it because I was like 14.
that correct?
That's correct.
Ms. Gilman, if I could direct you to the fourth video, video number 4. And ask you to go about 50 seconds into 50 into this video. And I'm going to ask you to play this, Ms. Gilman, from 50 seconds to about 1:30. Thank you, Ms. Gilman.
I'm
So, Sergeant,
shocked.
from this particular video, what, if anything, is significance do you observe the defendant receiving during this time frame?
She receives another shot glass beverage and then places that liquid into her tall cocktail glass and stacks the second shot glass into the first shot glass into the first tall cylindrical cocktail glass she had previously received and consumed.
So this would now be the fourth drink, is that correct?
That is correct.
And per the video, that's about 9:33 p.m., is that correct?
Yes.
That is correct.
And Ms. Gilman, within the same video, if I could ask you to go to about
Of course, I had my Catholic Oma buy me that CD, so, you know. And my cousins gave me Exodus.
26 minutes and 30 seconds. Ms. Gilman, if you could pause there for just a moment. I'm going to ask you to play this until about 27:40.
It's a possibility. Oh, she can smile and laugh. This is the first the jury is seeing it. I mean, she smiles and laughs as soon as the jury's out of the courtroom, but this is the first the jury has seen her without resting bitch face. So, yeah. So, my first 45 was probably Appetite for Destruction, I think. I'm pretty sure it was Appetite for Destruction. I bought it at the, I think it was Tower. Paul, was it Tower on Piccadilly Circus or was it Virgin? Right there at the north end of Piccadilly Circus. But 17, I bought Appetite for Destruction because, you know, for a while it was really hard to find vinyl, and you know, like, yeah, we have Cream on vinyl, you know, all of Cream's albums, but I never bought those. Those are my dad's. So my first that I bought was Appetite for Destruction in London. I actually bought it for my cousin, the one that just got married. He sent me with money for chocolate. I thought, he'll like Appetite for Destruction better because his favorite band at the time, he was like 11. But then I decided once I got home to give him some chocolate and keep the record for myself.
During that period, Sergeant, what, if anything, of significance did you observe the defendant receive during that time frame?
She received a tall cylindrical cocktail glass.
And in addition to that,
And clearly this is why she didn't leave a little, you know, when they left to go to Waterfall. She's like, I'm not leaving a quadruple shot. I'm taking it with me.
Anything else that she received from the bartender during that time?
A shot glass size beverage.
And what, if anything, did you do with the shot glass in regard to the larger cylindrical glass?
It was placed inside the tall cylindrical cocktail glass.
So that would be drinks 5 and 6, is that correct?
That's correct.
And per the timestamp on the bar video, this is now about 9:57 p.m., is that correct?
Correct.
And Ms. Yeoman, if I could direct you to video number 5. And if I could ask you to go to about 3 minutes in. And ask you to play that till about 3:30 or so. Thank you, Ms. Yeoman. And if I could ask you to go to about 10 minutes and 30 seconds in.
Probably just lost the
And I would
Facebook
ask you
feed
to play that for about a minute to about 11.
since we're over 8 hours. Ugh. Absolutely. Absolutely. Yep, we lost Facebook.
Ms. Gilman. So Sergeant, sort of rounder shots during this portion of the video, is that correct?
That's
Yeah, sustained. You can ask it differently.
What, if anything, of significance did you observe the defendant and or the group that she was with do in this portion of the video?
in this portion of the video, the two gentlemen to the right of the defendant consume a shot-sized beverage.
And as far as the shot glass that the defendant received, what, if anything, do you observe her to do with that?
Objection.
I'll allow it. Or strike that. Just what did you observe, not what she had.
What did you observe the defendant to do during that portion?
Prior to the shots being taken, a shot glass was poured into the cylindrical tall glass.
And again, so that would be drink number 7 at that point?
That would be drink number 6.
They're counting.
And I'm sorry, so
and this is drink number 6, assuming what she's received in the tall glasses have been singles. Because if those are doubles and then she's pouring, you know, this could be 8 units already over a 2-hour period. So that's a lot. And remember, she has MS. So could make her drunker, more intoxicated.
previous portion was a cylindrical drink and then a shot glass that was 5 and 6, is that correct?
Objection.
I think that was the testimony. Ask it differently.
As far as that drink during that portion, is that drink number 6 or drink number 7?
Objection.
Yeah, in that form, I'll
Asked
sustain
and
it.
answered, and
At this point in time in the video, after watching what you watched, how many drinks has the defendant consumed at this point?
At this point, she's consumed or is in possession of
Objection.
I'll allow it.
6 drinks.
And this is at approximately 10:29 p.m., is that correct?
Yes, that's correct.
hour and 10 minutes. Hour and 20 minutes.
Ms. Gilman, if you could go to about 20 minutes and 30 seconds in. Actually, wait for the next 10, 20 seconds.
Yeah, don't drink and drive. It's a scumbag move.
So during that portion of the video, what, if anything, do you observe as to the...
I mean, what is she? 5'8", 5'7", 5'8"? Judging by Johnny's 6'2". Of course, she might be in heels, so this might be misleading, but I'm putting her about 5'8", fairly petite.
drink the defendant has and how full it is at that point?
She has a cylindrical tall cocktail glass in her hand.
And can you observe, or did you observe how full that glass was?
Drink number 6 is empty, or near the bottom, almost empty.
And Ms. Gilman, if I could ask you to go to about 22 minutes and 40, I'm sorry, 22:40 or so within her time stamp, I'm sorry.
It could be her parents. Could be her dad, but yes, Jennifer Ray, bar number 1. This is still McCarthy's. Waterfall had the terrible CCTV.
Now, from this portion of the video, Sergeant, what, if anything, do you observe the defendant and Mr. O'Keefe doing in reference to Cedar Park?
Once the defendant got drink number 7, the defendant and Mr. O'Keefe walk out of C.F. McCarthy's, the defendant holding the beverage, tall cylindrical glass in her hand.
What? Did Turtle Boy say she was sober? One or two at the most. Just like every drunk driver ever. I'm shocked.
May I approach?
Yes.
Ms. Kelman, you can take that down. I'm sorry. I'm showing you a 5-page document.
Hey,
Review that
is
with
this
us
the
when we finish.
receipt? I hope this is the receipt. I bet this is the receipt. That's a long receipt. Of course, not all of them are hers. There are the beers that the boys were drinking. The boys had shots, but that's still a long receipt.
And do you recognize that document, sir?
Yes, I do.
What do you recognize it to be?
I recognize it to be a series of transaction receipts from the tabs at C.F. McCarthy's.
And are these the transaction receipts or tabs that you received, you and Trooper Keefe received from C.F. McCarthy's on February 1st, 2022?
Yes, they are.
And with reference to those receipts or tabs, to whom, if anyone of significance, do you, so those tabs pertain to?
The first one for 5280 was opened under the bar tab, Karen A. Reed.
And is there also a receipt from John O'Keefe?
Yes, it is. The transaction through the credit card, being a MasterCard for 5280, was paid by Mr. John J. O'Keefe.
And with reference to the items listed within that particular receipt, what, if any,
This is another reason I could never be a drinker. I'm too cheap. I could not pay this for drinks.
items of significance do you observe listed on the receipts?
Under Karen A. Reed's receipt, 1 Tito's, $10, 1 Tito's, $10, 1 Coors Light, $5.
Sustained.
Hearsay.
Yeah. Go, John.
Yes.
Although
Think to introduce in minutes and next exhibit.
although they're well, he's reading them is the problem. They're business records kept in the ordinary course of business, so that's the hearsay exception, but he can't read them.
We probably should,
Okay.
briefly.
No, we're trying to get out of here. No approach. No approach. Damn you, Jackson. You approached like you said you were. She's probably thinking, I could go for a drink about now. Today's been rough. Let's see. We're getting close. We're getting close. It says 20 minutes to go, but remember, we're at 1 1/4 speed, so it's a little itty bitty less, but I'm ready. I'm ready. It's been
You
a
are
long
unmuted.
one. Huh. And the lawyers. They'll leave Diaper Boy behind because, you know, that's a little gross.
And so Sergeant Mechanic, on those receipts from C.F. McCarthy's under both Ms. Reed's receipt and Mr. O'Keefe's receipt, there was Tito's vodka listed on the receipt, correct?
Correct.
Now, also on February 1st, what, if any, other establishments did you go to in the town of Canton?
Myself and Trooper Keefe went up across the street to the Waterfall Bar and Grill and retrieved transaction receipts and video from there as well.
And as far as the video is concerned from that establishment, have you reviewed that video as well?
Yes, I did.
And it sucked.
And with regard to the receipts from that establishment, you reviewed those as well. Is that correct?
That's correct.
Your Honor, may I approach?
Yes.
So I'm showing you 4 photographs of still shots. You can review those and look up when you're finished.
And then he'll claim it as a business expense. So.
And you recognize those, sir?
Yes, I do.
And what do you recognize those to be?
Those are still shots of surveillance video from the Waterfall Bar and Grill on the night of January 29th after midnight. And Mr. O'Keefe is depicted in the still shot.
And those are both interior as well as exterior camera shots of Mr. O'Keefe's sort of exit from the waterfall. Is that correct?
That's correct. Interior, him leaving at 12:11 a.m., which the timestamp on the surveillance video at the waterfall was accurate to real time. He is holding a beverage shorter cocktail glass in his right hand as he exits the establishment. He's seen on the exterior camera walking towards Washington Street.
This is narrative,
Thank you, Mayor Pro Tem.
non-responsive,
Yes.
but
I want to seek to introduce and amend his
but Jackson didn't object, so.
Thank you.
Such noisy papers.
Thank you. Your Honor, with the court's permission, if I could ask that this be published for the jury.
Yes.
And Ms. Gilman, if I could just have the first one. I apologize. Ms. Gilman, if I could have the first one from the interior. Thank you. And sorry, do you recognize what's up on the screen, which is now the mark as 464?
I do.
And what do you recognize that to be?
That is the still shots presented to me and entered into the exhibit of Mr. O'Keefe walking out of the Waterfall Bar and Grill at 12:11 a.m. on the night of the early morning hours of January 29th, holding a cocktail glass.
And if I could have the second still from this second still. And again, do you recognize what's up on the screen, sir?
Yes, sir.
And if you could, using the laser pointer before you, just direct the jury's attention to where you observe Mr. O'Keefe and what, if anything, you observe is holding as he exits the waterfall.
Mr. O'Keefe is observed here. He's holding that shorter, fatter cocktail glass as he's walking out of the establishment.
So shorter, fatter
If I
cocktail
could have
glass,
the exterior, just the second one, please.
not a shot glass though.
And again, sir, would you recognize
Like
what's up on the
a
screen, which is now
whiskey.
467?
Yes, I do.
And if you could,
By shorter, fatter, I'm assuming like a whiskey glass. But
using the laser pointer, direct the jury's attention to what, if anything, is significant to observe in this step.
This is Mr. O'Keefe walking out of the Waterfall establishment, holding the cocktail glass in his right hand as he walks towards Washington Street.
and they planted the flag here as part of the conspiracy.
Mr. Officer, we can have the lights. Thank you, sir.
Absolutely. If only they could have led with this on day one.
Madam Mayor, approach the witness.
Yes.
Yeah, that's what I meant. But it still sounds a little
So I'm showing you what's been previously marked as exhibit 4 accessible with that.
like, based on the dimensions of the glass they gave, a rocks glass seems a little wider than I think what they ended up with, so I'm not sure.
And do you recognize what's contained in exhibit 54?
I do recognize, yes.
Are those the receipts that you received from the waterfall when you went there on February 1st?
Yes, they are.
May I approach the camera?
Yes.
And that shows this is a put on
Now, sir, with reference to the waterfall,
an eminence front.
in regard to the timestamp on that surveillance video, what, if anything, were you told as far as the accuracy of that timestamp when you retrieved that video?
That video was confirmed to be accurate in time, as in real time. No discrepancy.
And Your Honor, with the court's permission, if I could just publish 3 quick clips from what's been marked as exhibit 53.
Okay.
Ms. Gilman, if I could ask from channel 3, the second video down. If I could ask you to go from the timestamp on the top of the screen to 10:54 in 25 seconds. Keep it clear. I can ask you to pause right there. So Sergeant, from that particular portion of the video, what, if anything, of significance did you observe occurred?
That portion of video depicts Mr. John O'Keefe walking in with the defendant gesturing to a group of people at the top of the screen, and then Mr. O'Keefe walking over and giving a hug to an individual that's part of the group.
So from the same channel, Ms. Gilman, if I could have from the fourth video down.
Is that an hour and 46 minutes after her first drink?
If I could ask you to go 11:39 and 40 seconds. Pause there, thank you. And in about 5 to 10 seconds or so, I'm going to ask Ms. Gilman if you could pause it, and I'm just going to ask Sergeant if you can direct your attention to sort of the top right corner of the screen. Okay, so pause there. From that portion of the video, you observed the defendant in that portion of the video?
Yes, I did.
And what, if anything, did you observe her to be doing?
She retrieves a drink from the table and appears to consume it.
Now, as far as the drink and the tall cylindrical glass that you observed her walking out of C.F. McCarthy's with, what, if anything, do you observe from the glass that she's taking a sip of from this portion of the video, the waterfall?
It's a shorter, fatter style glass compared to the cylindrical tall style that she walked out of C.F. McCarthy's with.
Thank you, sir. Ms. Gilman, you can take that. And Mr. Officer, if we could have the lights. Thank you, sir.
Mr. Lally, why don't we end for the day? It's been a long day. Everybody ready to go home?
Yeah.
All right, so Sergeant, we're gonna leave you back tomorrow, and I'll ask you to just follow the jurors out when they leave. So jurors, the same reminders, please do not discuss this case with anyone.
Follow the jurors out as they leave. Turtle Boy is here. Moron is here. Piss Boy is here. Yeah.
Don't do any independent research or investigation into the case. If you happen to see, hear, or read anything about the case, please disregard it and let us know. We'll see you tomorrow.
All rise to the court, please.
Hey. Yeah, roll your eyes before the jury's out, maybe.
I will see counsel at sidebar about
What-
scheduling, please.
What do they have to smile about? Seriously. What do they have to smile about? This was not a good day for them. Why are they smiling? Why are they smiling? Did they take this as a win? Seriously. It's stupid. And let's see. Well, either way, I don't know that we're going to get any closing instructions or not, since they're meeting for scheduling. I believe we have a half day tomorrow. Well, 2/3 day roughly. I think there's no court on Friday, but I can't remember. Yeah, Dad's the only realistic one there. I mean, Glare's glaring, but Jackson and Karen, you know, they're happy. I don't know why. Yeah, that was to me, a totally devastating day for the defense. Totally devastating. I I'm pretty close on DUI manslaughter. I'm pretty close. So, of course, the defense may be able to change my mind because we wait until the end of trial. But I'm getting there. I'm absolutely getting there. So, yeah. But as it's been 8 hours and 21 minutes, and it's 9:45 my time, I'm going to go find something to eat, and I will see you guys tomorrow. So do all the YouTuber things, like, share, subscribe, bribe your friends and family to do the same. And I absolutely agree. He looks like he has the Neanderthal brow. So yes, but on that note, I'll see you all tomorrow. Bye-bye.